Well, welcome to One Civil Law Indeed, where we learn from the misfortunes of others. And that tagline has rarely been as true as it has been yesterday and today. Holy shit. Where we heard testimony from Shannon. Shannon, you came into your life and you made us sad. It's total trash fire, Shannon. Yes, Shannon, the expert. Shannon, the expert. That's good. Um, yeah, it was bad. It was bad. It was incredibly horrible. People have been asking me like, how that changes my assessment of the odds. I'm not sure I have a coherent answer to that question yet, but that's okay. I can defer to the wisdom of the crowds. So Polymarket is taking bets on this, which is hilarious. And so if you want to bet with actual real money, what does the crowd say? What do the crowd say about it? Well, Polymarket now projects 40% chance of acquitting on all charges and projects a 15% chance of convicting on either count 1 or count 2. That is their current projection. So, respectively between those two betting odds. So, yeah. So I guess my 60% is now 15%, according to the betting market. So the betting market says, Kurt, you were off by a factor of 4. At least you're off by a factor of 4 now. So if you'd like to get involved in that action, Polymarket is available for you, I guess. So all that good stuff. So yeah. Let's take a look at the acquitted all charges over time. Apparently they were at a high at 55, and they went down since yesterday. How? Apparently, I don't know how. They were at 55% during the testimony yesterday, and then apparently this morning came down to 40%. I'm not sure what happened there, but that's what the markets are saying. So you can do all that stuff. So yeah. Anyways, that's what's happening there. Not sponsored in any way, but in any event, that's what the markets are saying. Ads were off. I thought I turned off ads. Did I not? No. You can't turn monetization off completely. Don't do that. No. No. Mid rolls, insert rolls manually. No, that's the correct setting. No, don't change that. Don't change that setting like that. No, don't turn monetization off. Fuck. Don't do that. Good morning. Did I see where the judge signaled Brennan? I've seen it. Yeah. I've seen it. Yeah. We can't turn monetization off completely. I do want to earn revenue for this stream. Damn. Don't ever turn monetization off completely. Shit. Don't do that. Yeah. How much worse do I think it's gonna get? I don't know, man. I don't know. It could get bad. It could get bad. Do I think they'll bring up the not for expert designation on cross? Probably. I would. Have you noticed that it's been marked for not for expert designation? So even your own company doesn't believe in you? Yeah. Yeah. I imagine that will be mentioned at some point. Yeah, they stamped not for expert designation, like that somehow prevents me from using it in a court proceeding. Oh, it's been marked as not for expert designation. That means I totally can't use it in court. Uh-huh, that's definitely how that works. Uh-huh. Sure. Oh Lord. How does Brendan rehabilitate this guy? I don't know, man. I don't know. Focus on the facts of the report, I guess, is all you really have at that point. Just focus on the report and focus on the science of the report and ignore all the character stuff. Just focus on the hard scientific truth and ignore the rest. That's all I can think to do. They have the watermark on all their experts, so they don't believe in any of their experts. How verifying? That's nice. So Aperture has put the watermark on all their experts, so apparently they don't believe in any of their experts. Yeah, please don't use any of these in any court proceeding. We don't have enough confidence in it. We don't have enough confidence in it that we want you to use it in a court proceeding. That definitely makes it better somehow. That they've stamped every single one of them not to be used as an expert designation. Oh boy, man. So the company doesn't believe in any of their experts, or they don't believe in the truth of it enough to be used in court. Wow, that definitely says that this is a credible company that really minds their P's and Q's. We don't have enough assurance in even our own employees' CVs. We don't have enough assurance in our own employee CVs that we're willing to say that, yes, this is suitable for a court proceeding. What kind of defense is that? They put it on all their CVs. What kind of defense is that? That is a bullshit defense. That's worse. That's not better. That's worse. Oh, none of their employees are credible and reliable, or at least none of their CVs are credible and reliable. Please don't use any of their CVs as part of certifying this person as an expert. We don't have enough reliability in it. It's not credible enough to be used in that purpose. What kind of bullshit defense is that, man? Give me a break. And also, of course, as I pointed out earlier, that stamp in absolutely no way, in any sense, prevents me from using it in a court proceeding. So this is not to be used in expert designation. Are you out of your fucking mind? Are you out of your fucking mind? Every single expert from Aperture in every single court proceeding from now until the end of time, as long as that stamp remains. Yeah, it's going to pop up in every single court proceeding. Are you aware that on your own company's website they have this CV? I'd like to tender this as an exhibit. Can you please note the watermark not to be used as expert designation? So your own company doesn't even believe in you. It says not to be used in objection, says not to be used in expert designation. Well, it is a business record maintained by the business in the ordinary course of business. So that's a hearsay exception. And the fact they themselves don't believe in it is exactly the issue I want to raise, Your Honor. Objection overruled. So as I was saying, dot, 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 Sierra and the Cat for $6.99 Canadian says, I'm putting Masters of Law and thoracic brain surgery from Harvard on my CV. If anyone asks, I'll just say it's a misinterpretation. That's an exciting idea, you know? That's an exciting idea. Yeah. Oh yeah, and they put it on all the CVs? Oh, holy shit. Yeah, I didn't even think about that. That means that any person from Aperture that's called for the rest of this trial, yeah, that means any person from Aperture that's called for the rest of this trial. Yeah, guess what's being guess what's being introduced as an exhibit, right? I'd like to bring to your attention that your company apparently has updated your CV. Would you like to take a note of this? This is a business record that I got from the company. You know, I proffer, as the lawyers would say, I proffer that I downloaded this myself from the company website earlier today. Right? So that'll do it, right? It's like, how do you authenticate it? I'll authenticate it as the lawyer myself. You can kind of do that. It's called proffering if we want to learn something of legal value. So, like, if you need to authenticate the document, one of the ways you could do that is basically the lawyer says, like, I'm basically saying it. I personally downloaded it myself today from the company's website. You know, this appears to be kept in the ordinary course of business, Your Honor. I'd like to ask a question about it. No problem. Introduce the exhibit. Does this appear to be your CV? It sure does. Can you please read this designation? It says not for you. Your own company doesn't seem to believe in you. Lord. Your Honor, I still object. I don't think this is sufficiently authenticated. Well, Your Honor, if you really feel that way, we could subpoena someone from Aperture, the custodian of records. The custodian of records! We could subpoena the custodian of records and get it authenticated. No problem. Oh man. Aperture right now apparently does not believe they have any experts in their entire company. That's what we've learned. Aperture does not believe that they have a single expert in their entire goddamn company. Which, to be fair, might be a sign that they're self-aware. We should be kind to Aperture. We should be kind because becoming self-aware is hard. As a person who tries to be self-aware, although not to say I'm perfect at it, but a person who tries to be self-aware, trying to recognize one's own flaws and admit to one's own flaws is challenging at times. Trying to admit that you have a problem, whatever that problem is, and that there are flaws, trying to be introspective is difficult. It's also difficult technically. It's difficult technically because it's difficult to be objective about yourself in a very technical sense because of course you're in your own head, right? So it's difficult to be objective about yourself because of course in evaluating yourself you have to evaluate yourself with your own mind, which kind of makes it inherently subjective. So it's difficult to divorce yourself from yourself when evaluating yourself. So that's challenging. It's technically challenging. And then of course, so that's technically challenging. And then also it's challenging because of ego, right? So it's challenging because I don't want to do it, ego. And it's challenging technically because I'm evaluating myself through my own lens. So it's challenging both subjectively and objectively. But we have to give Aperture credit. They're at least trying. They're trying. They're trying to become self-aware, which is a good start. And they have marked all their experts as these are not really experts. They are trying to become self-aware. And that's a laudable thing. That is a laudable thing. We should give Aperture credit. Yeah. I don't know if I'm going to be copyright struck for this, but you know what? Fuck it. Let's do this thing. Hold on. I think this is the song that Alyssa is singing this morning. And if Alyssa doesn't know the lyrics, Alyssa should learn.
This was a triumph. I'm making a note here, huge success. It's hard to overstate my satisfaction. torture science. We do what we must because we can. For the good of all of us, except the ones who are dead.
The ones who are dead would be the expert witness in this song at this point.
But there's no sense crying over every mistake. You just keep on trying till you run out of cake.
Alyssa has not run out of cake.
And the science gets done and you make a neat cut.
Does anyone know where we can wear Alessi's staying or something? Because I will personally buy him a Black Forest cake at this point. Because the man deserves it. If anyone knows where Alyssa is staying and where I can send him an emergency Black Forest cake, please let me know. I will pay for it. I will buy it from a nice baker. I am ready to spend $50 on a really nice Black Forest cake for an emergency Black Forest cake delivery. Do you think I can get it sent to the courthouse, or do you think that's too much?
For the people who are still alive. I'm not even angry.
Yep.
I'm being so sincere right now.
Yep.
Even though you broke my heart and killed me.
This song is so appropriate right now. I don't know who's singing this song. Is the witness singing this song, or is Alyssa singing this song? Even though you broke my heart and killed me? I don't know, man. I don't know. It might be the witness who's singing this song. This is a lot. The witness has a karaoke song for life. The witness has an absolute karaoke song for life. Holy fuck. I'm not even angry. I'm being so sincere right now, even though you broke my heart and killed me and tore me into pieces and threw every piece into a fire. As they burned it, it hurt because I was so happy for you. Holy shit. Now these points of data make a beautiful line. And we're out of beta. We're releasing on time. Well, this guy definitely got released out of beta. Holy shit. So I'm glad I got burned. Think of all the things we learned for the people who are still alive. Holy shit. This is Court TV. I don't know where you are, Court TV. I know it's copyright infringement, but it's like only $150,000 per violation. So like I think you got to do it. I think it's worth it. Just write him a check or something. I don't know. Holy shit, Court TV. I don't know. Just do it. Send an apology note to them later or something. I don't know. Holy shit. Fuck. Play this on stream. Fuck.
Go ahead and leave me. I think I prefer to stay inside. Maybe you'll find someone else to help you.
Probably, yeah. They probably should find someone else to help you. They probably, the prosecution would be well advised to find someone else to help them right about now.
Maybe Black Mesa.
Black Mesa might be a good bet.
That was a joke. Haha. That chance.
I'll take my chance with Black Mesa.
Anyway, this cake is great. It's so delicious and moist. Look at me still.
Do you think it qualifies as witness intimidation if I send him a Black Forest cake? Where's the witness staying right now? I will also send him a Black Forest cake. Congratulations on your testimony. We need to crowdsource some emergency Black Forest cake. We need to crowdsource an emergency baker in Canton.
Talking when there's science to do. Then I look up there, it makes me glad I'm not you. I've experiments to run, there is research to be done on the people who are still alive.
Yeah, research to be done on the people who are still alive. Holy shit, dude. This song is Chef's Kiss. Holy shit, dude. Holy shit, I didn't realize how appropriate this song is. Holy shit, dude. What the fuck?
And believe me, I am still alive. I'm doing science and I'm still alive. I feel fantastic and I'm still alive. While you're dying, I'll be still alive. And when you're dead, I will be still alive. Still alive. Still alive.
Apologies if that comprises copyright infringement. Apologies to the fine people at Valve and anyone else for that potential copyright violation. I'm sorry, but actually, on this occasion, I don't know, man. I don't even know if that comprises copyright infringement, because one of course, the major factors, of course, is transformative use. And I literally used the entire video in its original form. Nevertheless, given the context it's presented, I think I can make a fairly credible case on transformative. Holy shit. Yeah, it's transformative. Holy shit, dude. Holy fuck. Oh man, what a good time. Oh, I'm crying. It's okay. Oh man. Yeah, no, yeah. Let's go through the fair use factors. Yeah, let's do our quick 17 USC 107 analysis off the back of the envelope. 17 USC 107 analysis. Yeah, the classic uses for fair use: commentary, critique, news reporting. Yeah, transformative. Yeah, 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 yeah. I think that Court TV should just get their own. Just get their own singers. Get the Court TV choir. That's good. Let's do that. Let's get the Court TV choir and get them to sing it. Maybe we can get a youth group. We can get like the children's choir of Canton. There's got to be a children's choir out there somewhere we can borrow. Let's get a bunch of 8-year-olds, to sing it, or 12-year-olds or something. Get a bunch of 12-year-olds to sing it. Maybe a gay men's chorus would be good. There's lots of potential here. Does anyone know like a children's choir and or a gay men's chorus in Canton that would put together a song for me if I threw them a couple $100, asking for a friend? How much to get this recorded by a gay men's chorus in Canton? We'll retitle the song as well. We're not going to call it Still Alive. We're retitling it. What do we title it? We'll call it House Long to Die Inside as an Expert Witness. Maybe that's the title. There's potential. A barbershop quartet? Yes. I like the way we're thinking. Yeah, does anyone now we're talking. Is there a college in Canton or Boston? Or maybe Cambridge. Cambridge is in Massachusetts. Do we know any? Do we know any colleges in Cambridge? Perhaps one of those colleges that in Cambridge would like to one of their choirs would like to sing it. I'm willing to hire right about now. Let's read your super chats that have come in so far more. This is Searing the Cat, $6.99. Putting Masters of Law in Thoracic Brain Surgery from Harvard on my CV. If anyone asks, I'll just say it's a misinterpretation. DL became an uncivilian. Greg S. for $5 said, surprise. When they received new updated report, decided to contact the day before. Rose gifted 5 gift memberships. Pin King 554, $5. Don't worry, we're going to have a sidebar right away. Don't worry about it.
Honorable Beverly Cannoni, the Justice of the Superior Court holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors.
Are we not doing an immediate sidebar? No way.
So I have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with
Absolutely
anyone
not, Your
since we
Honor.
left yesterday?
Definitely couldn't do that. Sorry.
Everyone said yes or not affirmatively. Were you also able to follow my instructions and refrain from doing any independent
Nope.
research or investigation?
No, I might have done a little bit of that, Your Honor. Sorry.
Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday?
I don't know technically whether or not I saw or heard anything about the case in a technical
Mr. Burgess,
sense.
please?
Because I only watched the trial, which is the exact same thing the jury did. Well, that's not true. I watched some of Runkle's coverage. So yes, I did see something relating to the case. I was about to say, I'm not sure if I technically qualify because I only created the content. I technically didn't see the content. But I saw some of Runkle's coverage, so that even that was not correct. But it wasn't a lie. It wasn't a lie. I simply misinterpreted.
Mind you, you're still under oath. Thank you.
Good morning.
Good morning.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Morning, Mr. Burgess.
Morning.
On your direct examination yesterday, your experience was brought up in questions, correct?
Correct.
On your direct examination, your certifications were brought up in questions, correct?
Incorrect.
There was no discussion in your direct examination about having certifications in Celebrite and Magnet Forensic Axiom. Did I mishear that?
No, if I misheard your question, it was
I asked about certifications. I'll repeat it, sir,
Sure.
in case I misspoke. On your
We're off
direct
to a great
examination,
start, guys. It's going
your
really well.
certifications were brought up in questions, correct?
yes, correct.
However, on your direct examination, no questions were asked of you at all about your supposed education, correct?
Correct.
And you did not bring up your educational background at all on
Correct.
direct examination, correct?
Correct.
A forensic examiner must prioritize accuracy, correct?
Correct.
A forensic examiner must prioritize reliability, correct?
Correct.
Both are important.
Correct.
It's criminal proceeding we're in, correct?
Correct.
And therefore, accuracy and reliability are
Yeah, it's a
especially
criminal
important
proceeding we're
a
in
criminal
multiple
case,
senses of
as
the word.
opposed to a civil.
That's. I was laughing at it. I was laughing when he said we're involved in a criminal proceeding, because we're not only involved in a criminal proceeding, we're involved in a criminal proceeding. To paraphrase Breaking Bad. Yeah.
Civil case, correct?
I think it would be equally important in both, but yes,
But they're certainly important in a criminal case.
correct.
And accuracy and reliability are especially important when seconds and minutes matter, as they matter and as you testified to in this case, correct?
Correct.
You testified yesterday that the events on the timeline contained in your PowerPoint presentation that was displayed yesterday and presented to the jury were accurate, your words several times, down to the second, correct?
Correct. For the Lexus, yes.
For the Lexus.
Yes.
You said they were accurate down to the second.
Uh-oh.
Correct?
Correct.
Uh-oh.
Let's take a look at your PowerPoint presentation
Uh-oh.
that you discussed extensively.
Dude, do you not know you're in trouble? Do you not know you're in trouble? When on cross, the lawyer asks like 2/3 times when he asks, your report is accurate down to the second. Isn't that correct? You're being set up. Run away. Run away hard. Oh my God. Oh my God, help. Oh my God, help. What now? Shit.
Before the jury yesterday. Mr. Wool, could we please bring up slide 32 of the presentation Mr. Burgess discussed with the jury yesterday? And Your Honor, with your permission to publish,
Okay?
thank you. Mr. Burgess, pick your screen.
Sure.
Is this a true and accurate representation of your analysis of Miss Reed's Lexus vehicle traveling to 34 Fairview Road and the O'Keefe residence?
Yes.
According to your timeline, Miss Reed's vehicle powered on at 12:36 a.m. on January 30th, correct?
Correct.
Now, is your timeline on this slide accurate down to the second,
Oh,
as
no.
you stated in your direct
Oh, no.
examination yesterday?
No.
For the power on and off
no.
events, yes.
Yes.
You were just asked for the
Could we
fourth
go
time.
to slide 33, please,
You were just asked
Mr.
for the
Wolf?
fourth time. Is your report accurate down to the
And
second?
we're going to go through
Oh,
a handful
no.
of slides,
Sure.
Mr. Burgess, to just give you a heads up.
No.
Is this a true and accurate representation of your analysis of Ms. Reed leaving the O'Keefe's residence at 5:07 a.m.?
Yes, it is.
And according to your timeline, Ms. Reed powered on her vehicle at 5:07:46 a.m. on January 30th,
What fresh
2022,
hell are
correct?
we doing
Correct.
this morning?
Is the time on this slide
Too early for
accurate
this.
down to the second,
Oh,
as you
no.
stated in your direct examination?
No.
Yes, according to the Lexus, yes.
If we could go,
You
Mr.
were
Wood,
asked
to
again.
slide 34, please. And these are all your slides, correct, sir?
Correct, they
You
are.
prepared them?
Yes.
Is slide 34 a true and accurate representation of your analysis of Ms. Reed traveling to the Dighton residence at 12:25:01 a.m.? I'm sorry, 12:25:01 p.m.
12:35:01. Correct.
I'm sorry, thank
Yes.
you, 12:35. And according to your analysis, Ms. Reed powered on her vehicle to travel to Dighton at 12:35:01 p.m. on January 30th, correct?
Yes.
Dude, I think among many other, I don't know if Brendan has enough self-awareness, because if he does, he keeps his cards close to his vest, which to his credit he should, right? Like the line in A Few Good Men, right? Poker faces, right? You know, no matter what was said, that is exactly what you expected to be said, right? You know, don't react, don't scribble things down, just poker faces. No matter what happens, it's exactly what you expected to have happen. So if that's what Brendan is doing, then God bless him, he's doing it great. Everything is exactly what I expected. But if he is not like regretting the fact that he didn't want the voir dire, right? Because he's like, they want to voir dire my witness? Absolutely not. I don't want to voir dire my witness. And now we're just doing a voir dire. We're basically just doing a voir dire in front of the jury. And if he's not regretting his life choices at this point, silently inside, I don't know, man. I don't know. This was your fault, Brendan. If you had agreed to the voir dire, you could have then bailed, right? That if you had agreed to the voir dire and you had heard this, and you'd be like, you know what? I'm not going to be offering that expert anymore. Thanks. That might have been a better call. Oh my God.
That's correct.
And is the time on this slide?
No, note to self, to trial lawyers. Note to every trial lawyer everywhere. Just agree to the voir dire. Just agree to it. Just do it every single time. That's the new hot trial practice. That is the new hotness. The new hotness. Old and busted, resisting the voir dire. The new hotness for the trial bar, agreeing to the voir dire every single fucking time. We're gonna do I want the voir dire. All the voir dires forever. More voir dires. More voir dires. Holy shit.
Accurate down to the second, as you stated in your direct examination yesterday.
Yes.
Slide 35, please, Mr. Wold. Is this a true and accurate representation of your analysis of Miss Reed's vehicle being towed by the Massachusetts police vendor from her parents' residence in Dighton?
Yes, it is.
And pursuant to your timeline that you created here, Miss Reed's vehicle was powered on at 4:11 p.m. on January 30th, 2022 and towed to the Canton Police Department, correct?
Correct.
Is your timeline on this slide accurate down to the second, as you stated in your direct examination yesterday?
Yes, this timestamp is.
Slide 36, please, Mr. Wood. Is slide 36 a true and accurate representation of your analysis of Miss Reed's vehicle arriving at the Canton Police Department?
Yes, it is.
And pursuant to the timeline you created, Miss Reed's vehicle powered off at 5:36:42 p.m. on January 30th, 2022, correct?
Objection. Objection.
I'll let you have this.
Okay.
Is your analysis is your analysis on slide 36 accurate down to the second, as you stated in your direct examination yesterday?
Yes, according to the Lexus, yes.
According to the Lexus.
Yes.
In point of fact, Mr. Burgess,
Oh no.
none of the 5 timelines
No.
that we just reviewed from your presentation
Oh no.
are accurate at all,
Oh no.
and certainly not down to the second. Am I right or am I wrong?
You are wrong.
Are you aware, and if we could go back to the first slide, which is slide 32, and we'll look at each of them quickly.
Sure.
Are you aware that all of the relevant events in the timeline you described in your presentation in these slides actually occurred on January 29th, 2022, not January 30th, 2022?
Oh no. Oh no. No. Oh no. He put the wrong day. He put the wrong day. No. No. No.
Do you know that?
This is January 30th, 2022.
That's
Or
what
January 29th, correct.
It's January 29th, 2022. And in terms of January 30th, I want to go back and make sure it's very, very clear. In your presentation, they actually occurred on January 29th, 2022, correct?
The night of the incident, yes.
Oh
Can I have a
no.
moment, Your Honor, please?
Yes.
Thank you.
Oh no. No. It's accurate to the second. You put the wrong date on there. Oh no. No. Oh no.
Mr. Burgess, once that timeline crosses into midnight, it's January 30th, not January 29th, correct?
Correct, yes, it is January 30th, yes.
So in actuality, these 5 timelines, as you testified to them yesterday, are not accurate down to the second, correct? Because you got the wrong date.
Well, parlance, yes, but yes, they are.
Parlance. Uh-huh. Okay. Well, this testimony that's occurring as we speak right now on May the 21st of 2025 is very interesting. I'm very happy that we're together today, May the 21st of 2025. It is a beautiful May the 21st, 2025. Parlance.
Are still accurate to the second.
But the date, these 5 timelines, let's pursue this. These 5 timelines are exactly 24 hours off from the time where the event actually occurred, correct?
No, so these events occurred on January 30th. If I misspoke and said the 29th, yes.
Okay. You understand my point?
Yes, I do.
The core basis of your job, your role in this case, is to reconcile time discrepancies, as you say, down to the second, correct?
Correct?
But your discussion of the timeline on each of these slides, on each of these key events, is incorrect, correct?
No, it's not incorrect.
So your discussion of the applicable date, you're saying, as you described it yesterday and interpreted this timeline, was correct? Is that what you're saying now?
This timeline is correct,
But
yes.
my question is your discussion of it yesterday.
If I misspoke and said the 29th, then yes, I misspoke on that, yes.
And that was your testimony yesterday, what you spoke about.
Yes.
Let's turn to a different topic. Lights up, if we could, and thank you for taking that down, Mr. Bowe.
Okay. Oh,
Your,
dear. All right, it's fine.
actually, to mitigate the inconsistencies that you analyzed yesterday between independent clocks, am I correct that your position,
Yeah, DCD in chat says it's perjury. I'm not sure it is perjury. For it to be perjury, he has to know that what he's saying is false. See, that's the difference between a lie and an untruth, right? For it to be perjury, he has to know that what he's saying isn't true. Does he have knowledge? Does he have knowledge subjectively that what he's saying is false? I don't know, man. I don't know. I'm not sure about that perjury charge. Holy shit.
is that forensic methodology recommends cross-referencing timestamps from multiple sources to identify discrepancies and, when possible, leveraging time anchors events that contain both a system, timestamp, and an external physical event to identify and correct timing discrepancies. Do I have that right?
Yes, you did.
Yesterday, we talked about the scientific method. You recall that, sir?
I do.
And how it's designed to prevent bias from infecting the analysis. You recall that as well?
Yes, I do.
And yesterday, you agreed that experts should never selectively gather and interpret evidence to confirm a pre-existing belief while neglecting evidence that contradicts those beliefs, correct?
Correct.
And doing that is called confirmation bias, which you said you understood yesterday, right?
That is correct.
That would be improper to do that, correct?
Yes.
It would raise the specter, if not the reality, of unreliability if that occurred, correct?
It could, yes.
And it could also lead into errors in forensic analyses, correct?
Correct.
Let's take a look at your January 30th report, sir.
Okay.
And this is your first report, your second report being the May 8th report. In your January 30th report, you did not issue any opinion or conclusion with regard to the timing of what you call the text stream event 1162-2 in your January 30th report, did you?
No, I did not.
You didn't even mention either the phrase text stream event or the phrase 1162-2 in your January 30, 2025 report, did you?
No, I did not.
But in that January 30, 2025 report, you did evaluate the variance between the Lexus infotainment system on the one hand and Mr. O'Keefe's iPhone data on the other, correct?
Correct.
In fact, in that report, the January 30th report, you compared the call logs on Ms. Reed's Lexus infotainment system with the call logs on Mr. O'Keefe's iPhone in order to evaluate whether there was a variance, correct?
Correct.
And do I have it correct in your report that it's the position that the timestamp call log data, specifically the recorded calls between Ms. Reed and Mr. O'Keefe, along with the infotainment power event logs, were analyzed for what you called clock skew by cross-referencing them against other independent data sources, right?
No, so that would have been comparing the timestamps from Mr. O'Keefe's iPhone with the timestamps from the defendant's Lexus.
Right.
Correct, yes.
Yes. Right, to Ms. Reed's Lexus.
Correct.
And a forensic comparison of these data sets was aimed to identify timestamp discrepancies, correct?
Correct.
To identify potential clock skew, correct?
Correct.
And potential clock drift that could impact event reconstruction, correct?
Correct.
All is stated in your January 30th report, right?
Correct.
As the defense, the only thing I'm wondering right now is how do I keep this guy on the stand longer? That is the only question going through my mind as the defense. How do I keep this cross going? That is the only question I have. How can I make it last longer?
This marked as the next exhibit in order for identification?
Yes.
Excuse me.
Sure.
Yeah.
Exhibit BBB for ID.
May I present to the witness, Your Honor?
Yes.
Thank you. Mr. Burgess, I am presenting to you what has been marked as Exhibit BBB for identification. I'd ask you to take a look at it, sir, and then pick your head up when you've had a fair opportunity to take a look at it.
Okay, sure.
Do you recognize that document, sir?
I do.
May we approach, Your Honor?
Yes.
Thank you. What do you recognize that document to be, sir?
Sure. So this is a graph that I put together that is comparing timestamps, call timestamps from the infotainment module with Mr. O'Keefe's iPhone.
And is that Exhibit BBB for identification in your January 30, 2025 report?
Yes, it is.
And did you create that chart that is depicted in Exhibit BBB for identification?
Yes, I did.
And is that a fair and accurate representation of the information that you discussed in page 33 of your January 30, 2025 report?
Yes, it is.
I offer Exhibit BBB for identification into evidence, Your Honor.
If we can introduce the whole report to put it in
Why don't I
context.
see you at sidebar instead of floor?
There is no amount of sidebar that is going to fix this, Bev. There is no amount of sidebar in this world that is going to fix this. As a judge in this situation, I don't even know what I would do in this situation at this point. I don't know what I would do because I have created such a incredible problem as a judge. I don't even know how to fix it. As the defense, I'd be saying, what do you want me to do? Do you want me to strike the witness completely? Do you want me to I would do it at this point. Do you want me to strike the witness and give a cautionary instruction? But that's a lot of bell to unring. A mistrial with prejudice, I'd think about it. This is bad. This is really bad.
I'm sure if Mr. Brennan has questions and wants you to identify
Hold on.
you to.
Sorry.
Yeah, continue, Your Honor.
Yes.
Yeah, you can continue.
Your Honor, at this time, I offer Exhibit BBB into evidence.
Okay.
Exhibit 189.
Thank you.
They represented to the witness, Your Honor.
Yes.
Thank you. Mr. Burgess, I am represented to you what is now Exhibit 189 in evidence. Ask you to, once again, take a look at it, and if you need further time, please take it, sir, and then pick up your head when you've had a fair opportunity to look at that document.
Okay.
Despite claiming the purpose in your January 30 report of, quote, identifying timestamp discrepancies, potential clock skew, and clock drift, you did not compare the time of the three-point turn between the infotainment system in the Lexus SUV and Mr. O'Keefe's phone, did you?
Not at that time, no.
Instead, you identified the potential variance by analyzing various calls on the infotainment system of the Lexus versus Mr. O'Keefe's phone, correct?
Correct.
This data in that exhibit captures a precise moment in time that is easily compared between the two devices, correct?
Correct, it does.
Mr. Wolk, Your Honor, may Mr. Wolk please publish this exhibit?
Okay.
So this data, just to reestablish, captures a precise moment in time that's easily compared between the two devices, correct?
Correct.
No.
Now, according to your own table,
Oh no.
there are potential
No.
offsets of reading in the
No.
far right-hand column.
Oh no.
2
No.
seconds.
What? No.
1
What?
second, 2 seconds,
Oh,
1
no.
second, 8 seconds, 16 seconds, and 21 seconds, correct?
Correct.
And yet, you failed to apply this variance to the infotainment time on the Lexus associated with the text stream event 1162.2, correct?
Correct. May I explain?
I will.
If you can explain this, I'll be amazed. What the idea in principle is that you had two clocks that are different. This is not too hard to understand. They're two independent devices. The idea that their clocks would be different is readily understandable. But the thing that you have now is that you need different offsets for different events between the two clocks, and that doesn't make sense, right? The clocks should be ticking at the same rate. Like a second is a second no matter what clock is ticking, right? Unless you're like going fast enough and we have to bring relativity into this, but let's not go there. A second is a second no matter what you're doing. So if the clocks are offset by, say, 5 seconds, then okay, but they'd be consistently off by 5 seconds, right? It shouldn't be that sometimes they're off by 2 seconds and sometimes they're off by 1 second and sometimes they're off by 8 seconds and sometimes they're off by 16 or 21 seconds. That doesn't make sense. That makes no sense. Why would you need to change the variance between events with respect to the same clock? That makes no sense. If you can explain this, okay, explain it. Make it make sense. My mind is open. Make it make sense. This should be real good. It should be really good. Holy shit.
We'll proceed along. I'm sure if Mr. Brennan has questions and wants you to explain, he may choose to do that. This is simple arithmetic, is it not? It's either an addition or a subtraction, the offset, correct?
Correct.
Was the only way that makes sense. The only way that makes sense technically is that the Lexus SUV was occasionally, suddenly, and without warning, accelerating to near the speed of light and then was not doing it for a while. And then was accelerating to near the speed of light and then was not doing it for a while. That is the only way it makes sense. The Lexus SUV is just prone to sudden accelerations close to the speed of light so that the variances change. That is the only way this makes sense. Or of course, by other alternative idea that makes sense because it would explain a lot of things that we've talked about before. Unexpected black holes. Unexpected dark matter black holes. That would do it. Like that explains a lot of things in this case. We've talked about the unexpected black hole before, right? The unexpected black hole just appeared at the lawn of 34 Fairview. That is what caused John O'Keefe to fly through the air. It wasn't the Lexus SUV that hit him that caused John O'Keefe to fly through the air. It was the sudden black hole. You see, it caused a gravitational shift, right? That's what it was. The sudden black hole just appeared at the lawn at 34 Fairview. Just at the same instant, the car hit John O'Keefe, right? And the unexpected gravity caused John O'Keefe to fly through the air towards the unexpected black hole, and then the black hole magically disappeared, right? And that also, of course, explains the shift in colors, right? Because sometimes the taillight appears to like be a different color. And what happens, what happened is there's an unexpected black hole that appears just exactly in between the path of the light, between the lens of the Lexus SUV and the camera, right? It causes a Doppler shift that causes the light to merely appear to be an unexpected color. And now we've got unexpected black holes causing a time shift due to gravitational influences. The unexpected black hole is an explanation that continues to radiate through this case. I want a goddamn Nobel Prize. That's what I want.
And yet, in your initial report on January 30th, 2025, you did not take that final analytical step, did you?
No, because these clock variances do not apply to that time frame.
But you didn't take, you know what analytical step I'm talking about, correct?
No, I don't. I don't
All right.
believe so.
We'll come back to it. I want to go focus on your opinion. What you did do, as I understand it, in your January 30th report. So, in your opinion, we can leave that up for a moment, please, because I want to see if we need to show the contrast. With your Honor's permission, can we leave it up just a little bit longer?
Yes.
Thank you. In opinion number 5, and please feel free to look at your January 30th report,
Sure.
you indicated only this. The difference between the Lexus infotainment and Mr. O'Keefe's cell phone ranged between 8 seconds and 16 to 21 seconds during the period between 5:21:36 a.m. and 5:30:31 a.m. on January 29, 2022. Do I have that correct?
Yes, between 5:21 and 5:30 a.m.
Yes. Now what I'd like to do is, and we can take that down, thank you, Mr. Wope. Let's talk about what information you learned after you issued your January.
Or the other explanation, or the other explanation is sun events. It is possible, as I'm sure some of you know, it is possible for sun events to sometimes flip bits on computer data. This is actually a thing that sometimes has to be accounted for. When you get random coronal ejections from the sun and stuff like that, and like random sun interference. So the other way that it makes sense is that the times of the events are distorted, right? Because it wasn't that it wasn't recorded properly. That would be the black hole, right? The black hole explanation would be why it wasn't recorded properly, because the time was literally different because of the black hole. Other explanation is unexpected sun activity causing bits to flip. That just makes it appear to be different, which also, of course, explains the deleted search, right? Because and also explains the call logs relating to the butt dials. It wasn't a butt dial. In fact, the entire log is a phantom. The entire log is a phantom because the sun created the log by bit flips that just so happened to create the appearance of a log. So, the sun interference, electromagnetic activity. That's it. That's what's happening. It's the sun. It's the goddamn sun and the black holes, man. Black hole sun, won't you come and wash away the rain?
January 30, 2025 report. Or at the time of that report, you received and reviewed a copy of a portion of your colleague's slide presentation and report at Aperture, Dr. Judson Welcher, correct?
From a presentation by Mr. Dogra. Yes.
Well,
correct.
I understand you want to add Mr. Dogra. My question is...
Sustained.
Okay, yes, Your Honor, thank you. I'm focusing on what would you like to call it? Do you call it a slide presentation you prefer of Dr. Welcher?
Sure, we can.
I want
we
to
can
use whatever parlance you're comfortable with.
Slide's fine, yeah.
Slide. So the slide presentation of Dr. Welcher that he submitted the same day you submitted your report on January 30, 2025. And in that, he analyzed the timing of the 11:62 what he calls an infotainment event, you call a text stream event, correct?
Well, could I see the slide we're talking about to clarify?
Absolutely, absolutely.
Yeah, you can see the slide. The slide will save you, I'm sure.
Could we publish what is in evidence of what is 188?
Okay?
And I'm also, sir, at your request, may I approach, please?
Yes.
At your request, I want to give you
Sure.
that, you know, if we have 188, we'll just give them the actual marked exhibit. You know what we'll do? We'll use the slide. If you need an exhibit, we'll pull the exhibit and move it along. Please publish, Mr. Woke.
Quantum computing. There you go. Lexus. Lexus apparently, that's a good
Now,
explanation.
if we could
I like
enlarge
that
the-
explanation, chat. Lexus has, unbeknownst to anyone, started using quantum computers in their SUVs. And quantum computing is not really ready for prime time because sometimes it will create problems with data. So that's it. Yeah, Lexus is just so ahead of the curve that they started to use quantum computing in their informatic systems, and the quantum computing is not quite ready for prime time, and so it's creating data discrepancies. That makes a lot of sense. Who knew Lexus was so on the cutting edge? Yeah, that's good.
The text, we don't need the map, so make that as large as you can, please, Mr. Wolf, in the relevant portions.
Oh, Lord.
All righty. You're aware that according to Dr. Welcher's analysis, as depicted in this slide in evidence, the 1162-2, what he calls an infotainment trigger that you call a text stream event, right?
Correct.
The 1162-2 text stream event occurred at 12:31:38 a.m. on January 29, 2022, correct?
Correct.
And that's when it began, right?
That's when the trigger threshold was met. Yes.
That's when the trigger threshold was met.
correct.
You we can take that down now, Mr. Woke.
Yeah. Wow.
You also
Wow.
testified yesterday that you reviewed Mr. Whiffen, Mr. Ian Whiffen's January report, which established a timeline of the last interactive events on Mr. O'Keefe's phone, correct?
Correct.
Your Honor, could we please publish Exhibit 39, which is in evidence?
Okay.
And if we could go to slide 82 and have 83 available, if we can enlarge the applicable sections. And what I'm going to ask you, Mr. Burgess, is to see whether these events are consistent with your memory of what the applicable events are. Do you see the column biometric device unlock with Face ID event at 12:32:04 a.m.?
Yes.
Now that's after the 12:31:38 a.m. 11:62:2 text stream event that's in Mr. Welcher's slide, correct, that we just saw?
Correct. The unadjusted Lexus clock. Yes. Timestamp. Yes.
So, but it's, I'm going to repeat the question. The 12:32:04 a.m. device unlock with Face ID event is after the 12:31:38 and 12:31:43 11:62:2 text stream event that is stated in Dr. Welcher's report, correct?
Correct.
Now, do you see the lock event which occurred at 12:32:09?
Yes, I do.
That is also after the 12/31/38 to 12/31/43 text stream event, correct?
Yes, the unadjusted time.
That 12:32:09 a.m. lock event is after the 12/31/38 to 12/31/43 range that is stated in Dr. Welcher's report, correct?
Correct, from the Lexus clock.
So, if we could go back, and we're going to toggle back with Your Honor's permission between these two slides for the next couple questions. If we can go back to and enlarge Dr. Welcher's slide. That 12/31/38 to 12/31/43 time period is what your colleague, the licensed engineer, Dr. Welcher, chose and his slide analysis as the last user interaction, according to him, on John O'Keefe's phone, correct? That's what he chose.
Yes, the 12/32/09, yes.
Now, if we could go back to and zero in, please. Now, but even Mr. Whiffin's report establishes additional activity on Mr. O'Keefe's phone after the event chosen by Dr. Welcher, correct?
Correct.
And, in fact, Mr. Whiffin identifies a, quote, lock event that occurred 26 seconds after the 11:62:2 text stream event identified by Dr. Welcher at 12/31/38 to 12/31/43, correct?
Correct, using the unadjusted clock.
I would like, does Dr. Welcher at all use the words unadjusted clock in his slide, sir?
No, he does not.
Okay, what I'd like to do is ask you a question about whether, in fact, Mr. Whiffin identifies a lock event that occurred 26 seconds after the 11:62:2 text stream event at 12/31/38 to 12/43 as stated in your colleague's report, Dr. Welcher, the slide presentation. Is that correct?
Yes, that's correct.
Do you know whether a lock event on an iPhone requires human interaction?
Typically, yes, it would.
Is it just typically, or does it?
Well, it does, and in this case specifically, I believe it was via the lock button.
Correct, but this specific instance, the lock, it requires somebody, a human being, to actually press a button on the side, correct?
Unless it's auto locking, yes, it requires a button press, yes.
Do you have any reason to believe that the iPhone of Mr. O'Keefe had an auto locking function on it, sir?
No, as I said, he used the lock button.
Right. If we can enlarge that, do you see the end of health event 36 steps that we talked yesterday that was covering a distance of over 84 feet? Do you see that occurring at 12:32:16 a.m.?
I don't believe we talked about that yesterday, but yes, I do see that.
Do you see it?
I do, yes.
And that's also after the 12/31/38 to 12/31/43 text stream event identified by your colleague, the licensed engineer, Dr. Welcher, in his slide, correct?
Correct.
Now, finally, do you see the entry pocket state detected at 12:33:14 a.m. You see that, sir?
Objection.
Sustained.
How is that objectionable? Do you see this on the
Do you
slide?
know
How's that
what
objection?
a pocket state is, sir?
I do know what a pocket state is.
Do you know when the pocket states occurred on the iPhone of John O'Keefe pursuant to your analysis of his phone?
I do not.
You didn't analyze pocket state detections on Mr. O'Keefe's phone?
No, I did not personally.
Do you believe pocket state detected data? Well, let me just go back and confirm. So you didn't analyze with any source pocket state detection information with regard to Mr. O'Keefe's phone, is that correct?
That's correct.
So let's go back and summarize for each of the ones you did look at and analyze that you just testified. Every single one of those that we just discussed, those user interaction events, occurred after Dr. Welcher claims a collision occurred as represented in a text stream event of 11:62:2 at 12:31:38 to 12:31:43, correct?
Objection.
Sustained.
Do you understand? Let's, if we can go back, please, to Dr. Welcher's slide. Highlight the text again, please, Mr. Woke. Do you understand that Dr. Welcher is correlating the infotainment trigger 11:62:2 with an alleged collision? Do you understand that?
Objection.
Let's come to sidebar, please.
I don't know what to say. What can you really say? I've got nothing to say. It's just absolute trash fire. Let's skip ahead.
From Dr.
You can put it back up.
Thank you, Your Honor. If we could go now, Mr. Woke, back to the slide from Dr. Welcher's slide presentation. And if you could re-enlarge the applicable section that we've had up before. Thanks for your patience,
Sure.
Mr. Burgess. You have reviewed this slide and this specific data in this slide previously, correct?
Correct.
And I just want to, Mr. Woke, just go back to the slide so we're clear on what this is. So this slide here is what you're speaking about, right?
Correct.
And you've reviewed this slide prior to your testimony in this court, correct?
Correct.
And you considered this slide as part of your analyses that you have performed and testified about, correct?
Yes, I have.
So, now, Mr. Burgess, I'd like to ask you a question. Every single one of the user interaction events that we talked about, steps, lock, etc., occurred after Dr. Welcher's, what he calls an infotainment event, which you call a tech stream event, in the range of 12:31:38 to 12:31:43, correct?
I would agree that, yes.
So
with-
the answer is yes?
With the caveat.
I'm sorry, I didn't know
Sorry.
you hadn't finished.
Sure.
Please finish your answer.
Yes, with the caveat that user interaction only applies to the device lock, steps, and the pocket state are not duplicative of user interaction per se.
Let's just assume that is the case. Let's then just focus on what you consider to be a user interaction, which is device lock, correct?
Correct.
And the device lock event that you agree is a user interaction, we could go back to that just so we have clarity. The lock event that you agree is a user interaction occurred at 12:32:09, according to Mr. O'Keefe's phone, correct?
Correct.
In that 12:32:09 time period, we could go back to Dr. Welcher, it is after the end of the text stream event dubbed as 11:62:2, correct?
Correct. According
And that's
sorry.
26 I didn't finish my question, I'm sorry, Your Honor.
So go ahead, finish your question. Don't answer, Mr. Burgess, until the complete question.
In that event lock, even according to Dr. Welcher's own words in his own slide, occurs 20 seconds after the end of the text stream event 11:62:2, correct?
Of the unadjusted clock, yes.
May I have a moment, Your Honor?
Yes, do you want the lights on, Mr. Lessie?
I'm going to keep that up. And so to repeat to alter it, hopefully make it a little clearer.
Sure.
So according to Dr. Welcher, the licensed engineers, your colleague at Aperture, his slide that he has here, the last O'Keefe cell phone event, the lock, occurred within approximately 26 seconds after the end of the text stream event dubbed 11:62:2. That's what's stated there, correct?
Correct. According to the unadjusted clock.
You keep adding according to the unadjusted clock, but do the words according to the unadjusted clock appear anywhere in that slide, sir?
No, they do not.
We can take that down and, with the court's permission, turn the lights back on, please. Yesterday, you stated that you reviewed a presentation by another expert, Mr. Dogra, who reviewed the findings of your January 30th report. Do you recall that, sir?
Yes, I do.
In fact, in your May 8, 2025 report, your second report, your first being the January 30th report, you only cite 2 new sources of data that you reviewed before making your conclusions, correct?
Correct.
May I have a moment, Your Honor?
Yes.
May I approach, Your Honor?
Yes.
I'm going to need to be heard on this as well.
All right.
You need to be heard on this? You think that there's a way I don't know as a lawyer what you do in this situation. I don't, honest to God, know what you do in this situation. It's such a trash fire. I guess you do your best to fight for every inch, But this is like,
And approach the witness.
this is so disheartening. I'm not sure what you do. I guess even though the fact you're behind like 70-0, you just keep playing the
Your Honor, and
game.
approach the witness.
Yes.
Thank you.
What else can you do? You just keep playing the game.
Excuse me, Mr. Burgess.
Sure. I guess.
I'm going to present to you 2 documents, each of which is marked for identification. The first is Exhibit CCC for identification. That is one slide out of what is marked as Exhibit DDD for identification. And Exhibit CCC is one page out of Exhibit DDD for identification. And I'd ask you, sir, to take a look at those documents and reference either one. And please let me know, sir, when you've had a fair opportunity to review those documents so I can proceed with questions about them.
Sure.
List this dark mug.
Okay.
Sir, can you please read the exhibit designation on the entire slide presentation?
On DDD.
Pardon me?
On Exhibit DDD.
And that's triple D as in David?
Correct.
So in Exhibit DDD, is that the March 5, 2005 PowerPoint presentation of Mr. Dogra that you spoke about extensively yesterday?
Yes, it is.
And sir, before you came to court yesterday, did you review and consider the Exhibit DDD for identification?
Yes, I did.
And as a matter of fact, you spent considerable time with regard to Exhibit DDD before you came to court yesterday.
Correct.
And in addition, isn't it the case that your testimony yesterday is that Exhibit DDD, the March 5, 2025 slide presentation of Mr. Dogra, was part of the reason why you created your May 8th, 2025 report, correct?
Correct.
May I approach, Your Honor?
Yes.
Yeah. Tony says DDDDs.
Your Honor,
Yep,
I
D is
offer
nuts indeed.
Exhibit Exhibit CCC into evidence, and do not offer Exhibit DDD at this time.
Okay, the witness just spoke of DDD, so why don't you have him just say what CCC is before we put it in?
I will do so, Your Honor. Thank you. Mr. Burgess, is Exhibit CCC a slide page out of Exhibit DDD?
Yes, it is.
Okay, now it'll,
Thank you for that, Your Honor. I now offer Exhibit CCC for identification into evidence.
yes.
Thank you. And I also hand back to Madam Court Reporter Exhibit DDD for identification.
Exhibit 190.
This guy looks like the manager of a Blockbuster
And sir,
video.
do you have before you read the 3 letters, please, just so we're on the same page in that exhibit?
Jim, we need that. The
That
other
the
one.
one that's in
Thank you.
the one page?
I know I really shouldn't be one to talk, but this guy needs to do something
Yes.
different with his hair.
Exhibit 190.
I don't know what
And
it
that's
is, but
the
we need to have a conversation.
Entitled All
man.
Possible Combinations?
Yes, it is.
So we'll refer to that as Exhibit 190, okay?
Okay.
Have you had a fair opportunity to
You know, pot,
refresh
kettle,
yourself
and all
on
the
that
rest of it,
one-page
but still,
chart?
damn.
Yes, I have.
Your Honor, may I please publish Exhibit 190?
Yes.
And if we could enlarge it without, I think, Mr. Wolk, we can obscure for the moment the all positive on the right and come back to that as needed. Thank you.
We need to get this guy a
Now,
subscription to him or
Mr.
something.
DeSogra, who is
Get this guy
an
some
expert
Propecia
for the
or
defense,
something.
took the data points you evaluated in your January 30, 2025 report and simply performed the last step in your analysis that I was referring to in previous slides, correct?
Correct. For a lot of data points that do not apply for the time of the accident.
I understand you may have a view as to whether they apply or not. I'm just trying to understand
Objection.
what you understood he did.
Again,
I'll repeat. Yeah, yes,
So
Your Honor.
we'll strike the comment part and just a
I'll
question,
repeat
please.
and just go to the question. So you understand
I don't think the
that
bald book is
Mr.
gonna work for
DeSogra
him.
took the
I really
data
don't.
points that you evaluated in your January 30, 2025 report
Maybe we'll
and
give him a
simply
toupee, I don't
performed
know.
the last step in your analysis, correct?
In my report, in addition to Dr. Welcher's.
Right. In addition to Dr.
Correct.
Now, what I want to do is just elucidate the columns and their meaning. So, the column on the right equals the number of seconds, and it's the far right, the number of seconds between the end of the 11:62:2 text stream event that in the slide of Dr. Welcher is ending at 12:31:43 and the lock event on Mr. O'Keefe's phone that's occurred at 12:32:09, correct?
Correct.
And that's your understanding of that column as well.
Correct.
Now, even taking your colleague Dr. Welcher's assumption that the last user interaction on Mr. O'Keefe's phone occurred at 12:32:09 a.m. on January 29, 2022, is Mr. DeSogra demonstrating in this chart that by using the clock variance that you calculated in your January 30 report, there are no circumstances where the trigger event of 11:62:2 occurs before the lock event on Mr. O'Keefe's phone?
Objection.
After.
Sustained. There's one part of your question that needs to
Okay.
be omitted.
In terms of this chart, do you agree that the methodology and application of it of Mr. DeSogra is that Mr. DeSogra took the last user interaction data point of Dr. Welcher in his slide of 12:32:09 and applied the clock variance that you calculated in your January 30th report? Do you agree that that's what Mr. DeSogra did?
No, I do not.
What do you believe Mr. DeSogra did here?
Well, so the math is correct. So when he's trying to adjust clock variances between the two devices, that math is correct, but he's applying incorrect adjustments.
I understand, but what I'm trying to get at is just what you understood Mr. DeSogra did in this chart.
Correct. I did understand, yes, what he
Okay.
was trying to do.
And so, do you agree, based upon what Mr. DeSogra did as represented in this chart, there are no circumstances where the 11:62:2 tech stream event occurs, well, let me have you describe what you believe Mr. Dogra is doing with regard to comparing, based upon this chart, the 1162-2 tech stream event of Dr. Welcher with the lock event on Mr. O'Keefe's phone.
Sure. So he's trying to adjust the clock from the Lexus to the Mr. O'Keefe's iPhone clock, but he does that inaccurately.
Well, I understand you have I understand your comment. But my question, sir, is this. What do you understand Mr. Dogra is doing with regard to this chart? Do you understand what he is doing in this chart?
Correct.
I'd just like you to state what it is you understand he is doing.
Sure. So he's trying to adjust timestamps.
He's trying to adjust timestamps. In adjusting timestamps, do you agree that Mr. Dogra makes the point with this chart that there are no circumstances where the 1162 trigger occurs before the lock event on John O'Keefe's phone?
Objection.
Sustained.
All right. Can I have a moment, Your Honor?
Sure.
Thank you. Let me see if I can clarify this in this my question.
Sure.
Do you believe, do you understand that what Mr. Dogra is doing in this chart is he is showing numerically and arithmetically that there are no circumstances where the tech stream event 1162-2 occurs after the lock event on Mr. O'Keefe's phone?
Objection.
I'm going to allow it in that form.
So yes, I understand he's trying to show that.
Right. Well, he did more than try. Isn't that what he, by his math, that he is demonstrating?
Objection.
I'm going to allow that.
Yes, but it is inaccurate.
I understand. But that's, again, the question is that what he demonstrates using this chart?
Yes.
And what he demonstrates is that Mr. Dogra demonstrates that there are no circumstances where the 1162-2 trigger event occurs after the lock event on Mr. O'Keefe's phone, correct?
Yes, inaccurately.
So I'm asking what Mr. Dogra demonstrates in this report, and isn't it correct that Mr. Dogra, using this math, Mr. Dogra demonstrates and concludes that there are no circumstances where the 1162-2 tech stream event occurs after the lock event on Mr. O'Keefe's phone?
Objection.
I'm going to allow that. Does that demonstrate that?
Yes, inaccurately.
Okay.
So let's.
I'm going to move on, Your Honor. I'm going to move on. And this methodology and approach of Mr. Dogra is simply math that he's using, correct?
No, it's not simply math.
Well, let's go to the clock variance values in the middle column on that chart. You see that, sir?
Yes, I do.
Those are, as of March 5 of the date of this, that this column was created, nothing in that middle column is new, is it? That data?
Yes, some of that data is new.
Well, the source data upon which it is created is not new, is it?
No, it is not.
All right. So the source data of that column, it's not new.
Correct.
And the middle column uses your data points from your January 30th report, correct?
No, not all of those are.
But it does use some of the data from your January 30 report, correct?
Yes, it does.
Is the reason that you did not take that final analytical step that we've been talking about in your January 30th report, and this is a question, is the reason you failed to take that final analytical final analytic step we've been talking about in your January 30 report was because you knew if you did that if you calculated the actual time of the 11/62/2 text stream event based upon your own methodological analysis of the clock skew, there would always be continued interaction on Mr. O'Keefe's phone after the text stream event.
No.
So you deny that?
Yes.
Okay. Good.
Did you keep your January 30, 2025 report purposefully vague by merely noting a clock skew without engaging in any further analysis, such as tethering that clock skew or otherwise connecting it to the text stream event in Dr. Welcher's slide presentation?
No, I did not.
Switch to another topic. Take that down. Thank you, Mr. Wobe. After reviewing, and I'm going to identify 3 timelines. After reviewing the timelines, the timelines presented by Dr. Welcher, 1, Mr. DeSogra, 2, and Mr. Ian Whiffen, 3, all of which established that the 11/62/2 text stream event occurred before that last user activity, the lock on Mr. O'Keefe's phone. You then decided to issue a new report that would become dated May 8, 2025, correct?
Objection.
I'm going to allow that.
No, so I issued the supplemental report based on that presentation that you just had up.
Well, before you issued that report, isn't it correct that you had reviewed the time data of Dr. Welcher in the slide that we were reviewing?
Not before that time, no.
You had not looked at Dr. Welcher's slide with a text stream event 11/62/2 and a time for that before issuing your May 8th report?
No, yes, before sorry, misheard you, yes.
That's my question.
Yes.
So let me just ask it through a question.
Sure.
So it is correct that before you issued your May 8th, 2025 report, that you had reviewed that slide of your colleague Dr. Welcher on 11/62/2 that establishes the text stream event as 12/31/38 to 12/31/43, correct?
Correct.
You reviewed it before your May 8th report.
Yes.
You
yes.
also reviewed before your May 8th report the slide presentation of Mr. DeSogra, correct?
Yes, I did.
And before you issued your May 8th, 2025 report, you also had reviewed the January 2025 report of Mr. Whiffen, correct?
Correct.
Each one of and all of those 3 established that the 11/62/2 text stream event occurred before the last user activity on Mr. O'Keefe's phone, correct?
Objection.
I'm going to allow it if that's what, let's see what the answer is.
Using either unadjusted timestamps or inaccurately adjusted timestamps, yes.
Let me ask my question again, and if it's not clear, please let me know.
Sure.
After reviewing what we've discussed, prepared by Dr. Welcher, Mr. DeSogra, and Ian Whiffen, each and all of which established that the 11/62/2 text stream event occurred before the last user activity on Mr. O'Keefe's phone, You then decided to issue a new report that would become dated May 8th, 2025. Is that statement I just made correct?
Yes, that is correct.
Now let's take a look at your May 8th, 2025 report.
Oh my God. Aperture needs to have like a crisis meeting.
You
Aperture
departed
needs to hire
in your May
crisis
8th,
PR
2000.
man.
Did you,
Holy
sir, do you have
shit,
that
dude.
report in
I
front
do,
of you?
yes.
Do you need a
I don't
moment
know
to
who
look
you
at it,
get
or
as
are you ready
Aperture,
to
man, but
take
No,
questions?
you
go
need
ahead.
to pay someone
Thank
a
you.
shit ton of money.
You departed from your analysis. Let's start it this way. In this May 8, 2025 report, you departed from your analysis in your January 2025 report to reach a conclusion that would attempt to put the 1162.2 text stream event after human interaction with Mr. O'Keefe's phone, correct?
No, I did not depart from my original report. I clarified.
Okay, so you didn't depart from it.
didn't depart.
But you, in your May 8th report, but your position is you clarified.
Clarified.
Correct.
Okay.
But isn't it correct
Sure.
that in
yeah.
your January 30, 2025 report, you did not address at all whether the 1162.2 text stream event occurred before or after the last user event on Mr. O'Keefe's phone, correct?
Correct.
But you did that in your May 8th report, correct?
Correct.
You don't call that a change, sir?
No, sir, I do not.
You call that a clarification.
I do.
Okay. I mean, he doesn't call it a change. He calls it a clarification. I mean, you know, it is okay.
In your
fair.
January
I mean, all right.
2025
All right.
report,
Sure.
you compared call log entries between the infotainment system on the Lexus and Mr. O'Keefe's iPhone to determine a potential variance, correct?
Correct.
And call logs are discrete points in time that are fairly easy to compare.
Correct.
Now, in your May 8th, 2025 report, you abandoned the call log analysis from your January.
On behalf of the channel on civil law, I'd like to formally apologize to Trooper Paul. Trooper Paul, I'm sorry. We completely misjudged you. Please accept my apologies.
January 30th, 2025 report, correct?
No, I did not abandon it.
But you did depart from it, at least in some respects, correct?
I did not depart from it. I used another method.
Okay. So you used another method.
Correct.
In your May 8th, 2025 report, you opined, as I understand it.
I'd also like to formally take, I don't know, personal umbrage with Brennan, because I made what I think was a fairly reasonable assumption when I previously was talking about 66% chance to convict or 60% chance to convict. As I said, when I made those predictions, I was making, I think, what was a reasonable assumption that Brennan would get people that would be comparable to Aperture. That would be the reasonable expectation, right? He has his choice of experts. There's a wide swath of experts. There's a lot of people out there. And to find someone who could, back his play, that would have the credentials that could, in some sense go to toe-to-toe with Aperture, was, I think, a pretty reasonable assumption. Unfortunately, Brennan is now making me look like a complete asshole. And I'm looking bad because I assumed that he'd find someone competent. And I feel personally aggrieved at this point.
that the call log variance has been ignored because, in your words, this offset is measured approximately 5 hours after the time of the alleged collision and cannot be assumed to apply to other timeframes as stated in the initial report. Do I have that right?
Yes.
Now, please show me,
Oh dear.
show the juror,
Oh dear.
in your January 30 report where you ever made that statement.
No. Okay. That's. It's not there. I promise you it's not there. I assure you it is not there. It is not there.
Sure. So that would, it's not worded exactly like that, but that would be in conclusion 5.
And conclusion number 5 is on page 37 of your January 30, 2025 report, correct?
Correct.
And you concede at least as much that at least different words are used in paragraph 5 in your January 30th, 2025 report, correct? And your position is that it's the same statement as in your May 8th, 2025 report? Because that's my question.
That is correct.
Stop! He's already dead!
In your May 8th, 2025 report, instead of applying the offsets from the call logs, which are discrete points in time that are fairly easy to compare, as you stated just moments ago, you decided to use, in your words, quote, approximate time of the 3-point turn as your anchor between the two devices. Do I have that right?
Yes, you do.
Isn't what you did and we just discussed a classic example of confirmation bias, which is to be avoided in science?
No, it is not.
So you believe that that is not confirmation bias?
No.
Choosing the 3-point turn as the independent data source is the only way you could ever get the text stream event to even possibly occur after the lock event on Mr. O'Keefe's phone, correct?
That adjustment is the only adjustment that can be applied due to the data. Yes.
And that adjustment is the only thing that can be done to get the text stream event 1162.2 to occur after the lock on Mr. O'Keefe's phone, correct?
Correct.
And that only one is the one that you chose, correct?
Correct.
And that's only because it's not a pinpoint in time. It's an amorphous range that can only, in your words, be approximated, correct?
No, that is because it is the only time adjustment in that time range that can be applied.
So it's your view that that's the only one that can be applied, but it is even what you're using is, in your words, an approximate time, correct?
Correct.
Isn't the shortcoming, sir, in your analysis that you ignored the additional user activity on Mr. O'Keefe's device that occurred after the lock event?
After, can you repeat that question?
Yes, I can. Isn't the shortcoming in your analysis, sir, that your analysis ignores the additional user activity on John O'Keefe's device, his cell phone, that occurred after the lock event?
No.
Well, let's take a look at events that, you tell me if I'm correct or not, occur after the text stream event 1162.2.
Sure.
So, do you recall our discussion yesterday about the Apple Health data event of 36 steps covering a distance of over 84 feet? Do you recall that?
Yes, I do.
And do you recall that that occurred at 12:32:16?
Yes, I do.
And that's after the text stream event of Dr. Welcher that he put in his slide, correct?
Correct.
Do you also recall a Doppler pocket state detection at 12:33:14? Do you recall that?
Yes, I do.
And that is almost an entire minute after the 1162.2 text stream event that is identified by your colleague, the licensed engineer, Dr. Welcher, in his slide presentation, correct?
Correct. And neither one of those are user interaction.
I understand your, well, but let's just take
He's about to say
one
I
of
understand,
them.
but he's like, no,
And
actually I
that
don't.
is the
no.
Apple
No.
Health data event of 36 steps covering
Unless
a distance of
unless he's
84
like, I was
feet
about
at
to say I understand, but no,
12:32:16.
really no.
Would you agree that those steps covering that distance is human activity at least? Would you agree that's human activity?
Yes.
Thank you. Let's take a look at opinion number 7 in your initial January 30th, 2025 report.
This feels like potentially one of the most complex ethics problems you could ask on a bar exam right now. As the prosecutor, what are your ethical obligations and what are your ethical options as the prosecutor in this situation? Because you have a duty to zealously represent your client, but you also, of course, have duties as the prosecutor to, for justice and all. So what are the ethics here as a prosecutor? This feels like the worst ethics exam ever, man. Holy shit.
And sir, tell me when you had a fair opportunity to locate that.
Okay.
You concluded to a reasonable degree of scientific certainty that, quote, the infotainment module power-on events were on average recorded 3 seconds after the ignition release or finger off, correct?
Correct.
That means that your own testing requires an offset of -3 to account for a delay in the power on of an infotainment system, correct?
Correct.
That increases the time between the text stream event 1162.2 and the iPhone lock event by 3 seconds, correct?
Correct.
You testified about this same 3-second discrepancy yesterday during your direct examination in connection with your January 30, 2025 report, correct?
Correct.
However,
Oh no.
you did not mention this offset of 3 seconds in your May 8th, 2025 report, did you?
No, I did not. Can I explain?
No.
Mr. Brennan may have questions for you with regard to that. So nowhere in your May 8, 2025 report did you include the 3-second offset that you discussed in your January 30, 2025 report, did you?
Correct.
And in fact, sir, nowhere in your May 8th report do you even discuss why you're not addressing that 3-second, do you?
I do not discuss it, but it is, that offset is adjusted within the adjustment that we do with the 3-point turn.
I understand. My question is simply, there's no discussion in your May 8, 2025 report how or why you're not discussing that 3-second offset, correct?
Correct.
I've got a next section, Your Honor, if you would like me to move into it.
So why don't we keep going?
Okay. Sir, a text stream data event like 1162.2 does not, well, let me back up this way. You testified on direct that you're involved in accident reconstruction. That's part of the work that you do, sir?
No, that is not part of the work that I do.
Well, let me clarify then. Do you at all understand whether there's an issue as to whether a collision actually occurred in this case? Do you understand if that's an issue?
Objection.
Sustained.
Sir, do you have any understanding about what Dr. Welcher in his slide presentation was addressing in context with this case? Do you understand it?
Objection.
I'll allow a yes or no on that.
No, I do not.
So you have
I believe that.
No idea
I believe he doesn't understand.
your
Yep,
colleague,
I believe it.
Dr. Welcher, who's working on the same case, was addressing in his slide presentation?
Generally, yes, but I cannot speak to it.
What do you generally understand?
Objection.
Sustained.
What understanding do you have after reading Dr. Welcher's slide presentation?
Objection.
Sustained. Ask it different. Sustained.
Do you have any understanding?
That's a
Can
good
we
question.
approach, Your Honor?
Sure.
Do you have any understanding? Question is pretty good. Yeah. Do you have any understanding is a very, very good and very, very appropriate question. At this point, I'd like to announce a brand new merch item. Because, obviously we need a brand new merch item. I'd like to announce the Unexpected Black Hole coffee mug. Unexpected Black Hole Case Solved coffee mug. See, it's got a black hole in the back. That's nice. And then, it's got Unexpected Black Hole Case Solved, and it comes in your choice of colors. You can get blue accent, you can get pink, yellow, black, orange. Orange is good. Orange with black, that's good. $13.95 can be yours from our merch shop. Yeah. The Unexpected Black Hole explains many, many, many things in this case. Yeah. And we're back to live. Very exciting. On the plus note, we have hit enough for a merch giveaway. We've hit our 550 likes, so it's time for a merch giveaway. So let me set that up, and you might be able to win the Black Hole mug. How exciting for all of you. So give me a second to set it up, and we'll run a merch giveaway. Good times. Okay. Talk amongst yourselves, please. All right. Yep. This is, yeah, I like this one. Let's do this one. All right. Where's my streaming thing? Too many windows open, man. Too many windows. Oh shit! Did I close this? Did I close the stream? Oh no, good. I thought I closed the stream for a second. Ugh. That would have been disastrous. Oh dear.
May I proceed, Your Honor?
Yes.
Thank you. Thanks for your patience, Mr.
Yes, sir.
Burgess. I would like to go back to the line of questioning I was starting, and that is I would like to discuss with you, and I'll start with your conclusion, and I'm going to reference your May 8th, 2025 report, sir. If you could turn to the conclusion section of your report, which is on page 7. And I'm going to start with, and I may just end with, we'll see, conclusion number 1. Please take a fair opportunity to read that. Pick your head up when you have concluded that fair reading.
Pick your head up. Pick your head up. Start over again. Yeah.
Okay.
Now, that paragraph 1 states, under conclusions, you say the following can be stated to a reasonable degree of scientific certainty. 1, as noted in my initial report, the only call logs that can be used to compare and synchronize the clocks between Ms. Reed's Lexus and Mr. O'Keefe's iPhone are those occurring between 5:21 a.m. and 5:30 a.m., which occur approximately 5 hours after the collision. You see that, sir?
I do, yes.
Now, what I'd like you to do is to go back in your report.
Same report?
Yes, sir, same report, May 8th. And I'd like you to turn to page 3.
Okay.
And if you could go to the 4th full paragraph that begins with 2 events near the time. And let me know, sir, when you're there, and if you could read that paragraph, pick your head up after you've had a fair opportunity
Okay.
to read it.
Okay.
Thank you. Now, you state 2 events near the time of the collision were recorded by the Lexus system as identified by Dr. Welcher and referenced by Mr. Dogra. The first event, labeled Techstream Event 1162-1, is associated with a 3-point turn on Cedar Crest Road. The second event, labeled Techstream Event 1162-2, is associated with a reverse maneuver on Fairview Road. These events will be referenced below for clock synchronization analysis. The timestamps associated with these 2 events are based on a combination of the Lexus infotainment power on event and Techstream time count. Did I read that correctly, sir?
Yes, you did.
So in the same paragraph, am I correct that you're discussing a couple of Techstream events, 1162-1 and 1162-2?
Yes,
And you are talking about that text stream event in the same paragraph as you're talking about an alleged collision, correct?
correct.
And in your paragraph of your conclusion that we were referencing, conclusion 1, is this paragraph part of the basis for that conclusion 1? Is this sort of like some predicate analysis for conclusion number 1?
No, no, it is not.
So it has no, your view, it has no relationship whatsoever to conclusion 1.
No, correct.
So let's go to your discussion of a collision and a text stream event. Let's go back to paragraph 3. You see, you mentioned the word collision in paragraph 3, correct?
I do not.
Where are
I'm
you?
sorry, I just had paragraph 3. I meant page 3, sir. Page 3.
Yes, page 3. Yes.
Page 3, that paragraph we were just looking at, paragraph 4.
Yes, sorry. Yes, I do say
You
collision.
see the word, use of the word collision.
Yes,
And again, that term is used in the same paragraph as you're identifying text stream events 1162.1 and 1162.2, correct?
correct.
Where did you get the basis to use the word collision at that part of your report?
That would have been from crash reports,
And whose crash reports?
the Massachusetts State Police.
So you used Massachusetts State Police reports to discuss allegations of a crash, collision.
Yes.
Do you state anywhere in your May 8th report that you used those reports at all? Do you list it in your references?
No, not in this report, no.
Oh,
And,
no.
and as a matter of fact, this is the first
Oh,
time, right this previous moment,
Oh, no.
that you are mentioning those reports at all, correct?
No, those were mentioned in my initial report.
Right, but I'm talking about your May 8th report.
Yes, sorry, yes.
Okay. Your statements, and I want to clarify this because this is the ultimate topic I want to go to. It is not your conclusion that every text stream data event means that there is a collision. Do you, sir?
No, that is not my conclusion.
So isn't it correct that you can have text stream events and they're not collisions?
Yes, you can.
And isn't it a fact that a text stream event, sometimes called a trigger event, is not like an airbag type deploying, correct? They're just, and we're going to get to this later, it's just something that happens with a Lexus vehicle that can cause the vehicle to register a text stream event, correct?
Correct.
And some people refer to text stream event as a trigger, correct?
Correct.
But there's many things that can happen with a vehicle that can cause a trigger, correct?
Correct.
We will come back to that. So you would agree, again, that a text stream trigger event does not mean that there was a collision, correct?
Correct.
A text stream data event doesn't mean that airbags were deployed, correct?
Correct.
A trigger data event doesn't mean that there was a vehicle impact, correct?
By itself, no.
By
Correct.
itself, it doesn't mean, correct?
Correct.
A text stream data event merely refers to Lexus's practice of capturing real-time data from applications databases and not devices and transporting that data for immediate processing and storage or for real-time analysis and analytics reporting, correct?
I don't think I understand your question.
I believe it.
If you could rephrase.
Sure. A text stream event merely refers to Lexus's practice of capturing real-time data from applications and databases. Is that correct?
I would not call it applications and databases, no.
What would you call it?
So from various sensors or other modules on the vehicle.
Okay, so
Sure.
it's Lexus's practice of capturing real-time data from various sensors and modules on the vehicle, right?
Correct.
Why don't we stop here, Mr. Lessie?
Yes.
Okay. Folks, we'll take our morning recess, so it's 20 minutes.
All rise, please.
Okay.
You arrogant ass. You've killed us.
Yep, that about covers it. Anyways, sorry, I lost my own train of thought. We were going to do a merch giveaway, right? That was the plan. We were going to do a merch giveaway. I thought was the plan. Yeah. Okay. What's the triggering phrase? Speaking of triggering phrases. All right. Okay. There it is. All right. Okay. Time for a merch giveaway. Time for a merch giveaway. All right. Here are the rules. Void where prohibited. I'm going to play a little video, and then I will give you the phrase to type into the chat. You type in the phrase in the chat, and you get an entry. One entry per person. You can select item or items up to $20 worth of value from the merch shop. If you win, send me an email with the item or items that you want, not to exceed $20 of value. I will then send you back a redemption code so that you can get those items. Shipping should be included. If it is not included for some reason, then just send me back the receipt proving that you paid shipping, and I will compensate you for the shipping cost. Those are the rules. Void where prohibited. All right, let's do this thing. Where's the button?
Sidebar giveaway.
Exciting. The phrase to type into chat is aperture science equals pure fiction, as I have typed it into chat. Just type the phrase aperture science equals pure fiction into chat. One entry per person, void where prohibited, up to $20 of merch item or items. If you win, send me an email with the item or items you want. I will send you back the redemption code, etc., and so forth. Let us talk about some of the items you can win if you win the merch giveaway. Or you can purchase as well. Callie the Bee Fish welcomes you to the Uncivil Law merch store, where we have, I think, some of the best merch in the game. If I am not, too biased, we have our brand new Unexpected Black Hole mug. You could win that if you like. We've got the Sidebar Drink Whiskey glass and Sidebar wine. Sidebar drink it mug. We got some shirts and stickers. Yuri's lunch bag, some spinny fan stuff, pocket state merch, pocket shaped mug, which comes in a variety of sizes. We got some don't be a dick stuff. We got some, we got some don't be a dick shirts. We got, what else do we have that's available? We've got some mouse pads that are cool. We got evidence cup stickers. We got the purple collection statement mug. We got, of course, the evidence solo cup for all your evidence collection needs. Very useful. And it's made out of glass, so presumably even better for your evidence collection needs. Got some uncivil law logo mugs. We got some pint glasses that you could get. We got Cali stickers. We got a cowboy hat, cup. We got uncivilian shirts. And of course, we got Cali wanted poster mug in a variety of colors. Wanted for shenanigans. Of course, Cali is very wanted for shenanigans in multiple jurisdictions. So those are some of the fun things that you could win. You could also get, of course, Learning from Misfortune's mug. That's fun. Some stickers, all that good stuff. All kinds of fun and exciting. From the Uncivil Law merch shop. Uncivil law, does the phrase only count during the timer? I don't know what you're talking about. The phrase starts as soon as I gave it in chat. The timer is just when I close it. No, the timer, the phrase is valid the moment I announce it in chat. I don't know. No. There's currently 117 of you who have entered this. One entry per person. You don't have to be a member. You only have to be a subscriber. Q squared. You don't have to be a member. You only have to be a subscriber. Entry is free. Because subscribing is free. So you do not have to be a member. You only have to be a subscriber because subscribing is free. This is no cost to you. There is no cost involved in this. The phrase, in case you need it again in chat, so that you type it correctly. The phrase you need is aperture science equals pure fiction. That phrase as displayed in chat. You can literally copy and paste it if you like. But that phrase is the phrase you need. Aperture science equals pure fiction. It has to be typed exactly the way it appears. So, again, because some of you people are not typing it correctly, it has to be typed exactly the way it appears. There's a reason I provide it in chat so that you can type it exactly the way it appears. If you don't type it exactly the way it appears, it doesn't count. Some of you people in chat have problems typing it exactly. Oh, yes. Tomorrow afternoon at 4 p.m. Eastern, or as soon as the court ends, we have an interview with Vinny Polentane of Court TV, the head reporter, head presenter of Court TV, will be joining us tomorrow, 4 p.m. Eastern time, for an interview. We will talk about Karen Reed, but we'll also talk more broadly about court coverage and how trials are being covered, the state of coverage, the state of true crime, all that kind of stuff. That's principally what we will talk about. We will talk a little bit about Karen Reed, but we will talk about Court TV, talk about his program and how he sees his program, how he sees Court TV in the zeitgeist, how he sees LawTube in the zeitgeist, how he sees true crime podcasts in the zeitgeist, how he sees the state of coverage relating to all these things. We'll get his perspective on the state of true crime and court-related media. It should be fun and exciting. Make sure to tune in for that tomorrow as well. Currently, there are 154 of you entered into the contest. Just to give you the phrase, Aperture Science equals pure fiction is the phrase. Must be typed exactly that way or it does not count. Let us go ahead and run a timer to end this wonderful little contest. The timer is ticking. When the timer ends, your ability to enter the contest ends. I don't need alerts from Ring Doorbell. Thank you very much. You have another 7 seconds to type the phrase. Must be typed exactly as it appears. All right. Entries are closed, and our winner is Slow Ride. Slow Ride is our winner. Thank you, Slow Ride. Again, just send me an email. The email is Kurt at Uncivil Law LLC. It's in the video description. It is in the About tab of my page. It's on my link tree. It's in many, many places. Just send me an email with the item or items that you want, not to exceed $20 of value, and I will send you back a redemption code. You don't need to even tell me where you live. I don't care. Just tell me the item or items that you want, and I will send you back the redemption code. And you can get those beautiful items. Congratulations, Slow Ride, on your victory. Very exciting. It is just that easy to win, people. It is just that easy to win the merch giveaway. Of course, if you did not win the merch giveaway, you can still purchase many, many beautiful items, as we went through before. There's a lot of wonderful, beautiful items available for your purchase. I think the quality is pretty good. People who have sent me emails after getting the items have pretty universally said that they think the quality is very good. So I hope that you will enjoy the items that are available. Also, for what it's worth, I have discounted them slightly from the suggested price to make them a little bit more affordable. So, and I still need to fix the price of that sidebar drink because it should be $95, not $96. Let me fix that because, get that 1 cent savings. There we go. Now, there you go. Now it's 95 cents. And make it 1 cent cheaper. Yeah, it's very exciting. There you go. Now it's $12.95. It was just that easy. Yeah, we got the sidebar drink, sidebar glass, unexpected black hole. Thank you, Jinx, by the way. She is our principal creator of merch. So thanks, Jinx, our mod, for creating some of this beautiful, beautiful merch. Jinx has an eye for this kind of thing that I do not have. I could not create this. I don't have the artist's eye to create it. So Jinx, thank you very much. She is our wonderful, wonderful creator for this merch. What is the email? Again, the email is in the video description of every video ever. It is on my About page. It is on my link tree. It is kurt@uncivillawllc.com. It is in the video description. It's on my channel about page. It's everywhere. It's also in my contact. There you go. Or is it Linktree? There you go. It's also on my Linktree. It's everywhere, man. It's everywhere. It's all the places. It's all the places, man. Good times. Oh, good morning, everyone. Thank you, by the way, for the 700 of you who are currently here and spending time with us. Very much appreciated. We should have another giveaway if we hit a certain concurrent viewership count. Yesterday it was 1,000. We should up it a little bit though to make it a little bit more challenging. So what should the concurrent viewer count be today to hit it? I don't know. 1,050 concurrent viewers? That sounds good. If we hit 1,050 concurrent viewers, we'll do another merch giveaway. That sounds fun. Daryl Brooks, 1,050 is the number I'm going with. So 1,050, it will be fine. How many more witnesses do I think the Commonwealth will call? I don't know, man. I would have thought with calling Aperture, they were getting close to wrapping up because that was the logical sequence. I assumed, of course, that Aperture would be better than it was when I was making that prediction, but it seemed like the logical place to end would have been with Aperture or the dog bite people or something. So, or shift it into your case in chief. But because I assumed that Aperture was going to be like really good. So, but but people are saying that Brennan is saying that they're going to rest pretty soon. They're going to rest by like Tuesday, by like Wednesday or something is like what people are saying. That seems plausible. That they're resting by Wednesday because what's left? So yeah, I think that seems pretty plausible. Genstar Capital just announced it would like to find a buyer for Aperture. Is that real or are you just memeing? If that's a meme, it's funny. If it's real, it's hard. I took it as literal. I think you meant it as a meme, though. I read it as serious. I guess that maybe that was wish fulfillment. I don't know. I thought Aperture was good. I never said I thought Aperture was good. I want to correct the record on this point. I never said I thought Aperture was good. That is slander. Take that back. Take that back. That is just flat out slander, Heidi. I never said I thought Aperture was good. I said I expected them to be good because that would be a reasonable assumption. I expected that, Brennan would be calling people who could go toe to toe. I never said they were good. That is out and out slander. You take that back. It's liable. It might be liable because it's written. Yeah, it's probably liable because it's in writing. Either way, it's defamation more broadly. All right, cool. I just got your email, but you didn't send me what you wanted in your email. See, you didn't follow the slow ride. You have to tell me what you want. It was in the instructions, man. Slow ride. You have to tell me what item or items you want. It was in the instructions. Try again, please. Please try again. Send me the item or items that you want, not to exceed $20 of value, and then I'll send you back a redemption code for those item or items. I need to know what items you want so I can send you the redemption code for the items, please. Thank you. Problems with instructions. I don't know, man. You have to tell me what you want. You have to tell me what you want so I can send you the code. Did I accept my apology? Apology accepted. Thank you. Thank you, Heidi. Thank you for the apology. Good times. Everything is wonderful over here in Uncivil Law. It's all good. I love you guys. I love you all. Let us read. Oh, make sure to read the super chats that came in because I haven't read them all, I don't think. Let's read the super chats that came in. Siri and the Cat gifted $6.99 Canadian. DL became an uncivilian. Greg S. gifted $5 Australian. Rose sent 5 memberships. Pin King 554 said, send it to the judge to give to the witness with no names attached, making it anonymous. Q squared, crowdsource licensing this from Joe Co from Core TV. Nice. Greg S. said, for $5 Australian. Brennan said he was caught by surprise when he received the new updated report despite being contacted before. Is that perjury? No, I mean, maybe not. It's something. Rebecca Zarowski for $4.99 said maybe Aperture has shut down the site pursuant to checking the education all CVs of everyone. Maybe that's what's going on. That's a generous interpretation, but sure. DL sent 5 gift memberships. Jennifer C for $2 said this is a massacre and painful to see. Q squared for $2 said defense. Let me systematically undo everything you said. Milov P for $2 said don't they have cell server provider data? That is part of the data they have, sure. Anita Carroll for $1.99 said, I would have not shown backup. Gordon Butler for $5 said, can you file for unemployment from the stand? Nice. Little Misfit became an uncivilian. Greg S. said, even Alessi is laughing at his answers. Yep. Q squared gave hashtag for justice for Trooper Paul. Facts. Skinny Boy's been a member for 6 months. And Maximum Bacon for $5 said sidebar giveaway video intro is great. Makes me laugh every time. Awesome. I'm glad you enjoy it. This has been an absolute trash fire. This has been just, and the thing that's really bad about it is you are arguably stuck with Trooper Paul, although probably not, because Trooper Paul was the guy who the Massachusetts State Police apparently decided to do the accident reconstruction. So in some sense, he was not selected for you. Now, you could have gotten someone else rather than Trooper Paul, but it makes you are slightly more stuck with Trooper Paul as opposed to this guy. This is a complete unforced error by the prosecution. In no sense was the prosecution stuck with Aperture. They could have simply not called them to the stand. Not calling them was entirely an option. And I continue to find it hard to believe they couldn't have found some expert somewhere who would have backed their play. There are a lot of expert witnesses out there. There are lots and lots of expert witnesses out there. And to find some PhD somewhere who would have backed your play, right? I mean, I find it amazing that they couldn't have found somebody out there who would have been able to honestly say, no, I agree with the Commonwealth. Honestly, forthrightly, and said, I believe it, with the PhDs and the credentials and everything. I find it truly amazing they couldn't have found somebody. And of all the many options that apparently or should have been available to them, this is the best they had? I mean, that's the most plausible conclusion, right? Of all the potential expert witnesses they could have called, presumably, they picked the expert witness they thought were the best, right? Because why would you do anything else? Why would you do anything other than call the expert witnesses who you think are the best for you and your case? Why would you do anything other than that as a lawyer? You wouldn't, right? Of course, you pick the expert witnesses that are the best. You have your choice. You have your choice of expert witnesses. We thank you for choosing us. So the most plausible conclusion, and I say that reservedly, because how is this the most plausible conclusion? But what else is there? The most plausible conclusion is that Brennan thought in his own mind that this witness was the best expert witness he could use. Right? I mean, presumably he had an array of potential people. And he's like, you know who I really want? You know who's my go-to? Shannon. Shannon's my go-to. That's my guy. Shannon Burgess, he's my guy. He's the one that is going to ride this home. That is sadly the most plausible conclusion of this. And then even on top of that, even assuming it is his best witness, he still could say, I'm not calling him anyway, which is an unforced error. So just because it's the best option doesn't mean it's an option you should pick. Just because it's the best available doesn't mean that you're forced to say yes. If this was the best available option to Brennan, which I find amazing to believe, but if it was, Brennan should still have said, no, I'm good. Whatever ambiguity in the timeline this was meant to solve, because this witness presumably was there. The purpose of this witness, the fundamental purpose of this witness, it seems, was to reconcile the timelines. That is the fundamental purpose of this timeline. The two timelines are out of sync. But you could have just let the unsynced nature of it sit, and you would have been better off. All right? You just get whatever witness. It doesn't really matter. It doesn't really matter what witness it is. You know, the defense calls a witness to say, isn't it true the timelines are out of sync? And you just ask a cross question, right? You just ask the cross question of whatever expert witness it is the defense is going to call. It doesn't really matter, right? The defense calls whatever expert witness, Aperture presumably, and asks the question, isn't it true these times are out of sync? And Aperture says yes. It's like, okay, the way I solve that problem as the Commonwealth is I simply ask the question on cross. Isn't it true that these devices are independent devices? Yes. And isn't it true that independent devices could have independent clocks? Yes. And isn't it therefore true that the reason that these timestamps are out of sync is because they're from independent devices, and therefore the fact they're out of sync is not unexpected? Yes. Great. Right? And so I just solve it on cross. And, the defense does, whatever rehabilitation they do, and it's whatever. And, but I have a completely plausible explanation. I have a completely plausible explanation. They're out of sync because they're independent devices, which, that is a completely plausible contention. That is a completely plausible thing to say, right? And so I just solve it in a cross question. I don't need to bring an expert witness on to resolve it. I mean, I could, that would be nice, but if my choice is let the ambiguity sit versus call this guy, if those are my choices, I'm pretty sure I'm going with let the ambiguity sit. Just let it be a little point of ambiguity. It's a little, not every case is perfect. They're not all wonderful. And and not every case is perfect. And, it's not beyond, if that's the only flaw, I can sell beyond a reasonable doubt, no problem. Right? Beyond a reasonable doubt isn't beyond all doubt. The fact that the time between the phone and the Lexus, that fact alone is not reasonable doubt. It is simply not. They're two independent devices. There's no particular expectation they would be in sync. The fact they're out of sync is completely understandable. That is like, I can sell beyond a reasonable doubt with that ambiguity, no problem, every day of the week and twice on Sunday. Now, I have other problems, many other problems with beyond a reasonable doubt. But among my other problems, I got 99 problems, but this ain't one. Hit me. 99 problems. I feel bad for you, son. 99 problems, but the time sync ain't one. Hit me. So I can live with that problem all day long, every day of the week. No problem. But instead, I decided to call this witness in what must be one of the most unforced errors of all time. It's pretty bad. Trooper Paul was arguably an unforced error too. I didn't have to call Trooper Paul, but at least it's marginally more understandable. Marginally more understandable an error than this. It's still an unforced error, but a marginally more understandable one. This is just trash fire. There is no way to make calling this guy work. It is totally an unforced error. It makes me sad inside. It hurts the lawyer parts inside my soul.
Court is back in session. You may be seated.
Court is back in session. Okay.
All right, Mr. Lessie, whenever you're ready.
Thank you, Your Honor.
I know I was watching Ian Runkle of the Bailey, my friend and yours. Holla, shout out Ian. And he said that he was trying to get funding to teach a course at law school. And one of the courses that he was thinking of teaching was basically trial practice through famous trials, right? Using famous trials, teach trial practice. And he said if he ever gets approval for that course, that this cross-examination will definitely be part of the curriculum. Yeah, that's 100%. That sounds right. Yep.
Mr. Burgess? I'm going to pick up, sir, where we left off. A text stream trigger event does not automatically mean there was a collision, correct?
Correct.
A text stream data event doesn't, without more, mean an airbag deployed, correct?
Correct.
A trigger data event doesn't mean, without more, that there was a vehicle impact, correct?
Correct.
A text stream data event merely refers to Lexus's practice of capturing real-time data from applications in databases, correct?
Sensors and other modules.
That's right.
Available.
You had said that earlier, sir. Sensors and modules. You reviewed the raw text stream trigger events on Miss Reed's vehicle, correct?
No, I did not.
Oh, you did not?
No.
Do you understand whether, do you have an understanding whether Mr. Dogra reviewed those events in his March 5, 2025 report?
I do not.
So you did not review the raw data for text stream trigger events on Ms. Reed's vehicle, and you did not therefore perform any analysis of that data as you sit here today, correct?
Correct. Outside of what Dr. Welcher provided.
Are you aware that there were approximately 30 text stream trigger events in an 8-month period on Miss Reed's vehicle?
No, I'm not.
Assume the data shows that in the mere 8-month period that Miss Reed owned her vehicle, the Lexus in question, there were 30 text stream trigger events. Assume that. You would not conclude that there were 30 collisions in that 8-month period, would you?
No, I would not.
Would you agree, sir, that there were actually 2 triggers on January 29th?
Yes.
And the first trigger that you referred to of 1162-1, that was not a collision, was it, sir?
Without reviewing the data, I don't know.
Well, as you sit here today, you have no basis to state that the 1162-1 trigger was a collision, do you?
No, I do not.
And in fact, didn't you refer to that as a 3-point turn?
I did, yes.
And you didn't mention in your direct testimony when you talked about the 3-point turn anything about a collision, did you?
No, I did not.
And as you sit here today, there's no fact or data that you have to conclude that there was any supposed collision associated with that 1162-1 3-point turn trigger event, correct?
Correct.
A trigger event can occur on a Lexus vehicle by a whole host of possibilities, correct?
Correct.
You could maybe slam on the brakes and cause a trigger event.
That is one possibility.
You could have just unusual driving. You could be going at a speed or doing something else that has nothing at all to do with a collision, correct?
That is correct.
And in fact, there are almost countless events that can occur that can cause a trigger event in a Lexus vehicle.
So I don't know the exact count of what type of triggers there are, but
That's
yes,
not
there are.
important to
There are a
know.
number.
That's
yes.
not, that's not important to know. It's not important to know how many trigger events there are. That's not important information.
So back to the 1162-1 3-point turn trigger event. On your direct examination, you just referred to events surrounding that as a 3-point turn, correct?
Correct.
And yet that 3-point turn registered as a trigger event, right?
Correct.
Are Lexus SUVs trigger happy?
I do not know, sir.
As you sit here today,
That's good.
none of the information in that black box that you referred to on your direct testimony indicates that there was a collision on January 29th, does it?
Not by itself. no.
Not by itself.
Correct.
And it doesn't occur, that none of the information in that black box indicates that there was a collision on any day without more, correct?
Correct.
I'd like to now turn to a different topic, sir. In your direct examination, you referenced a Ms. Maggie Gaffney. Do you recall that?
Yes, I do.
And wasn't part of your reference to her a criticism of her for some of the work that she did with respect to the Lexus SUV?
Yes, it was.
And for instance, you criticized her for failing to extract the micro SD card from the circuit board during the initial chip-off, right?
So, sure. So I did criticize for not identifying the micro SD card and subsequently not downloading it. Yes.
And on direct, you even tried to lay at her footsteps, if you will, your bits, bytes misinterpretation on her by claiming that you assumed, quote, a competent expert, close quote, would not have overlooked a relevant chip.
Dude,
so you became
you don't have
confused
permission to talk about
how
what a
there could be
competent
data
expert
missing.
would or
Is
would
that a
not
fair
do, dude.
characterization?
Come on.
No, it is not.
Did you at all try to use as a justification for your misunderstanding of bits and bytes that it was her work?
Her word? you
Her
say?
work.
Her work.
Yes, her work.
So it was the, overlooking of the SD card. Yes.
Right. So you did try to lay at her footsteps part of the reason why you misinterpreted the bits and bytes that we discussed yesterday. Is that correct?
No, that is not correct.
Okay. So you would agree then that the bits and bytes misinterpretation that you and I discussed yesterday had nothing to do with the work of Ms. Gaffney, correct?
So in part, but that was my mistake. Yes.
All right. I'm trying to understand which is it. Is it Ms. Gaffney's work had some part in your misinterpretation of bits and bytes, or her work had no part in your misinterpretation of bits and bytes?
Some part.
So you do attempt to lay some blame on Ms. Gaffney for your misinterpretation of bits and bytes, correct?
No, I'm not trying to blame anyone.
Okay. In your January 30, 2025 report, are you consistent with your criticism of Ms. Gaffney?
As I recall, yeah, I believe so. Yes.
In fact, you yourself provided the explanation for why the micro SD card was not extracted during the original chip-off, didn't you?
Yes, that it was overlooked.
Right.
Yes.
So if you could please turn to page 5 of your January 30, 2025 report.
Okay.
I tell you what, if I ever feel bad about myself in any way,
And sir, when you
I ever
get
feel
there,
like a poser
if you
or
could
incompetent,
let me know,
if I ever,
and
if
I
I
will
ever
then
have,
proceed
you
with
know,
questions.
Okay.
if I ever have imposter syndrome issues,
So
This guy's gonna make
you
me feel better.
do attribute
Forever.
to Ms. Gaffney in your report some responsibility for this micro SD card not being extracted during the original chip-off. Is that correct?
Yes.
So let's go to page 5 of your report, sir.
this guy is
And-
just walking validation that everything I'm doing
Bear
okay.
with me, I want to get you the exact location.
I may not be the greatest, but I'm better than this guy.
I don't have it exactly, but I want to quote it. Your Honor, may I have a moment to get the exact quote?
Sure.
Thank you.
Either that or just watching CLEs. Every lawyer CLE makes me convinced I'm the best legal educator that's ever lived. Because they're all so dry. They're so bad. So dry. I'm the greatest legal presenter of all time. Yeah.
Thank you for that, Your Honor. I now have it. Mr. Burgess, if you could turn to page 5, as I was referencing, and go to the third full paragraph. If you could look about 2/3 of the way down the far right, you see the word where it starts with at. It's the paragraph beginning when examining vehicle
Yes,
systems.
I
You see
do.
that,
Yes,
sir?
I see it.
And do you see the at that is at the very far right of that paragraph?
Yes.
So it says, at the time of the incident, Burla, and Burla is what? Can you read?
Burla is a company that offers and develops forensic hardware and software for vehicle modules.
Right. So at the time of the incident, Burla did not offer support for the infotainment and telematics modules removed from the Lexus, but have since released updated software indicating similar modules are supported via in-vehicle acquisition. According to Burla, currently, there are 2 known and documented modules within the vehicle that have the capability to store data. The infotainment module removed from Ms. Reed's Lexus is consistent with the MMU documented by Burla and has been identified as containing an internal micro SD card not acquired during the initial chip-off acquisition by Ms. Gaffney. Did I read that correctly?
Yes, you did.
So as you stated, Burla is the organization that you described, which for the purpose you did, I'm not going to repeat it on direct examination. If I could sort of put in layman's terms and see, you tell me if this is correct. Burla produces hardware and software to make it easier for non-technical people, as you put it, to extract data from a vehicle, correct?
Non-technical people such as...
You describe
such
in your
as-
January 30, 2025
Yeah.
report that at the time of the initial chip-off, Burla did not provide support for the information contained on the micro SD card, correct?
No, so I think you're misreading that last sentence, and I can clarify.
Can you read the last sentence, sir?
I can. So the infotainment module removed from Ms. Reed's Lexus is consistent with the MMU documented by Burla and has been identified as containing an internal micro SD card not acquired during the initial chip-off acquisition by Ms. Gaffney.
So my question is, did or did not Burla, at the time of the initial chip-off by Ms. Gaffney, provide the technical support to address the information contained on the micro SD card?
No, Burla did not and does not.
Good. That I wanted to.
That was my identifier of the micro SD card. Correct.
So it was not until after the initial chip-off that Ms. Gaffney participated in.
Totally unironically, ChatGPT would be more reliable by far. By far. Lord have mercy.
That Burla updated their software to be able to identify the types of data, for Burla software to be able to identify the types of data contained within the micro SD card on the Lexus circuit board. Is that correct?
No, that's incorrect.
So Burla didn't do anything new after the initial chip-off with its software?
Sure. So Burla released new software after the initial chip-off that addresses being able to download software via the infotainment module while it's in the vehicle. So that involves plugging a USB in to the vehicle and downloading data. That does not address the micro SD card on the circuit board itself.
And Ms. Gaffney did not have, at the time of the initial chip-off, that updated Burla software, correct?
Correct.
Okay, thank you, sir. Appreciate your questioning. Thank you for answering my questions. That's all I have at this time, Your Honor,
Really?
but I have a bit to pack up, so Mr. Brennan can have a clear podium.
Go right ahead.
Thank you.
Cross is over. Cross is over. All right, Brendan. This is one of the most challenging positions I think I've seen a lawyer in quite some time. This is rough. This is rough. All right, Brendan, you have to somehow rehabilitate this guy, your own expert who you called to the stand and paid to be here. You have to somehow fix this. Go.
Thank you for that opportunity, Your Honor.
Brendan, I believe in you. You can do it. It's no problem. Brandon, 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 Brandon.
Good afternoon.
Good afternoon.
Do you know what a sequestration order is?
Yes, I do.
And what is it?
So it would be an order to not view any testimony of a trial, is my general understanding.
Does that mean that you can't watch any of it on television?
Correct.
Do you understand whether or not you can speak to attorneys about testimony? Is that precluded as well?
I'm not aware either way.
Has anybody ever spoken to you about any testimony about that occurred in this trial before you testified?
No, they have not.
Have I ever discussed, intimated, or suggested any information whatsoever to you about arguments, testimony, or anything about this case as it's ongoing?
No, you have not.
Do you follow the rules, sir?
Yes, I do.
Have you followed them in this case?
Yes, I have.
When you gave your opinions and you've testified, do you have any information or knowledge about this trial as it actually occurred until the point when you testified?
No, I do not.
You were asked some questions about your CV. A CV is a resume?
Yes, it is.
Okay. And you were asked about a LinkedIn account.
Yes, I was.
Is your LinkedIn account different than your CV?
Yes, it is.
And in this case, when did you learn that your LinkedIn account was wrong or had not been updated? When was the first time you learned that?
That was yesterday.
When you started your LinkedIn account, do you remember when it was you set it up?
I do not. It would have been maybe 10 years ago or more.
Do you routinely update your LinkedIn account?
No, I do not.
When you set up your LinkedIn account, the section where it asks for education, whether graduated or ongoing, do you remember filling out that section?
I don't particularly remember filling it out, but obviously I did at some point.
When you were asked about Aperture's website, how many experts are associated with Aperture?
I could give you a rough number between 80 and 100.
How many offices?
15 or so.
Are you involved in the website design or content?
No, I'm not.
Do you know if Aperture gets the information from their website directly from LinkedIn?
I don't know where they get all of their information from.
Did you ever weigh in or develop your information that was on Aperture's website?
No, not on the website.
You do provide CVs before you come to court, don't you?
Yes, I do.
And in this case, you were asked by the defense, when you provide your CV, do you understand that it's going to be reviewed by whoever requests it, the Commonwealth or the defense?
Yes, I do.
And that it will be shared with both sides in the court?
Yes.
In fact, The first time you provided a CV in this case, was it October 11, 2014?
Objection, Your Honor.
So the leading nature sustained.
Do you remember the first time you provided a CV in this case?
It would have been around October
Of what year?
of 2024, sorry.
And when you provided that, was it as an exhibit to something?
Yes, if I recall, it was as an exhibit to the initial protocol that I sent out.
And when you submitted that CV, did you appreciate whether or not it would be part of a court filing in public?
Yes, I did.
If I could have exhibit 183, please. $183. You could enlarge the top section. Right there is good. And sir, when you provided this CV to be filed with the court and made public, did you indicate that you had obtained a bachelor degree?
No, I did not.
Why did you put currently pursuing?
Because I am currently pursuing a bachelor's degree.
And did you understand your CV was received by the defense and they knew this?
Yes, I do understand that.
Subsequently, you were asked to provide an updated CV in April 2025?
Yes, I was.
Did you do that?
I did.
And can we have exhibit 184? Did you further appreciate this would be provided to both the court and the defense?
Yes, I did.
Did you represent to the defense that your education included earning a bachelor degree?
No, I did not.
You've testified in, you can take that down, please. You've testified in many other cases
I have, yes.
in courts around the country.
Yes, I have.
And when you've testified in other courts around the country, do you know whether there are transcripts of your actual testimony?
Yes, I believe there are.
Have you ever represented in any court that you achieved your bachelor's degree?
No, I have not.
Have you ever inflated your qualifications in a court?
No, I have not.
When I asked you about some of your background, you told us that you had certificates in Celebrite and Axiom. I didn't go through all of the qualifications and all of the accomplishments you had, did I?
No, you did not.
Do you have professional certifications, GIAC, Advanced Smartphone Forensic Analysis?
Yes, I do.
Do you have professional certification from CCME, Celebrite Certified Mobile Examiner?
Objection, Your Honor.
Sustained.
Do you have professional certifications as a Magnet Certified Forensic Examiner?
Objection, Your Honor.
Sustained for the same reason.
I'm sorry?
Sustained for the same reason.
Do you have a number of certificates that I did not ask you about?
Yes, you did. I
Can you
did,
share
yes.
some of those with us?
Sure. So one of those is going to be GIAC, Advanced Smartphone Forensics. So that's going to be Global Information Assurance certification. And that is basically a 40-hour class or 48-hour class with a test at the end to get that certification. There's also a Celebrite Certified Mobile Examiner certification. That is specifically to, kind of demonstrate your knowledge of the Celebrite software, as well as Magnet Forensics certifications, again, for their software specifically.
Any certifications regarding computer hacking?
What was that last part? Sorry.
Any certifications regarding computer hacking?
No, not currently.
Okay. Did you also take any classes regarding crash data or BOSH?
Yes, I have.
What do you have for certificates in that arena?
So those certifications would be Crash Data Retrieval Technician and Crash Data Retrieval Analyst. So those courses would be around acquiring and analyzing crash data from airbag control modules.
You mentioned that you had over 700 hours
Yes, I do.
of classes and certification.
Yes, that's of classes and classes and seminars or conferences, specifically in digital forensics or vehicle forensics.
Do you need a bachelor's degree to be competent and achieve in this area?
No, I do not.
Is a bachelor's degree a prerequisite of success in a particular field?
No, it is not.
You ever hear of Bill Gates,
Yes.
Stephen Jobs?
Oh no! Oh no! Oh no! 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 Oh no! 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 Uh, uh, okay. All right. All right. All right. Hold on. All right. Hold on. Uh, okay. Uh, all right. All right. Okay.
Yes.
Oprah Winfrey?
Sustained.
You had become engaged in this case in October 2024?
Correct.
And when you first became engaged, you had a chance to look at photographs and some data?
Yes, I did.
At that point, you hadn't had a chance, did you have, had you had a chance to actually inspect any of the physical property?
No, I had not.
Did you have an understanding that somebody else did?
Yes, I did.
Who?
Miss Gaffney and a number of other people with the MSP.
Attended some type of procedure?
Correct.
And do you know who led the actual procedure?
As far as I'm aware, it would have been Miss Gaffney.
The defense expert?
Correct.
You filed a protocol. What was the purpose in October when you first got involved of filing a protocol?
Sure. So the first purpose of the protocol was just to address the fact that we were missing data that we expected and address a potential solution to gather more data.
Without having looked at the physical property, the actual boards, how did you conclude simply on data and photographs that there was missing data?
Sure. So that would be reviewing the initial data that was provided and not seeing user data like I would expect. And that's because there's a number of different chips that are on a circuit board for an infotainment or a telematics or any other module. And there's a number of different data-bearing chips. The purpose of those chips will vary. Some chips' main purpose is to store user data. Some chips' main purpose is to store software or firmware. So if you're gathering, acquiring data from chips that only have software and firmware, then you would not expect or you would not see user data within those chips.
When you made that analysis and concluded that there was missing data, had there been any report provided by Ms. Gaffney suggesting there was missing data?
No, there was not.
Had there been any analysis or opinion alerting that there was missing data?
No, there was not.
Was there anything to indicate that the person who did this test missed data at that point?
No, not at that point.
When you decided to write a protocol so you could actually look at the boards and do an analysis, did you put that protocol in writing?
Yes, I did.
And do you remember if that was around October 10, 2024?
That sounds familiar. Yes.
Now, when you were cross-examined, the attorney asked you if you knew what the word mendacity meant. Do you remember that?
Oh no.
Yes, I do.
And you didn't know. Do you now know that means to lie or be untruthful?
Sustained.
He didn't ask you a question. He just asked you if you knew what the word was. Do you remember that?
Yes, I do.
Okay. Do you remember he also...
Why would you ask that question in rebuttal? Why would you ask him if he knows it means to lie? Why would you ask that as a redirect question? You want to put in the mind of the jury that he's a liar? Why would you object to that as the defense? I'm not quite sure.
On cross-examination suggested that when you had your mistake about megabytes, megabits, it was the defense expert that alerted you to that mistake. Do you remember that suggestion by the defense?
Yes, I do.
Did they ever show you the documents so you could see the chronology?
No, they did not.
Okay. you wrote a report on October 10, 2024. Did you then write another report, a supplemental protocol?
Yes, so I did write that initial protocol and then a supplemental protocol.
Was that on October 17, 2024?
That sounds about right.
When you wrote that a week later, at that point, had you realized your mistake?
Objection, Your Honor.
Sustained.
Why did you?
Can we approach, please?
Okay.
I don't know why Brandon would ask that question, and I don't.
Do you remember
also,
the date?
I also
that you-
don't know why the defense objected. It seems like a mistake to me, both ways.
When
We need a new poll, mods. We need a new poll at least
when
every
you
hour.
realized your error, what did you do?
So I intended to correct it with a supplemental protocol.
When you corrected it with the supplemental protocol, do you remember what date that was?
Not specifically, I do not.
Okay. If I showed you your report, would that help your memory?
Yes, it would.
May I approach?
Yes.
Please don't read this, just look at it, and if it refreshes your memory, let me know, and then I'll ask you a question.
Yes, it does.
When did you correct your error with the supplemental protocol?
That was on October 17th, 2024.
Okay. And do you remember the date that you first received any information from Mr. DeSorga?
No, I do not
Do you
specifically.
remember the date when Mr. DeSorga's information was first filed?
No, I do not.
And do you know if it was, whether it was after your October 17th supplementary report?
Not specifically, but I believe it was after.
Okay. And so when it was suggested that you had to be schooled or advised by Mr. DeSorga, was that accurate?
Objection, Your Honor.
Word it differently. Word it differently.
The claim that was made that you weren't aware until someone advised you of your error, was that true?
No, that was untrue.
When you realized there was an error and put it in a report, were you ever dissuaded from publicly alerting all the parties of your mistake?
No.
Do you leave stuff in or out of a report if you find it helpful or hurtful to one side?
No, I do not.
Have you, in this effort that you've made in this case, have you always been encouraged to provide all information, regardless of what it is?
Objection, Your Honor.
I'm going to allow that.
Yes, I have.
And who's encouraged you to always provide all information, regardless of what it
No,
says?
no one. So my job is to assist the jury. So the jury, assisting the jury means presenting all the information.
Have you ever been discouraged by me?
No, I have not.
When you looked at the photographs and you looked at the boards without actually touching them, how long did it take you to figure out that there was some other vehicle for data?
Sure. So it took a few times to look at the photographs before I identified the micro SD card slot.
You were asked whether it's important to be accurate and reliable. Is it in this field?
Yes, it is.
And if data is not found on the chips, is it a standard practice to look elsewhere?
Yes, that would be a standard practice.
Was that done in this case before you became involved?
No, it was not.
Who was the first person to identify where the missing information was?
Myself.
What happens if you miss information because you don't see it?
So if you miss information, that's information that won't help in the analysis.
In this case, the information on the SD card that you found, how important was that to this entire analysis?
It was important to timestamp certain events.
Without that information in the SD card, would you have been able to so accurately timestamp certain events?
No, not so accurately.
Before you were involved, was that information, that very important information for timestamps, was that available for either side?
No, it was not.
Is it now?
It is.
You were asked about Burla. When Burla did not have updated software to simply plug into a car and download the information, what process would have to be used?
Sure. So best practice for vehicle forensics is if the module or a vehicle is not supported by a forensic tool, would be to remove that module, or let me start over, manually document the screens on that infotainment module if it's available and it can be powered up. But then also going through disassembling the module, identifying any type of chips or SD cards that may hold data, and acquiring that data.
Is that called a chip-off process?
It is called a chip-off process.
Does it describe the process well, chip-off?
Yes, it does.
Since Ms. Gaffney did the original analysis and did that chip-off, has the software updated?
Yes.
And is that the Burla software?
No, I'm sorry. So she has not done a updated analysis with the Burla software.
But has the Burla software itself updated?
So the Burla software itself has updated, but it is limited to, again, plugging in a USB into the infotainment module while it's in the car running.
Does the updates in Burla software have anything to do with the SD card?
No, it does not.
Why not?
Because, again, they're going a different route to acquire data, and they are acquiring a limited amount of data through what's called diagnostic logs. So if you think of diagnostic logs, your radio unit is keeping logs of any time things happen on the radio for manufacturer purposes. So Burla is taking those logs and they can interpret some of those logs. They are not, acquiring all the data that is on the SD card itself.
You have drafted a number of reports in this case.
I have, yes.
Regarding the chip-off process, did Ms. Gaffney ever write a report?
No, not that I'm aware of.
When you wrote reports in this case, do you expect for them to be shared?
Yes, I do.
When other experts, like, for example, Mr. DeSorga writes a report, do you expect to have a copy and review it?
Yes.
Sustained.
What is the standard practice when there are reports from different experts regarding the same subject matter?
Objection, Your Honor.
Sustained.
Is there a standard practice
Sure.
regarding reviewing reports from similar experts in similar subject matter?
Sure. So anytime a report is written by an expert, that report would be provided and shared with opposing experts.
Reports, do they always come at the same time in a case?
No, they do not.
When you wrote your reports, how would you provide them so they could be disseminated?
Sure. So that I would typically provide them to the client or the attorney that hired me, and then that would be disseminated from there.
Did you have an opportunity to receive Mr. DeSorga's March 5th, 2025 PowerPoint?
Yes, I did.
Were you provided that by me, the Commonwealth?
Yes, I was.
And were you asked or given any direction on what you could or should do?
No, I was not.
Were you ever asked to reach any particular result?
No, I was not.
Were you ever asked to avoid anything?
No, I was not.
What did you see your role as when you receive a report from another expert like Mr. DeSorga?
Sure. So when I receive a report, I would typically review it and then make a decision if it's better to address any issues in that report through testimony or address those with a supplemental report.
And in that analysis, do you follow your own discretion or do you follow directions of the client?
No, I would follow my own discretion.
Did you ever receive any direction on what you should and shouldn't do regarding considering Mr. DeSorga's report?
No, I did not.
When you looked at Mr. DeSorga's report, did you have concerns about his report?
I did, yes.
I want to talk about his report in detail. Before we get there, share with us what your general concerns were about Mr. DeSorga's report when you reviewed the whole report.
Sure. So what Mr. DeSorga does is take a couple different adjustment methods to attempt to adjust the clock from the Lexus with the iPhone. But what he does is takes a lot of methods or data points that are not applicable to the time that we're interested in.
What do you mean? Can you explain with a little more specificity what he does?
Sure. So if you think about it, your clock is constantly, changing as far as it syncs up with other GPS satellites or network time servers, and it's updating constantly. So a clock variance between two devices may be different at, say, 12 o'clock in the day versus 1 o'clock in the day.
Oh, bullshit.
So best practice is to choose an event that is nearest to your time in question, so you have the most appropriate adjustment for that clock variance.
Bullshit.
DeSorga's analysis, did he choose the event most closely tied to the backing up event?
Objection, Your Honor.
Sustained.
The backing up event, are you familiar with that time frame?
Yes, I am.
Okay. Was Mr. Sorga's analysis based on information most closely related to that event?
Objection, Your Honor.
Sustained.
What information did Mr. DeSorga choose to use for that analysis relative to the backing up event?
Sure. So he chose a couple.
I can't let it pass. We have to have a discussion about this because I know too many things. This is impossible. I can't let it pass. This idea that your clock is constantly updating and therefore that explains the changes in the variance. If I were trying to measure to, like, I don't know, the microsecond, then maybe, I guess, that would partially explain it, but not seconds. No. I mean, both a phone and a car are using a quartz clock, independently. Quartz is typically accurate to 15 seconds a month. So if it's not synchronized externally, and that's cheap quartz, the quartz that are used in the cell phones and vehicles might even be a little bit better than that. That's because, like, the really cheap quartz is 15 seconds a month. It gets better from there. The idea that because the phone or the car is syncing to a known time signal and therefore that's changing like seconds a day. Bullshit. Unbelievable. Also, let's just have a quick stroke check because I need to check for that. Apple pie. Okay, I don't think I'm having a stroke, but I might be having a brain bleed, so. Okay.
Things that's going to be call logs that happened on both devices or that was recorded on both devices, as well as a GPS data point, which was incorrectly identified as being near that or encompassing that 3-point turn. So what we did is did a more thorough analysis of that 3-point turn event when it occurred within the iPhone data, and then compared that and adjusted with the Lexus.
Explain to us your concern about using call logs.
Sure. So there's a number of call logs that you saw earlier that were recorded by the phone and the Lexus. The one thing you'll notice, and it's hard to kind of go back to it without the graph, but the calls that happened between 1 and 5 o'clock that morning actually happened when the car was powered off. We know that based on the power on and power off events. So those timestamps that are recorded with that 2-second and 1-second offset is actually from Mrs. Reed's iPhone as she gets back in the vehicle and her phone connects up and syncs back up. So the 8-second and the 16 or 21-second offset are the only offsets that we have to compare to calls.
Was that a concern?
It was a concern.
Why?
Because if you're using the 1 and 2-second offsets, that could be misleading because it's not actually comparing the Lexus clock with the iPhone clock from Mr. O'Keefe.
What's it doing?
It's comparing the Mr. O'Keefe's iPhone clock with Mrs. Reed's iPhone clock.
What other concerns?
Sure. So the other concern was a GPS point known as GPS 154, which, if you remember yesterday, we talked about a little bit. So that was misidentified as being the end or towards the end of that 3-point turn. But when we look closer at all the location data, we can see that that actually occurs between 12:23:59 and I believe it was 12:24:07.
Let me ask you some questions about what compelled you to look at the 3-point turn and synchronize the clocks. Were you aware of Mr. Whiffin's report where he offered that the last user interaction on Mr. Whiffin's phone was 12:32:09?
Objection, Your Honor.
No. You were asked, did you consider Mr. Whiffin's report where there was a last user interaction of 12:32:09 by the user?
Objection, Your Honor.
I'm going to allow that.
You were asked if you considered that. Did you know that information?
I did know that information was available and existed, but I did not use that in my analysis for the clock synchronization.
Did that have any part of your motivation to do the clock synchronization?
No, it did not.
Were you attempting to match the synchronization with any of this other information that exists in data?
No, I was not.
You were also asked if you were aware of Mr. O'Keefe's phone that at 12:32:16 it ended its movement.
Yes, I was aware of that, yes.
Did that in any way affect your interest or your decision to synchronize the clocks?
No, it did not. So my primary focus and to adjust the clocks was because I thought the PowerPoint slides by Mr. Dogra were misleading.
When you were shown Exhibit 190, can we have 190, please? You were shown this chart. Was this the entirety of Mr. Dogra's report?
No, it was not.
Was there text information offered by Mr. Dogra to give his position or explanation of this?
Yes, there was.
Is that included in this exhibit?
No, it's not.
Did you get a chance to read Mr. Dogra's report, including the actual text explaining his analysis and process leading to this chart?
Yes, I was.
Did you look at Mr. Dogra's entire report?
Yes, I did.
I move to introduce Mr. Dogra's report.
No objection, Your Honor.
Okay, so this was triple D for identification. That would be the next exhibit.
Exhibit 191.
You said as a result of Mr. Dogra's report, you were concerned, so that compelled you to do your analysis that resulted in your May 8th report?
Correct.
I want you to take us through Mr. Dogra's report and explain to the jury what concerned you about his analysis.
Sure.
With the court's permission, I'd like to put this page 1 of this report. Is this the front cover of Mr. Dogra's March 5th, 2025 report?
Yes, it is.
Turn to page 2, please. Where do you recognize this slide or photograph coming from?
Sure. So this slide is coming from Dr. Welcher's overall PowerPoint slides.
When you first saw this slide, where did you first see, what source did you first see this through?
Through Mr. Dogra's PowerPoint.
Well, Dr. Welcher works at Aperture, doesn't he?
He does, yes.
Did you know he was working on this case?
Yes, I did.
Was he providing you his PowerPoint or slides before this point?
No, he was not.
When you first saw this slide, did you see information about the timing of the text stream event, which was the backing maneuver?
Yes, I did.
And what time did that show?
Can we blow it up just so I don't get the time
Please.
wrong?
It's too late for that. Just so I don't get the time wrong, it is way too late for that. Way too late.
Up, please. I'm sorry. Up. Here we go. Thank you, Ms. Gilman.
Sure. So that's got the text stream event ending at 12:31:43.
These text stream events that are captured, do you know how long of the event is captured? How many seconds?
Yes. So approximately 5 seconds before the trigger threshold is met and 5 seconds after.
When this information that you reviewed in Mr. DeSorga's report, do you know what clock is used to identify the 12:31:38 to 12:31:43?
Yes, I do.
And what clock is that?
So that's a combination of the Lexus clock that's coming from the infotainment center, as well as the running timer that we discussed yesterday, that's coming from the airbag module itself.
Is the source of that time important?
Yes, it is.
If you compare time from a different clock with time from a different clock and don't synchronize the two, does that lead you to an accurate result?
No, it does not.
When you were answering questions, you repeatedly were saying, according to the Lexus clock. Why were you offering that qualification repeatedly? One moment, please.
Sure.
Why were you offering that qualification repeatedly?
Sure. So to make sure that the jury understood that that timestamp was coming from the Lexus itself and was not an adjusted timestamp to Mr. O'Keefe's iPhone.
Could you scroll down, please, Ms. Gilman? Up a little bit, please. Thank you. The 3209, what did you understand that information to be?
Sure. So that is information I understood to be the last device lock recorded on Mr. O'Keefe's iPhone.
And what clock did you understand that time came from?
That would come from Mr. O'Keefe's iPhone clock.
If you reconciled his iPhone clock information, or if you compared it without reconciling to the Lexus information, what's the danger in doing that?
Objection, Your Honor.
Sustained.
Is there any danger in doing that?
Objection, Your Honor.
I'm going to allow that.
Is there any danger in comparing two times if you don't consider the clocks that they came from?
Yes, there is. So you could essentially be, inaccurate time for when that event actually occurred.
If you could just scroll down to the bottom so we could see the rest of that. You mentioned the word variance yesterday during your direct examination. I'm going to ask you to look at that box that has the green around it. Is that an example of variance?
Yes, that is an example of variance between, no. So I take that back. That is not an example of variance itself. That is an example of comparing the end of the text stream event to the device lock event.
Is that attempting to compare two different devices?
So that's attempting to, that's not attempting to compare anything. It's just stating that the time between the device event lock and the end of the text stream event, unadjusted, is approximately 26 seconds.
Is that accounting for synchronization or not?
It's not attempting to compare anything. It's just saying the time between
Accounting for synchronization.
That is not accounting, that is not with synchronization.
Could we turn to the next page, please? Did you review the next page of Mr. DeSorga's report?
Yes, I did.
And did it lead you to any concerns?
This page specifically, yes and no. So this page again is just showing the time difference between the end of the text stream event and Mr. O'Keefe's last device lock event.
Is this another way of showing the information that was in that green box?
It is. It's another way of showing the information in that green box, but it is not a clock variance or an adjustment.
Could you turn the page, please? When you read this page, is this a opinion or conclusion?
No, it does not.
What is it?
So this is just pointing out that when the 26-second window, which they'll
Okay. The question is, does this slide represent an opinion or conclusion? And he says no. Okay.
refer as John's interaction window. When that number is positive, then the phone interaction occurs after the end of the text stream event. When that number is negative, the phone interaction occurs before the end of the text stream event ends.
Did you have any issue with that slide?
No, not that slide in particular.
Okay, and if we turn the next page. Did you have an opportunity to review the next page?
Yes, I did.
And were you in agreement with this page?
I was in agreement with this page, yes.
And what does this tell us?
So this page points out that two clocks are not always in sync. So again, to synchronize those clocks, you would have to have a shared event that occurred on both devices.
If we could have the next page, please. Any chance to make that a tiny bit bigger, Ms. Gilman? Were you in agreement with this page?
No, I was not.
Tell us what concerned you about this page.
Sure. So this page is potentially misleading to the jury, again, by using,
Objection, Your Honor, move to strike.
I'll strike that.
Just tell me what your concerns were.
Sure. So my concerns with this, that it was potentially misleading to the jury.
Objection,
Oh,
Your Honor,
fuck.
move to strike.
No, I'm going to allow that. That's his concerns.
Sure. So that this slide was potentially misleading to the jury because it uses incorrect adjustments to try and adjust the times.
How does it use incorrect adjustments? Explain that to us so it's very basic, please.
Sure. So as we kind of go through the next few slides, you'll see. But essentially what they're doing is, or what is being done, is they're comparing call logs, timestamps from call logs from when the phone was off, suggesting that, again, that the lock event occurs after the end of the text stream event, as well as incorrectly identifying the GPS point when the three-point turn ends.
Will you better be able to explain that to us with the further slides that come next?
Yes, I believe so.
If we could turn to the next page, please. Okay. Is this just a label of what's to come?
It is.
And could we turn to the next page, please? If we could start, Ms. Gilman, with the top left-hand box, if you could enlarge that for us. Did you review this information in this box?
Yes, I did.
Okay. And before we get to your opinions, what does this information tell you?
Sure. So this is a snapshot from my initial report where I point out that the ignition on happens approximately 3 seconds before the infotainment power on event. So you can see that. I think we're up a little too high on the page.
Like,
Yeah. So highlighted in the red. That's based on our testing where we identified that the ignition on, or your finger on the ignition pressing it, and the engine coming on and the vehicle coming on happens 3 seconds before the infotainment system powers on.
you were asked on cross-examination about that 3 seconds between the pressing the button and the infotainment system going on, but you weren't allowed to answer the question whether you considered it or why that was important. So I'm going to give you that opportunity now.
Objection, Your Honor.
Sustained. Ask the question, please.
Okay. Is there significance to that 3 seconds, and did you consider it in your report and your findings?
Yes, I did.
Share with us.
Sure. So when we make our adjustments based on the event, so in this case the 3-point turn, what we're looking at is the approximate time frame when that 3-point turn occurred via Mr. O'Keefe's iPhone. And then we're adjusting that for the approximate time that the tech stream event and that 3-point turn ends. So as we sync those clocks, we're adjusting not only for the difference in the clocks, but we're also adjusting for this 3-second delay.
Did you accommodate that 3-second delay in your analysis and your conclusions?
Yes, that was included in my analysis.
Now back to the screen. The information there, is that text taken from your actual report?
Yes, it is.
Could we shrink the screen, please? And then the photograph in the bottom left, if we could enlarge that, is that as well from your report?
Yes, that is also from my report.
Did we look at that yesterday on your direct examination?
Yes, I believe so.
And briefly tell us what that depicts?
Sure. So that's during our exemplar testing, where again we've got it rigged with cameras that are recording video and timestamps of interactions we're having with the vehicle, which include powering it on and powering it off.
If you could shrink the screen, and we'll go to the right, Ms. Gilman. What was the import of this screen to you in its entirety?
Sure. So this is not actually a valid way to adjust or synchronize clocks because, again, we're not adjusting based on a shared event. So the ignition on event occurs. It is not recorded by Mr. O'Keefe's iPhone. But again, we are adjusting and including this in our timestamp adjustment.
You don't necessarily
next page,
need a
please.
shared event to sync the clocks.
You were asked about
That'd be helpful, but it's not
the
necessarily
process
strictly
of
required.
synchronization through phone calls or through the 3-point turn data.
Yes, that's correct.
Why did you choose to use the 3-point turn data instead of phone calls?
Sure. So I chose to use the 3-point turn data because it was closer in time to the event that was of interest, as well as it was based not only on the infotainment clock, but it was also based on that running timer. So once we adjust that first event to Mr. O'Keefe's phone, the second event is also based on that running timer, so it would also be adjusted.
Did you have any concerns about using phone calls specifically?
Yes, I did.
And what were they and why?
Sure. So those concerns were related to the phone calls that we could actually compare, and again, some of the phone calls that happened earlier or closer to the event of interest were not actually recorded by the infotainment system itself.
Why is it important to take an event closest to the time of the event you're studying?
Sure. So like I kind of said before, clock variance will change between devices as they are constantly syncing back up with reference systems. So a clock difference that you see at 1 o'clock in the day is not going to be the same as you would see at 2 o'clock in the day.
When you chose the
That
3-point
makes no
turn,
sense.
how close to the backing up event
I object
was
to
that in
that.
time?
I believe it was within 10 minutes or so.
Was that closer in time or further away in time than the phone calls as a method?
That was closer in time than the phone calls. If you think back to the phone calls that we could have compared, those occurred at 5 o'clock in the morning.
We turn to the next page, please. Did you have a chance to review this slide of the PowerPoint?
Yes, I did.
Okay. Now you see on the left is a box. Where's that box taken from?
Sure. So that box on the left is taken from my report. That's going to be my initial report.
January 30th, 2025?
That's correct.
Okay. And share with us what you were trying to express in this box.
Sure. So again, this box is a
I'm sorry to interrupt you. I
Sure.
apologize. Ms. Gilman, is there any chance we could enlarge the box on the left? My apologies. Okay, please proceed.
Sure. So this is a comparison of the calls. So the infotainment call timestamps are on the furthest left column. So again, your infotainment system, when you plug your phone in, is recording and synchronizing your calls. It's not great about recording and synchronizing every call. So there's a lot of calls here that we don't have that we know exist based on Mr. O'Keefe's iPhone. So the calls that we do have that were recorded in the infotainment system, we can compare to the timestamps that those are recorded on Mr. O'Keefe's iPhone. So when we do that, there's a couple things we notice is during that 1 o'clock and 4 o'clock and 4:45 time frame, when we look back at the power on and off events, we know the vehicle was not powered on at that time. So the vehicle's off. So those timestamps are not coming from the vehicle. They're coming from Mrs. Reed's iPhone or the defendant's iPhone. And then the times after 5:21, we know the vehicle has been powered up at that point. So those timestamps are coming from the infotainment system itself. So that's why we can actually do a comparison of those timestamps and determine the exact or the approximate clock variance.
When you look at the call timestamps of 1:14:13, 4:38:16, at 4:42:06, and 4:45:12, was the power on or off with the car during those four first calls?
Yeah, so with those first 5 calls, the car was powered off. And again, we know that based on the power on and off event. We also know that just by looking at the offset, it's a consistent 1 or 2 seconds. And that's what we typically expect and see between two iPhones. That's because iPhones are generally pinging back to Apple servers or GPS towers that are the same. So those times are pretty consistent and pretty accurate.
Was the power on by 5:04:28?
No, not at 5:04:28. It was still powered off.
So those first five events, were they reliable for you to use in synchronization?
No, they were not.
You gave us a number of reasons. One, the time distance between the event and because they were phone to phone. Any other reasons why they weren't?
I'll strike the first part, ask the questions.
Besides the reasons you already gave us, are there any other reasons why this would not be a reliable way to synchronize two separate devices?
Not besides the points I've made already.
Okay. And if we could zoom back on this. The box on the right, is that from your report? Is that Mr. DeSorga?
That's Mr. DeSogra.
Was there anything about that analysis that concerned you?
Sure. So that analysis is misleading because, again, it's not comparing Mr. O'Keefe's iPhone to the infotainment system. It's actually comparing the defendant's iPhone to Mr. O'Keefe's iPhone.
Is there any acknowledgement anywhere in Mr. DeSorga's report that he appreciated that this was iPhone to iPhone rather than iPhone to infotainment?
No, there's not.
Did you ever receive any report from Mr. DeSorga that would alert that he appreciated that this was iPhone to iPhone and not iPhone to infotainment?
Objection, Your Honor.
Sustained.
If we could go to the next slide, please. Is this a similar or different slide?
Sure. So this is a different slide.
Okay. If we can zoom in on the left box, please. Where does that box come from?
Sure. So again, that's coming from the same page of my report, just highlighting the 5:30 phone call. And this is comparing the iPhone from Mr. O'Keefe with the infotainment clock.
At that point, is the power on of the Lexus?
Yes. So at this point, the power is on. So this is a comparison of the infotainment clock with the iPhone clock at that time.
Could you zoom out? That final box that shows the comparison between the defendant's Lexus and Mr. O'Keefe's iPhone, do you have any concerns about the accuracy of that information for that time?
No, so I think those times are accurate, but again, that's at 5 o'clock in the morning when we're trying to adjust the clock variance, and it's too far away from the time in question. So if we zoom back in to the box, we can actually see in the data what I'm talking about as far as clock variance will change, with time. So the phone call at 5:21, we see an offset of around 8 seconds between the two devices, between the infotainment system and the iPhone. And then at 5:30, which is only 9 minutes later, we can see that offset has actually increased between 16 and 21.
In capturing this data, were there phone calls between the infotainment system and Mr. O'Keefe's phone?
Yes, those last two phone calls were between the infotainment system, or were recorded by the infotainment system with Mr. O'Keefe's iPhone.
How does that happen?
Sure. So that's, when the device is connected up to the vehicle and you make a phone call, the call is recorded within the infotainment system and it's recorded with the infotainment system's timestamp.
Could you focus on the right-hand box, please? Did you review the right-hand box?
Yes, I did.
Was that from your report, or is that Mr. DeSorga's opinion?
That's Mr. DeSogris.
Did you have any agreement with that?
Yes, so I do agree with that calculation, but again, that's 5 o'clock in the morning versus when we're really interested in around 12:30.
Can we have the next slide, please? Could we enlarge this? Do you know where this photograph came from?
Yes, so this screenshot came from Dr. Welcher's presentation.
When's the first time you saw this screen?
When I saw this presentation.
In Mr. DeSorga's report?
Correct, yes.
Had you seen this before that?
I had not seen this before that.
If we could focus in a little more, especially the bottom left hand. When you reviewed this, did you feel any need to do further testing?
Yes, I did.
Why?
So what we're looking at, if we zoom back out, so what that is the 12:23:38 is the approximate time that the text stream event occurred. Now, what we want to do is we want to be able to compare that to the 3-point turn from Mr. O'Keefe's iPhone. What you'll notice, though, is right here we've got a circled GPS point. So if we can zoom in there. So this circle here is actually circled GPS point 155, which is after this point, but we'll kind of ignore that. But GPS 154, and it's hard to see, the time is 12:23:58. When we look at that, what we see is that actually that GPS position is recorded before the 3-point turn even starts.
You mentioned 154 begins recording before the 3-point turn starts.
Correct.
Is the end time of the 3-point turn a time before or after that 12:23:58?
Sure. So the end of the 3-point turn logically would be after this point.
At the time you saw the slide, had you broken down point 154?
No, not at the time that I saw this slide.
Could you zoom back out a little bit, please? The information in the right box, is that from you or from Mr. DeSorga?
That is not from me.
And when you read that, did that compel you to want to do anything?
Yes, it did. So again, my initial thought was to address this during testimony. With further review and further thought, I decided it was best to offer a supplemental report. What this is, basically the math I agree with. The point I don't agree with is that GPS 154 is the time towards the end of the 3-point turn. And now reviewing further data, we know that's not true.
The 12:23:58 event on the phone, is that related to the first event, the 3-point turn, or the second event, the backing maneuver?
So that's going to be related to the first event, the 3-point turn.
Was there any other data that was closer in time to the to the backing event that you had access to?
No, not that we had access to.
We can turn to the next slide, please. You've seen this part of the report before?
Yes, I have.
Okay. Having seen the earlier part of the report, does it help you explain and understand this diagram?
Yes, it does.
Is this your diagram or Mr. DeSorger's?
This is Mr. DeSogris.
Do you agree with this diagram?
No, I do not.
Okay, could you explain to us what this, from your perspective, from your experience, what this chart is trying to suggest?
Sure. So this chart is trying to suggest that the lock event always occurs after the end of the text stream event. And again, that's using inaccurate adjustments to make that conclusion.
I want you to use the pointer and I want you to take us line by line why you believe that this is inaccurate in trying to conclude the time of those locking adjustments.
Sure. So it's kind of hard to tell. So what we've got is we've actually got two different sections. So we've got the top section, which is 1, 2, 3, 4, 6 events. So that's going to be the GPS event and those, let's see, no, that's going to be this, it's hard to say. That's going to be the phone calls and the GPS event that are calculated in this. And it's also done with the 3-second delay as well adjusted. But what we see is, so this obviously +1 is one of the phone calls that was from the defendant's iPhone time, so not from the infotainment system. So that's a inaccurate comparison. Same thing for the +2, the +1, the +2 again, the +8, the +16, and the +20 are going to be those last two calls. If you'll notice, the very last call, we can't really tell which phone call is the correct one to compare, so we're using both within that same time frame. And that's why we get the 16 or the 21-second variance. But again, that's 5 o'clock in the morning, so that's not appropriate for the time that we were interested in. And then the 20-second variance is coming from that inaccurate GPS position comparison.
Could we enlarge that a little bit, Ms. Gilman? On the 2021, is that plus or minus 21?
So that is -21.
The 20 and 21, is that based on different information than the 1, 2, and 8?
Yes, it is.
And explain again for us, where's the different source of the information?
Sure. So the -20 is coming from that GPS point 154, which we know is not the end of the three-point turn. It's right before the three-point turn begins. And the -21 is coming from the last phone call that happens around 5:20, I believe, or 5:30. And again, that's 5 hours after the time of interest.
The -20 and -21, is that suggesting that time should be taken off or put onto Mr. O'Keefe's phone for synchronization?
Sure. So that's suggesting that time should be. I'd have to go back to the other slides. I believe that's either way. It's suggesting that the iPhone lock event occurs +6 or +5 seconds after the end of the text stream event.
Besides not accommodating for the timing of that timestamp at the beginning of the three-point turn, is there anything else about this that concerns you?
No, just that overall, these numbers can be misleading, again, because they're based on inaccurate adjustments, and could lead, again, the jury to believe that the lock event always happens after the end of the text stream event.
Could we go to the last page of Mr. DeSorga's report? Is this a conclusion offered by Mr. DeSorga?
Yes, it is.
Did you agree with that?
No, I did not.
Why not?
So based on those inaccurate adjustments, this slide is again kind of misleading in the fact that it states there's always interaction with Mr. O'Keefe's phone after the end of the text stream event.
You can take that down and turn that off, please, for a moment. After reviewing this report, you told us you then engaged in further study for synchronization?
Yes, I did.
Did you call me on May 7th?
Yes.
Okay. And what were you told to do about a report?
On May 7th?
Yes.
Sure. So I would just finish the report and submit it.
Did you?
I did.
And when did you submit it?
May 8th.
And do you know that it was provided to the defense by email on May 8th? Do you know if it was provided to the defense?
Yes, I know it was provided. I don't know when.
Now, if we could have Mr. Burgess's PowerPoint, we can go back to page 38, please. After you explain to us.
Objection, Your Honor. Can we close, please, on scope, sir?
Who can say where the road goes, where the day flows? Only time. And who can say if your love grows as your heart shows? Only time. Who can say why your heart sighs as your love flies? Only time. And who can say why your heart cries when your love lies? Only time.
Is the court on lunch break? This this testimony defies any intelligent discussion by me. Yeah. if this guy talks about clocks one more time, if this guy talks about time one more time, swear in the name of all that's holy. um, how do you guys think the redirect is going? Is it going good? What do you think? Is the redirect redirecting? Are you feeling redirected? The time discussion is hurting my soul.
15-minute lunch because Burgess and I have some work to do here. I thought it would be quicker. It's my fault. So I'll go for lunch and Mr. Burgess again. You can call
Yep.
out.
Thank you.
All rise, please. Jurors, close the notebook, follow me.
Okay, we're on a 50-minute lunch break. Well, okay. All right then. Let's see if something intelligent is happening. Is anything going on at the Supreme Court right now? The Supreme Court issued an order, paused an order that blocked the administration from terminating deportation protection, but allows open possibilities relating to individual people to be deported. So, I mean, I don't know if there's a lot there. All right, so I have to, understanding the predicate is important in sort of understanding some of the Supreme Court stuff. So, Mayorkas, the then DHS secretary, shut up, Court TV. Mayorkas, the then DHS secretary, initially designated and later extended the designation of Venezuelans in 2021 as a country whose nationals in the United States were eligible to stay inside the United States and work under a program noted as the Temporary Protected Status Program. Okay, created in 1990, the program gave DHS secretary the power to make such designations when a country's citizens cannot return safely to their home country because of, problems. Then, of course, the current Secretary of Homeland Security announced the termination of the status, the protected status, and the Supreme Court and the District Court had prevented the administration from doing that, but the Supreme Court has allowed that status to be changed, which then would make them, it no longer gives them protected status. So they would be eligible for deportation under standard rules at that point. So not like a major thing. Like the administration initially granted the protection and the administration took away the protection. But they did it through a process that, was covered by law. So, fine. So the Venezuelan beneficiaries had urged the justices to leave the order in place, but, they said no. And so those people that had been protected by the status no longer have the status because the status had been revoked, because the status had been granted by the executive branch in the first place. And now the executive branch is removing the status. So, okay, fine. So, I mean, there's not really a lot to say about that, really. I mean, seems correct to me. The administration giveth and it can taketh away. So, okay, noted. Yeah, noted. That's insightful. So that was recently in the Supreme Court. So that's, fine. Let's see what else is happening in court news. You sent me something to talk about in my email? Okay, let's take a look. Let's take a look. There was some pleadings filed today relating to the buffer zone. It seemed to me that the judge's revised order sort of mooted the issue. What are these pleadings? Emergency request for review of the supplemental order. They're talking about some particular guy. That's not going to get them where they want to be. I mean, we can discuss this really fast. I mean, it's just not going to get them very far. But how do I... hold on. We can discuss this buffer zone stuff because people want to know. This deals with Karen Reed. So give me a second to download the orders and we'll discuss it. Or the pleadings in federal court, rather, and we'll discuss it. Give me a second to pull it up. Okay, do this. Combine them into a nice little PDF. Put them in a nice little order that they were filed in. Great. Yes. Close. Don't care. All right, let's see. All right, let's share this window. Fine. What happened? I don't think this is working. Oh, I don't know if this is working or not. Okay, that actually did work. Okay, cool. All right, so as for those of you who might not be as familiar with the issue, the trial court in the Karen Reed case initially put out a buffer zone that prevented people from congregating within certain spaces. And some people sued in federal court. The district court initially denied the request to look at the order. The Court of Appeals for the First Circuit took a look at it and basically vacated. They didn't reverse, which is kind of critical for legal details. They didn't reverse, but they vacated and basically told them to take another look at it in light of some revised case law. So hypothetically, the district court, when it was looking at the order having been sent back down from the First Circuit, hypothetically, it could have come out the same way on the order. They said, like, could you take another look at it in light of this thing that we think that you kind of ignored? Could you take another look at it? So anyways, sent back to the district court for another look, potentially leading to the same exact place in the end by the district court, and then back to appeal. However, the Judge Beverly Canoni, issued a revision to the order that appeared to track what the First Circuit asked them to do. So it wasn't clear that she had to do what the First Circuit wanted, because it was just a vacate. Like, it wasn't a judgment, right? It was just to take another look at it. So it wasn't clear that, the judge had to do what the First Circuit was suggesting. It was clear if she had done it that she would be in the clear. So doing what they wanted would put her in the clear, but it wasn't clear that she couldn't do something else and also be in the clear, if that makes sense. So she could just do what the First Circuit said and moot the issue, or she could do something else and potentially there would still be an issue. So in any event, Judge Beverly Canoni appeared to modify the order and appeared to modify it in a way that tracked what the First Circuit wanted. So it appears to moot the issue because it appears that she did exactly what the First Circuit had suggested. And so, but there's some revised filings relating to this, so we can discuss those revised filings. and discuss what they have to offer. So, anyways, we got three filings here. We got this is filing 693, emergency request for review for the supplemental order regarding the buffer zone. And then comes Erica Walsh requesting an order, and Walsh was repeatedly arrested for trespassing despite being on a public sidewalk. Walsh's First Amendment activity was unlawfully restricted. Taking action against her for the contents of the shirt, trespass statute, a pretext light to be arrested. She was arrested where she stood allegedly trespassing. So it's not clear that the order is relevant to this. It is not clear that this person was arrested compliant with the. Well, how do I phrase this? It's not clear that this person was violating the order that the judge had given out. It's possible this person was arrested for reasons outside the order. Like the order is obviously the scope of the authority, but it's possible the police exceeded the scope of the order. Okay, so it's not immediately obvious. It's certainly not obvious from this pleading that this person was arrested because of the order, or even that the order necessarily applied to this person's conduct. Right. So this person's arrest might be unlawful, but it isn't necessarily clear it's unlawful because of the order. Right. It's not clear that the police were enforcing the order, and enforcing the order, they arrested this person. They might have arrested the person, basically for illegally, because they not even in compliance with the order. They just arrested them ultra vires, outside of legal authority. So this person, Walsh, might have a valid claim, but this particular motion I don't think is good. Right? Because this particular motion is review the order because of what happened to me. But it's not necessarily clear that what happened to you was because of the order. So I don't know that motion really makes any sense, but okay, that's one thing. And so that's one motion that was filed. All right, then we've got this person, Jason Grant, requests a review. All right, so what happened to this? And also, incidentally, we're in federal court, right? Oh, no, we are in Suffolk County. We're in Superior Court. So where was this first one filed? This one was filed inside Norfolk Superior Court, not federal court. Okay. So this was not filed in federal court. This is filed in state court. So they want a review of what happened to me in state court. Okay, fair enough. And, the state court can, deal with that one way or another by, saying that the order did apply to you, or the order has nothing to do with this, or whatever, right? And then, from there, potentially they would have basis to sue in for violation of their rights. All right, so this person, Jason Grant, also wants a review of of the order relating to them. So what does Jason have to say on the issue? Purportedly pursuant to the second buffer zone, notwithstanding the supplemental order, the Massachusetts State Police threatened Mr. Grant for this sign. And then he has a sign. 2 Corinthians 3:17. Now the Lord is the Spirit, and where the Spirit of the Lord is, there is freedom. Jason Grant sought to stand across the street from the courthouse holding the American flag and Bible verse. The Massachusetts State Police denied him access to traditional and public forum, applying the buffer zone to prohibit purely patriotic or religious speech. Yeah, again, it's not clear that the buffer zone applied to him in the first place, and it's not clear that the buffer zone order applies to him, and so the police's order was therefore ultra vires. So he's asking for relief to clarify that, he wasn't in violation of the order in the first place, which he may very well not be. And then we have Thomas Dorser's order. Dorser was peacefully filming the exterior of the Norfolk Superior Court across from Pearl Street. One Massachusetts state trooper said okay as to where they're standing. Nevertheless, another trooper suddenly snapped and assaulted him. I'm always a little sketchy when they say assaulted. Like, what exactly do we mean? He violently grabbed him by the arm. How violently? Injured him and dragged him across the street. This injury required medical attention? Well, what exactly does that mean, required medical attention? Right? What does that mean? I mean, you can ask for medical attention for anything. It doesn't necessarily mean it's serious, but whatever. Hardman had no lawful or probable cause, yet emboldened by the buffer zone, either though he issued a supplement, the supplement does not restrain him. The state police have essentially taken and communicated the position. Nothing has changed, which, okay. Hardman decided he still could, under the pretext of his own, assault and injure him, even though he's been told where he could and on the path, blah, blah, blah. And so he wants a review. So fair enough. All three of these people have, in some sense, had their conduct restricted by the state police. And all three of these people, it's not clear that the buffer zone order as modified applies to them at all. And the police may not necessarily understand the revisions to the order, and they might need a little talking to. Fair enough. So all three people have asked for review of their situations, which, fair enough. And so, it doesn't necessarily mean the revised order itself is defective, though. That's sort of the point I'm trying to clarify, right? What happened to these people and the order itself being defective are not necessarily the same thing. So, we'll see, but that's what's pressing on. So all that's interesting, but a little in the weeds. It's a little in the weeds. And also, there's not really a lot of information given in the pleading. They're very, very superficial. They're very, very conclusory. So it's very difficult, based on that, to offer any sort of meaningful legal opinion as to whether what they were doing was lawful, unlawful, or whatever. So it's very difficult to offer any sort of meaningful legal opinion at this time. But, they want their rights adjudicated, and so, fair enough. That's fine. What else can we talk about? Is there anything else in particular that, who are they protecting with the buffer zone? Well, in principle, they're protecting people trying to get into and out of the courthouse, and also trying to keep the noise levels down so as to not interfere with the proceedings, because God knows we have enough of that as it is. So that is presumably what they're trying to solve. But in any event, the Court of Appeals for the First Circuit has no problem with the zone, at least as it relates to the courthouse grounds. And they have no problem with that. And it was not even clear what they necessarily have a problem with at all, because the First Circuit just said, take another look at this in light of this decision, and, come out with a revised decision in light of this, come out with new, exciting, revised thoughts. So, but that's what they're trying to do, at least in principle. Did I discuss the ethical issue? Not really. I don't know that I can discuss the ethical issue. It's like, that's an incredibly advanced problem. There's no way for me to really meaningfully discuss the ethics issue. Well, let's take a look at the rules on this and see if we can provide some sort of meaningful guidance on the ethics issues on this. Let's see. Okay, Rule 3.8 is what we need. Let's see if Rule 3.8 offers us any meaningful discussion here. All right, Rule 3.8. Rules of professional conduct, special responsibilities of a prosecutor. Okay. The prosecutor in a criminal case shall refrain from prosecuting where the prosecutor lacks a good faith base, that probable cause to support the charge exists, and refrain from threatening to prosecute a charge where the prosecutor lacks a good faith base, that probable cause to support the charge exists or can be developed. Unfortunately, there is probable cause, but so that rule isn't going to do us any good, but let's see if there's anything else. Make reasonable efforts to assure the accused has been advised of the right to and procedure for obtaining counsel. Yeah, that's fine. Not seek to obtain from an unrepresented person. Yeah, we can skip that. Make timely disclosure to the defense of all evidence. That's not the issue for the moment. Not subpoena a lawyer in a grand jury or other criminal proceeding. Yeah, that's not what's going on. Except for statements that are necessary to inform the public in nature of a statement, not makes extrajudicial statements. That's not the problem. Not avoid pursuit of evidence because the prosecutor believes it will damage the prosecution's case or aid the accused. Well, there might be something there. Refrain from seeking as a condition of disposition defense waiver of claims. No, that's not what's going on. When, because of new credible material evidence, a prosecutor knows there's a reasonable likelihood the convicted defendant not commit effect. Well, she's not been convicted, so that rule doesn't apply. When a prosecutor knows that clear and convincing evidence establishes defendants was convicted, she's not been convicted, that doesn't apply. A prosecutor's independent judgment made good faith that new faciure is not such a figure. So the only really rule that arguably applies here to this particular situation might be G. But otherwise, as relating to this particular witness, he's arguably in the clear as to this particular witness. I guess. I feel like he should be doing better than that, but we are where we are. All right, what else can we talk about? Who I think the defense will call as their first three witnesses? I have no idea. Strategically, I have no idea what makes the most sense. I haven't really thought about it. I don't really know because the defense didn't really put on a case last time. I think you probably start or end with ARCA. I'm not sure if it makes more sense to start or end with ARCA. Probably starting with ARCA probably makes the most sense. Although, yeah, probably starting with ARCA makes the most sense. Although there's a case to be made for calling Proctor before you call ARCA. Yeah, I don't know what else they have to work with in terms of their other witnesses. So, and then you have, of course, your own medical experts and stuff like that. I don't know. Yeah, I haven't really thought about strategically what makes the most sense in sort of the presentation of the thing. Is there a general rule to advance the interest of the profession? Yeah, Bookending ARCA? Do you bookend ARCA? That's an interesting idea. Because they do have two ARCA witnesses. Does it make sense to call one ARCA witness like at the start and one ARCA witness at the end? Does that make sense strategically? Maybe. That might make sense. I mean, arguably, that is actually a really good idea because the idea that the car didn't hit John O'Keefe, I think, or at least didn't cause the damage, is, I think, the defense's best argument. It's the easiest way to resolve it in favor of the defense. So taking the principles of primacy and recency, you want to put first and what you want to put last, basically your strongest thing. So calling one ARCA witness first and then calling the other ARCA witness last might make a lot of sense because then you begin and end with your strongest point, the weakest part of the prosecution's case. So that's an interesting idea. That's definitely an idea that's worthy of consideration. Oh, I think the defense is absolutely going to call Proctor. I think they're going to 100% call Proctor. I think you have to call Proctor. I would be amazed and somewhat disappointed if the defense does not call Proctor. It feels like a total give me by the defense, because there's basically no way it can go wrong. And Brennan's going to rehabilitate on cross. Sure he is. What else can we talk about? The ME or medical examiner, your own medical examiner. Yeah, I mean, there's a lot of potential ways to do this that make sense. And I'm not sure when you call Proctor. I'm not sure when it makes the most sense to call Proctor. Calling Proctor first might be interesting as a choice. That's a very bold choice to call Proctor first. That's an incredibly bold choice to make Proctor your first witness. I don't know that I would recommend that. Do I think they'll improve the jury instructions and slips? I think they absolutely will. And I think it will be very, very interesting to see whether the defense wants partial verdicts or not. Because they're going to be asked. Like, do you want partial verdicts? I would ask as the judge. I want that really, really fucking clear on the record. Do you want instructions? But it's like you have to decide before we charge the jury. I'm telling you, you have to make that decision before we charge the jury. You can't change your mind later. Okay? So you have to make the decision when we initially charge the jury. That's my constraint. But we'll do it either way you want. Right? We'll do it the way you want to, but you have to make the choice before when we charge the jury initially. So do you want there to be complete verdicts, or do you want to allow for partial verdicts? And I'd be like, defense, this is totally your call. I don't give two shits what the prosecution wants. This is 100% your decision. Which way do you want it? And we'll do it whichever way you want, but you have to make that decision. And I think it'll be really interesting because I don't think the defense is going to do it. I don't think they're going to ask for partial verdicts. I don't think they're going to do it. But, we'll only be able to tell when that happens. Closing arguments not being restricted to an hour. I feel like an hour is plenty of time, to be quite honest, for a closing argument. Yeah, an hour is a long time for a closing argument. If you can't get it done in an hour, I don't know, man. I don't know. But putting some sort of time constraint on opening and closing arguments, I am here for it. I am 100% here for it. I am definitely team clock. I like clocks. Right. I'm definitely team clock. Yeah, we're definitely going to limit your opening and closing arguments to some kind of reasonable time number. An hour sounds like a pretty reasonable time number. It's like, yeah, we're definitely limiting this down. Yeah, 100%. Don't come to judge on civil and be like, I don't want clocks on my closing. Yeah, too fucking bad. You're definitely having a limit. I'm not letting you drone on for hours and hours and hours about war and peace. It's for your own good, for that matter. It's for your own good. Constraints art from adversity and stuff, so forth and so on. If you can't get done in an hour, you're not doing very well, man. I would consider time clocks during the trial itself. Because I like chess clock. I really liked chess clock during Johnny Depp. It's like, this is how much time you have, and that's the time, and you figure it out. And then, Elaine with her surprised Pikachu face at the end. What do you mean I only have, 20 minutes or whatever the number is? It's like, well, that's the amount of time you have. I've been telling you at the end of every single day how much time you have, and somehow you're still surprised Pikachu face about it. I don't know what to tell you. But yeah, I would strongly consider chess clocks during the trial as well. I don't know what case law there is out there, really. I do know of one case where I read a Court of Appeals case where a trial judge used chess clocks in a criminal case, and the defense ran out of time and wasn't allowed to cross-examine witnesses because they ran out of time. And at least the one Court of Appeals I read basically said that the Sixth Amendment guarantee means that they have to give some time to cross, although the way it was written seemed to imply that basically like anything would have been sufficient. So if the court apparently, the way it was written, I mean, they didn't say it explicitly, so reading between the lines, but it's like, if all I give you is like 5 minutes to cross because you ran out of time, right? It's like, well, 5 minutes isn't enough. It's like, yeah, well, you have a right to cross-examine, but you don't necessarily, but I have the right to control the schedule. And you ran out of time. You could have had more time, but you didn't budget right. So it's like, if all I give you is 5 minutes to cross-examine the critical witness, then, sucks to be you. That's the way it read. But that was like one decision by one court that I read. So I don't know if other criminal courts have experimented with the magic of chess clock in trial, but it's definitely something I'd want to read more if I wanted to experiment with as a judge. I definitely want to read to see what other criminal cases are out there on the magic of chess clock before I start, rolling out this brand new exciting procedure. But chess clock is best clock, man. I'm telling you what, man. Glad to have you here, Just Rhonda. Don't want to take a guess how long deliberations will be? Not really. Does Turtle Boy do jail time? I haven't dived deep enough into the Turtle Boy case to really have a strong opinion about the Turtle Boy case. So I haven't taken a position on the ultimate issues because I haven't really dived deep enough into it to take a position. And I don't want to be honest, because I'm already deep enough into Karen Reed lore. I don't also need Turtle Boy lore in my head. So I've basically taken a pass on the ultimate issues relating to Turtle Boy. What little I have seen hasn't been strongly encouraging for the government, but I haven't seen a lot. So, I Yeah, Turtle Boy also had a bunch of charges dropped yesterday. That's very true as well. What was the deliberation time of the first trial? I think ultimately it was 3 days, I think. But I'd have to double check. Does the verdict have to be 12-0 on every count? Yeah, it has to be 12-0 on any count they convict for or acquit for. That's true. Whether or not they have to have verdicts on every count, we don't know. We don't know whether or not the defense is going to ask for complete verdicts or not. The judge has the right, under the relevant state law, they have the right to ask for partial verdicts, but it's discretionary, and it's not clear what the defense wants. I don't think the defense is going to ask for partial verdicts, but we'll see. Are prosecutions allowed to prep witness in between days of testimony? No. Once the witness takes the stand, you're not allowed to talk to the witness about their testimony. It's considered witness interference and obstruction. It was 5 days and 27 hours. Thank you. Should we see what's happening at the Court of Appeals and see if there's anything interesting happening in Court of Appeals land? Is there's another mistrial? Do I think that Bev would be the judge again? Couldn't speak to that. I wouldn't want to be the judge the third time. I'll tell you what, man. I'm not sure I'd want to be the judge the second time, to be quite honest. I mean, I don't want to do that again. Yeah. I don't think I'd want to do the trial again at this point. Just take another, do something different. It's like I already did this once. I don't want to do it a second time. Let someone else take a hit at it. We got 248 votes on my poll on Twitter. That's pretty good. Are they at lunch? They are at lunch, yes. Did I see Microdot's latest on Bev? No, I did not see Microdot's latest. Microdot's does some interesting stuff for sure. It's in staff Discord? What's in staff Discord? I don't see anything in staff Discord. What are you referring to? Just Rhonda. Well, Uncivil Law, I made very many more emojis for his trial. I'm currently working on memorandum of Trooper Paul. And you're out slots, but just for trial file, it could be fun. Maybe. The Microdot video? It's still not. How far back do I have to scroll to find it? Still scrolling. Okay, here it is. Let's take a look at this. All right, this is from the channel Microdots. Let's see what they have to say about it.
Special thanks to Olivia Lambo for pointing this out. Follow her on X. Let's set the stage. It's day 18 of the grueling case against Karen Reed. Judge Beverly Canoni, long accused of harboring a bias in favor of the prosecution, is eager to wrap up an excruciating day of cross-examination.
I would be too, to be honest.
Commonwealth expert witness Shannon Burgess, who's just been exposed.
Signal starts at 6:27. Okay.
Canoni glances at her watch, clearly weighing whether it's close enough to the end of the day to call it, just as the cross-examination is about to strike a nerve.
And then the next page, and tell me, sir, with reference to this entry right here, if that refreshes your recollection with regard to...
She takes a deep sigh. Now, We will play through what she does next once, then break it down.
With regard to the phone of Mr. and whether it refreshes your recollection on any comments Mr. Whiffen made about pocket state.
Objection.
I'm going to see it sidebar for 2 minutes on this. Okay.
That is a little sus. That is a little sus. Yeah. Yeah, that is a little sus. Yeah.
With regard
She glances at Brennan to see if he's looking in her direction.
to the phone of Mr.
She does it again, now realizing he can see her. She abruptly raises her arm to her face in a sharp, unnatural motion, making one of the most unmistakable signals imaginable. Then she locks eyes on Robert Alessi, like a trained hound pointing to its target. All with a bizarre grin on her face that gives it all away.
I mean, there's that.
And whether it refreshes your recollection on any comments Mr. Whiffen made about pocket state.
Objection.
Brennan finally picks up her signal and states his objection, and she couldn't be more pleased. It's one of the strangest moments we've seen from this judge, as if the gravity of a woman fighting for her life means nothing. She's just been caught sending covert signals to the very prosecutor whose conduct should be under scrutiny, not aided by the bench.
You know, not for nothing, but the judge doesn't need Brennan to object. If she wants to, she can just object herself. I mean, she can. This judge is more active than most. I mean, in terms of rephrasing questions, which isn't necessarily bad, by the way. Different judges have different traits. Some judges are a little bit more active than others. She's a little bit more active than your typical judge, although I'm not necessarily sure she is as active as I might be. I think I might actually be even more active than her, but that's just stylistic things. But yeah, it isn't necessarily, but she could just be like, you know, if she just wants to see counsel, she could be like, counsel, could you approach the bench? She doesn't need the objections. So it's like, why she need the fig leaf? I don't know.
Whatever her reasoning, this is unethical, inexcusable, and she should be removed for this infraction immediately.
I'm going to see it sidebar for 2 minutes on this. Okay.
Yeah, I mean, I won't take a position confirming it, but I mean, it's sus. That's as most as you're going to get out of me. Is that it's suspicious. It is suspicious. The way that happened, her smile on the face, that duper's delight thing, is a little suspicious. So yeah, I understand people's concern here. That's totally fair. See what else we can talk about. The Fourth Circuit ruled against Trump in an Alien Enemies Act case on the 19th, yesterday. In a 2-1 ruling, the Fourth Circuit Court of Appeals ruled that Trump invocation of the Alien Enemies Act cannot supersede a settlement barring deportation of a group of migrants. One of the judges also held that the AEA itself was invoked illegally. Exciting. Was the favorite case I've ever handled? My work was principally transactional, so I haven't done a lot of court work. It's not my experience. I was a patent lawyer for many, many years. So, yeah. In terms of, I was working on a Supreme Court case last year I had a lot of fun with. We reviewed the brief previously. I thought it was good, given what the constraints I had to work with. I mean, you know, I thought it was a pretty good brief, but then my client decided to hire somebody else, and I didn't like their brief because their brief was predicated on a legal error, right? I mean, it's like it didn't make any sense. Yeah. because my client wants to go to the U.S. Supreme Court. I'm like, well, that's hard, and I told my client that. I wrote a brief, and then ultimately my client decided to hire somebody else. The problem was the person they hired predicated basically their principal argument on a circuit split that didn't exist. So they basically lied to the U.S. Supreme Court in their brief. I was like, oh, there's a circuit split. I'm like, no, there's not. And we looked up the cases, and it's like, yeah, no, there's no split here. So they basically lied. The foundation of their argument was complete emptiness. And so I got really, really frustrated, because my client hired this person, because their writing style was better than mine. I mean, I'll credit it for that. Although, well, better's, I guess, it's more white shoe would be the better way of putting it. It's the writing style of the person my client hired would be more typical of like a really high end law firm, which tends to write. High end law firms tend to write in a much safer style. They tend to write in a more restrained style, and tend to be more. They tend to be a little bit more bland because they don't want to offend anyone, which is fair enough. They want to sort of play it really safe and play within the edges, which fair enough. That's reasonable. So it was written in a much more white shoe style, but it was predicated on a lie. And so I'm like, this is horrible. So that was frustrating. And I hope at some point I can write a Supreme Court brief again. I'd like to give it another go. I had a lot of fun with it. It was a lot of fun writing it. And then, in terms of other aspects of the brief that I wrote, it was, I think, it's like trying to judge your own work is challenging, because it's like, how do you judge your own work as a person? It's like, how do you judge it? The biggest thing you could say about my brief in terms of its weakness is a substantial portion of the brief was making, what would you say? Was making more sort of emotional arguments that are atypical, particularly for the Supreme Court. The reason it was done that way was because, unfortunately, my client didn't have any of the typical factors. So I sort of had to I needed to find some way to dress it up, and I couldn't dress it up by staying within the bounds of what is typical. So if you're going to the U.S. Supreme Court, you kind of need one of a couple things. First of all, circuit split would be really helpful. So if two different federal circuits have come out differently, that's your best ground by far, right? So two different federal circuits have looked at the exact same issue, and they've split. They've come out differently. Like, by far and away, that is going to be your most likely ground of grant. So if you have that, that'd be great. Might be why the attorney my client ultimately hired decided to try to write their brief that way. But unfortunately, it was a lie. It didn't really exist. So it's like, at least it's wrong, because it's just not there. It's like they tried to create something that just isn't there, and it just completely fell apart. So it's like, okay, my client didn't have the circuit split, so I can't sell them on that. A case of particular national importance in that it involves some sort of intra-branch fight. It goes to the core of powers, goes to core tensions between the branches, maybe core tensions between federal and state, right? Core federalism struggles, core intra-branch struggles, that kind of thing. Like, really, super important issues, because it involves, the balance of power between the federal government and the states, or involves the balance of powers between the branches of the federal government, something that goes to the core powers of, that kind of thing. It's like, well, that's not there. A case that involves a whole lot of people, right? A case that has wide impact. And it's like, yeah, it doesn't really have that. And then sort of secret fourth ground. The Supreme Court wants to take the case because they just really want to beat up on the lower court that day. which, sometimes, like if you're taking a habeas issue out of the Sixth Circuit, for example, then you're in secret fourth ground, right? Like, is it a habeas issue? It's like, well, what circuit is that out of? If it's a habeas issue out of the Fourth Circuit, If it's a habeas issue out of the Sixth Circuit, oh, okay, it's a habeas issue out of the Sixth Circuit. Oh, yeah, the Supreme Court's probably going to take that. Oh, it was a patent case from the Court of Appeals for the Federal Circuit. Oh, yeah, they might take that, right? So there's like secret fourth ground. The Supreme Court really wants to beat up on somebody. So my client didn't really have any of those grounds. So it's like, well, I have to make something up. And so a significant portion of the brief was making, I suppose, emotional appeals because, I was trying to elevate its support. My client was a veteran that was arguably discriminated against by her employer in an illegal way. Veterans are protected. She was fired by her employer arguably illegally. And so it's like, well, how do I make, so I was like, I don't really have a circuit split and I can't make one up. I can't do that. This case is an intra-branch conflict or intra-federalism conflict. It's just not. There's no particular reason to believe the Supreme Court's looking to beat up on the lower court just for the hell of it. So sort of the only ground left is how do I make it seem like it impacts a lot of people? And so then I basically spent a significant portion of the brief talking about veterans, PTSD, how PTSD affects veterans, how, they have trouble getting treatment, both practically because getting to a veterinary VA hospital can be challenging, backlogs at VA, and also stigma-related issues. I talked about, how it impacts, a lot of people, particularly from Iraqi, Operation Iraqi Freedom, people who've seen combat, how it impacts women because my client was a woman, basically lean on these factors that, it impacts a lot of veterans. And that's what makes it important. Plus, recently, the Supreme Court had been taking a bit more veterans cases than they normally have. So it wasn't like a lot more, but it was more, right? So the Supreme Court had recently taken cases involving veterans at a slightly higher rate than you might otherwise anticipate. So leaning into the veteran thing because it was already what the Supreme Court was doing seemed pretty wise. Everyone can get behind veterans, leaning on the flag, is good. But, it was to the critics' point, the briefing was more emotional and also in some senses, I suppose, not strictly legal in some senses because, it relied a lot on, for example, medical studies. It relied a lot on, well, not a lot, but it definitely mentioned medical studies, mentioned things like PTSD rates, mentioned studies by, that go to like, that are secondary issues or secondary factors, unfortunately, at least in my judgment, there was not enough there from the strictly legal lens to allow for me to do a strictly, like, you could argue that I did too much in that portion of the brief. You could argue that I should have dropped it completely, but at least in my judgment, I didn't think you really could because there wasn't enough there to make it work without it. And, so it's like you need to try something to make it, seem like a bigger deal. And, making the veterans issues seem important and all the rest of it. It's like, trying to elevate it. It was not the strongest petition, but that was because unfortunately my client didn't have the strongest position. I can only do so much. But I was proud of my work. I thought it was really good. You could critique it. You could disagree with it. And, there are definitely points to be made, and arguably it could have been better in some way, but I felt like it was really, really solid. Also, I didn't really like the way that the person who replaced me wrote their question presented. The question presented was like 8 sentences long. I was like, holy shit, dude. I mean, you gotta narrow that down, man. You gotta make this a more workable question. So, but I had a lot of fun with it. And I hope at some point I can write a Supreme Court petition again. If I could get to the merits, I felt like I had a pretty decent chance of winning on the merits. Getting the Supreme Court to take the case was the challenging part. If I could convince them to take the case, I felt like I had a pretty decent chance of winning on the merits. I felt like my odds were good on the merits. I felt like the text of the statute really went my way. The history relating to the statute, I thought, was pretty solid. The precedent that existed seemed to point in my direction, such as it was. The intent behind it, legislative intent behind it, and also policy concerns sort of went my way. So when you look at the five ways that the Supreme Court evaluates a case, when you look at sort of the big 5 factors that lean into a case, I thought I had a pretty credible argument that all 5 factors went my way. I felt like I had a really solid argument that every factor, would go my direction. And, you throw in the veterans on top of it, and that can't hurt. So I felt like if I could get the Supreme Court to pick it up, I felt like we were in a very, very good position on the merits. But getting the Supreme Court to pick up the case, of course, is the challenging part. That's the challenging part. And then if we could get them to pick up the case, I felt like we could win. Because all the sort of indicia that you use, it's like, every single factor sort of goes my direction. So, I felt pretty assured by it. I did my best. It would have been fun. It would have been a lot of fun prepping the case too. It would have been a lot of fun prepping the case. It would have been a lot of hard work. It would have been really challenging, but I obviously felt like I could do it. I felt like I was able to give my client competent advice, a competent counsel. I felt like I was able to do it, and I was ready to go to the Supreme Court. Well, after months of prep, I would have been ready to go. But it didn't happen. So what can you do? Yeah, the Supreme Court would have considered what you intended as far as it would have gone, but was a risky rhetorical approach regarding what the client will appreciate. I mean, there was definitely a calculation to be made in terms of, how to put the case in the best possible posture. It was, I just don't know that there was any way to do it any better. I don't know that there was any way to I mean, I obviously looked at the case in every possible light, but I think, I obviously made what I thought was the best combination of choices for my client and their case. You know, other lawyers would do it differently, to be sure. Other lawyers would almost necessarily make different choices. But I think that, I don't really know that I could have done it any better. I did my absolute best. So, what else can you do? You could definitely reasonably find that the sort of back half of my cert petition was overly emotional. You could certainly find that it was overly flag wavy. You could certainly find it was overly you could even think that it was emotionally manipulative in some ways. I mean, there's definitely a lot of criticisms to be had. It just I just think that it unfortunately was necessary given the posture that I was in. And so that's why I wrote it that way. I don't think my client was necessarily wrong for picking the lawyer they picked. I think the lawyer was wrong for what they wrote. But my client's choice relating to the lawyer was a reasonable choice. I think the client did. I think the lawyer who did the petition did the client a disservice in the end, because I just think that they were trying to create a circuit split that didn't really exist, and it just really fell apart under any analysis. So I think the lawyer who wrote the petition did the client a disservice by trying to create a circuit split where there was none. So yeah. It was this is also incidentally, like, for those of you who saw it, like the clip, like I think Alyssa clipped it out. You saw me like completely losing my shit, right? This is a clip where so previously we had ChatGPT do a comparison between the two briefs, and ChatGPT made a note repeatedly that the other brief mentioned the circuit split, right? And I'm like, did I miss something, right? Because it's like, as a lawyer, it's like, did I miss something, right? Did somehow I miss this thing, right? So I went back and I read the brief that was filed, because it's on the public record. I read the brief that was filed, and I read it and I discussed it, and then I realized that the circuit split didn't really exist. And then I started screaming basically into the void. This is like where I lost, for those of you who are curious, and you can go watch Alyssa clips, this is like where I get super animated. I'm like, I'm a lawyer, and this is bullshit and blah. I'm basically like, melting down, as the kids would say. But I'm melting down because the brief is based off a complete fiction. And it's like, this is It's trash. It's absolute total trash. And so it's like I'm a lawyer, I'm a good lawyer, and this is horrible and all the rest of it. And like, the clips shows and everyone else made fun of me, because here I am losing my shit. Look at Kurt, ha ha ha, right? All the rest of it. I'm like, yeah, but I'm losing my shit because the brief is predicated on a complete lie. It's predicated on the circuit split that does not exist. It's not there. It's like, yeah, crashing out. Yeah, people said I was crashing out. It's like, I don't know if I was crashing out or not. I'm not exactly sure 100% what that means, but if I was crashing out, I literally am not 100% sure what it means, to be honest, to be crashing out. So if I was crashing out, I was crashing out for a reason, because I was like, ChatGPT is giving this guy better marks because of this thing, and then I go look at it, and it's like, oh, it's not there. It's just not there. I'm like, this is bullshit. So, So I feel like I was at least partially misjudged by the comment section of illicit clips, and that there was a lot of very negative comments towards me in particular. There was a lot of people who are very, very harsh on yours truly on civil in that comment section. I feel like I was somewhat significantly misunderstood. I mean, to my own credit, I put a lot of energy into it, as you would expect. I put a lot of energy, time, thought. I poured myself into that brief, the one I wrote. Obviously, I poured myself into it because I want to do the best job for my client I possibly can. I'm a little invested. I was a little invested. And then ChatGPT's like, their brief is better because of these reasons. And then I read the other brief and I'm like, oh no, it's not real. It's not real. And so I got a little pissed. I got a little pissed.
Back in session, you may be seated.
Not to say that I think the Supreme Court would have taken my position. Of course, I knew from the start that the petition was, I knew from the start that it was not, it was. I was well aware that the petition had all the problems I've mentioned. So it's not like I think that if my client had filed my petition, she would have gotten a grant. I'm not saying that at all. I don't know that I don't know that my client was necessarily any worse off, although who can say how close it would have been in the justices' collective minds. But it's not like I think that we were but I was still frustrated that the brief was built on basically a fiction, and so that was a bit infuriating.
All right, Mr. Brennan, whenever you're ready.
Thank you.
I do think my client's odds were slightly better with my brief. Not a lot, but I think they were a little bit better. At least it wasn't predicated on something that wasn't true. It might have been a little bit overly emotional. It might have been a little.
Sir, when I asked you about,
it might have been a little. It might have been a little too flag wavy. It might have been even arguably jingoistic at parts, but at least it wasn't based on something that was false.
Your first report regarding the protocol, you told us October 10th, followed by your supplement on the 17th. You did not remember the day that you first received any information offered by Mr. DeSorga. Is there a document that may refresh your memory?
Yes, there is.
May I approach?
Yes.
Thank you.
I don't want you to read this. I just want you to look at it. You can look at any part of it.
Okay.
And look up when you're done, then I'll ask you a question.
Okay.
that refresh your memory the first time that you saw any information provided by Mr. DeSorga?
Yes, it does.
And when was that?
November 7th of 2024.
Before or after you recognized the megabyte oversight?
That would be after.
I want to go back to where we were at before we went to lunch. You had described 2 text stream events. I want to focus on the first text stream event, and that is the text stream event relative to the 3-point turn.
Okay.
You had described that there was a timestamp 154. Just to reacquaint us, can you very briefly tell us the significance of 154?
Sure. So GPS point 154 is a GPS point that occurs just before the 3-point turn starts.
And why is it important to identify when that turn starts and when it ends?
Sure. So what we're specifically looking at comparing is the end of the 3-point turn. That's going to be the text stream event ending, which is near the end of the 3-point turn, as well as the end of the 3-point turn as recorded in Mr. O'Keefe's iPhone.
Was it important to identify the beginning and end of that event to come to a conclusion to a reasonable degree of scientific certainty regarding the variance between the text stream data and Mr. O'Keefe's phone?
Yes, there was. So we can't say, we can pinpoint approximately when the 3-point turn ends based on the GPS data. But best practice would be to use a range of time. So the range we're using is the time that the 3-point turn starts to the time that the 3-point turn ends.
Could we have from Mr. Burgess's PowerPoint number 41, please? Is this part of your presentation helpful in explaining the beginning and end point of that 3-point turn?
It does. It does. So if you look at, and if you recall yesterday, the heading change, first heading change from a general north heading is depicted by that green shading circle.
Could you use your pointer, please?
Sure, yes.
Ms. Gilman, can you enlarge just a little bit?
So again, this green circle is going to be the center of this circle is going to be the GPS point itself. That's going to be centered on the horizontal radius, which is the accuracy. So the green circle represents the 16-foot accuracy zone. The black arrow coming off in a northwestern direction is going to be the heading for that point. And then again, the yellow is going to be the approximately 8 seconds later when the heading changes again in a southerly direction, and then the GPS points after that also continue south with increasing speed.
What part of the 3-point turn event does the green circle signify?
Sure, so that's going to be the approximate beginning of the 3-point turn.
And that time?
That's going to be 12:23:59.
The yellow circle, what part of the 3-point turn does that indicate?
Sure, so that's going to be approximately the end of the 3-point turn, and that time is going to be 12:24:07.
Is there any correlation between the times in the green, the time difference between the green and yellow circle, and the range you ultimately arrive at as far as the synchronization variance?
Yes, so that is what determines that range of 21 to 29 seconds.
This illustration or diagram where you've put the green circle, is that based on actual data?
Yes, that is based on actual data recorded by Mr. O'Keefe's iPhone.
That data, is it accurately reflected in this diagram?
Yes, it is. So again, the GPS point that is recorded within the iPhone, every point has a horizontal accuracy. And again, that horizontal accuracy is depicted by the green circle.
Is that level of precision used when you create this diagram?
Yes, it is.
The yellow circle, is that specifically reflected in the data, or is that an estimate?
Sure, so that's specifically reflected in the data. So that is another GPS position that has been recorded by the iPhone. Again, with a horizontal accuracy, a timestamp, and a speed and heading.
How about the orange circles?
So the orange circles are portions of the GPS positions leading up to this event. So if we went back one slide, you would see, it would zoom out, obviously, so a little bit harder to see. But essentially what we've done is I've removed the other orange circles representing GPS points heading north and the GPS points heading south after the 3-point turn. And I've just removed those for clarity to kind of clean up the map so it's easier to read.
On the left, text stream 11621. Remind us again where that information comes from?
Sure. So that's the text stream. That's the end of the text stream event for the 3-point turn. And that is based on the infotainment clock as well as that running timer from the airbag control module.
Does this diagram reflect the data that you reviewed to a reasonable degree of scientific certainty?
Yes, it does.
In breaking down this timestamp 154 and getting into the minute detail of when it started and ended, one of your charts, does it also show it numerically?
Yes, it does.
Can we have number 40, please? Before we discuss this again, where did you get the information to put in this chart?
Sure. So this is coming from Mr. O'Keefe's iPhone. Specifically, it's coming from a SQLite database that is recording locations as he's using the Waze app to navigate.
Is the information in this chalk or diagram directly from the data?
It is directly from the data.
Is this accurate to a reasonable degree of scientific certainty?
Yes, it is.
If we could zoom in just a little, we'll have to go left to right, Ms. Gilman. We start with the left. Timestamp 154. At what point in that 3-point turn does 154 represent on the left?
Yeah. So timestamp 12:23:58 or GPS point 154 is approximately 1 second before we see the heading change. If we could zoom out just a little bit. A little bit more. Yep. So we see the heading change represented in green. That's a heading change to 284. Before that, we've got a pretty consistent heading of 348 to 339. So that first heading change, as well as the drop in speeds, is indicative of a 3-point turn maneuver.
The latitude and longitude, did that assist you in making the diagram with the circles on it?
Yes, it did.
How so?
So the latitude and longitude are the center points for each GPS point, or the center point for each circle.
There's a green highlighted row and an orange highlighted row. What's the difference between the two?
Sure. So the green highlighted row is, again, the beginning, the approximate beginning of the 3-point turn. And the orange or the yellow is the approximate end of the 3-point turn.
And the time between the green and the orange lines?
Approximately 8 seconds.
Is that consistent with the range that you've shown for synchronization?
Yes, it is.
Point 21, or plus 21 and plus 29?
Yes, it is.
The inevitable variance that you found between the text stream data and between Mr. O'Keefe's cell phone, could you share with us to a reasonable degree of scientific certainty what that variance is?
Objection, Your Honor.
Sustained.
Do you have an opinion about the time range in the synchronization between Mr. O'Keefe's cell phone data and the Lexus clock that shows the text stream data to a reasonable degree of scientific certainty?
Objection, Your Honor, and appreciate an approach at the appropriate time.
Okay, so answer that question, yes or no.
Sure. So yes, I can.
So I'll see you at sidebar then, Mr. Wilson.
Thank you, Your Honor.
No, he can't. No, he can't. He absolutely cannot. There's no chance he can whatsoever.
Can we go back to slide 40, please? In reaching your conclusion about the variance between the defendant's Lexus as contained in the text stream as it relates to Mr. O'Keefe's iPhone, Was stamp 154, timestamp 154, part of your analysis?
Yes, it was part of my analysis.
Was the running clock on the text stream data part of your analysis?
Yes, it was part of my analysis.
What else was part of your analysis?
Sure. So in addition to the location data, including the GPS 154, that would be the running clock for the text stream data, as well as the infotainment clock from the Lexus.
How does the running clock correlate with the text stream data and with the time on Mr. O'Keefe's iPhone?
Sure. So they correlate. So the running clock and the infotainment clock are used to create that timestamp for the text stream events 1 and 2. And then comparing those to the iPhone, we can adjust and get a clock variance for those.
Did you come to a conclusion to a reasonable degree of scientific certainty about the variance range between the defendant's Lexus and its clock system and Mr. O'Keefe's phone?
Yes, I did.
And to a reasonable degree of scientific certainty, what is that variance that is needed to identify for synchronization?
Overruled.
That is 21 to 29 seconds.
Why would it be different? Why would it be 21 to 29 seconds? Why wouldn't the two clocks just be because the variance is different at 1 p.m. versus 2 p.m.? Okay.
We now have number 43. Did you create this diagram?
I did, yes.
When comparing the text stream event, the backing maneuver, to Mr. O'Keefe's clock on his phone, do you recognize the different timestamps on each device?
Yes, I do.
When you are trying to synchronize them, what do you do? What is the base? Do you start with the text stream event and you add, or do you start with Mr. O'Keefe's phone and subtract?
Sure. So we could do it either way. Because we're wanting to compare this against other events that happened or occurred on Mr. O'Keefe's phone, we're going to adjust the text stream clock or the Lexus clock to Mr. O'Keefe's clock. But you could do it either way.
The window that is depicted on this diagram, this is not the three-point turn?
No, this is not the three-point turn.
Which event is this?
This is going to be the backing maneuver.
The green, what does that green depict?
Sure. So the green depicts the range of time that this text stream event ended. So based on our range of 21 to 29 seconds and applying that, adding that to the Lexus clock, we get a adjusted time of 12:32:04 to 12:32:12, and that's going to be the approximate end time of text stream event 11:62:2.
Now again, the text stream data has a limit on the amount of time available?
Can you rephrase your question? So I
Sure. You
understand?
said a window is captured during a triggering event?
Sure, yes. So there is a window that's captured during the triggering event.
And what is that window? How much time?
Sure. So from the text stream trigger, there's 5 seconds before and 5 seconds after.
Can an event be longer than that 10-second window?
Yes, it can.
And in this case, do you know at the end of this reconciled event at 12:32:12, do you know from your study what direction the defendant's car was traveling at 12:32:12?
It would have been traveling in reverse.
And at 12:32:12, do you know how fast the defendant's Lexus was traveling at 12:32:12?
I do not recall.
Mr. O'Keefe's last user interaction with his phone at 12:32:09, where does that fall within the 10-second window that was captured by the text stream data?
Sure. So that falls within that 8-second window. So again, the text stream event ends somewhere between 12:32 and 04 and 12:32:12. But that does not represent that the backing maneuver has ended. Just the recorded data has ended.
And in your review, do you have, around this time, any other movement of Mr. O'Keefe's phone after 12:32:16?
I did not look at that specifically. It was my understanding that Mr. Whiffen looked at that.
To a reasonable degree of scientific certainty, did both these events, the last user interaction and the window captured on the reconciled data for the text stream, happen around the same time?
Yes, they did.
I have no further questions. Or I can approach later or now.
So we can approach again for a minute.
Okay. Apparently, this trial is brought to you by Fiji Water. Fiji Water is the sponsor of this trial. You think it's too late to get some uncivil law branded water and have that in the courtroom? That'd be good. Uncivil branded water. Get that. Yeah. Let's see if we can get some merch. Get these guys some merch mugs they can be drinking out. Get these guys some uncivil law tumblers or something they could have on the table. That'd be good. What is Jackson wearing on his right wrist? That's why I keep wondering. It looks like some sort of paracord and some sort of metal bracelet. Can't ever quite get a clean look at it. I wonder if those are like charms, if they represent something like significant people in his life or something. Anyone who happens to have any insight on that, let me know. The sooner this guy walks out of the courtroom, the sooner he can get fired. Also, we're still wearing that watch on the other hand. Not quite sure if that's the Daytona or whatever that is on the other hand. I noticed from a previous press conference he wore a Daytona. I'm not sure if he wears a Daytona every day. Very typical. You know, a little on the nose maybe, but you know, hey, that's all right. Gotta wear a Rolex as a lawyer, I guess, huh? Jackson probably knows more about time than the expert witness does. That's the question I really want to ask the defense team. What are the watches of the defense team? If we get an interview with Jackson, that's going to be one of the questions. What watches do you have in your collection? And what watches do the other members of the defense team wear? Tell me more about the watches. Why'd you choose that watch?
Your Honor, I move into evidence the following pages from Mr. Burgess's PowerPoint presentation. Move into evidence page 41. I move into evidence page 40. And I move into evidence page 43.
Okay, allowed.
Thank you. I have no further questions.
All right. Once we get these marked, I'll be.
Thank you.
A, B, and C.
All right. Whenever you're ready, Mr. Lessie.
Thank you, Your Honor.
May I, Your Honor?
Yes.
Thank you. Mr. Burgess, between the time you left the witness stand yesterday
Oh no.
until this moment, have you talked to anyone about this case?
No, sir, I have not.
Has a filing ever been made in any court in which your educational background has been misrepresented?
No, not that I'm aware of.
Pardon me?
Not that I'm aware of.
We all know what happens next, right? Everyone in the chat knows what happens next, right? Okay.
Did I understand that you're based out of the Aperture office in Texas?
Yes, I am.
And are you aware of a case in the United States District Court, Eastern District of Texas, Marshall Division, titled Jeffrey Glover and Teresa Glover versus Graphic Packaging International, LLC? Are you familiar with that case?
Yes, I am.
And is it correct that in that case, well, tell me how you are participating in that case, sir.
So I'm no longer participating in that case. So if I believe correctly, that would have been a accident reconstruction case from, I don't recall, a year or two ago.
And so it was a case that you did participate in, correct?
Yes, I did.
And what was your role in that case?
Sure. So my role in that case was an accident reconstructionist.
And did you provide any testimony, deposition or otherwise in that case?
No, I did not.
Did you, in that particular case, there were, like all cases, filings made, correct?
I'm sure there were, yes.
Yep. Yep. This is happening. Yep. I knew it was happening 10 questions ago. I'm just waiting for them. I'm just waiting for the punchline. I know what the punchline is, and I know what the punchline was 10 questions ago. I'm just waiting for the punchline. That's all I'm waiting for. I know exactly what the punchline is. Just waiting.
Yes.
I would like to have a document marked as the next exhibit for identification,
Okay.
please.
Exhibit EEE for ID.
May I present to the witness, Your Honor?
Yes.
Thank you. Mr. Burgess, I am showing you a document which has been marked as Exhibit EEE for...
Tell us what's happening. Okay, so for those of you who didn't know instantly, when I said, do you know what happens next? Like 10 questions ago? Alessi's question was, have you ever misrepresented your education in any other proceeding? And he said no. And I'm like, do you know what happens next? The punchline is he misrepresented his education in another proceeding. That's the punchline. So we're just waiting for the question. We're just waiting for the question about how he misrepresented himself in another proceeding. Like, isn't it true about this case in Texas? Don't you remember that case? What was your involvement? Every question is just getting to him. Yeah. The punchline is, here is the evidence of you misrepresenting your education in another case. That's the punchline. Yeah.
For identification, and I'd ask that you take a look at it, sir. Your Honor, may I remain here?
Sure.
Thank
As long
you.
as you stand back a little bit.
Exactly, yes. Thank you, Your Honor. I'll take it even farther.
Yes.
Mr. Burgess, with regard to Exhibit EEE, do you recognize the second page, and do you recognize any stamping at the top of each of those pages?
Yes, I do.
And can you describe what that stamping is?
Sure. So that is stamping for a file date of 8/7/2023.
And is that a stamping of a federal court?
It sure is.
That I'm not sure.
If I were to show you a document, might a document refresh your recollection as to whether
Sure.
Exhibit EEE is a filing in a federal court?
Yes.
May I, Your Honor?
Sure.
I am showing you,
Did you show those to Mr. Brennan?
thank you, Your Honor. I believe I did, but I want to make sure.
And just let me know if we need to move.
We will, Your Honor.
It's a slow motion train wreck. I know exactly what's going to happen.
Yep.
Let me just.
I know exactly what's going to happen. I'm just waiting for the train wreck to happen. Choo choo, motherfuckers. True, true.
If I could see that back and report, I want to see if this is the second page for that document. It is, so it can be marked as one document for identification.
Exhibit FFF right here. Thank you.
I reach over you, sir.
Yes.
Thank you. Sir, I am showing you what has been marked as Exhibit FFF for identification and ask whether or not this document can refresh your recollection as to whether the court filing that you reviewed in Exhibit EEE is indeed a federal court.
Yes, it is.
So that document refreshes your recollection that what has been filed as represented in EEE is a filing in a federal court, correct, sir?
Correct.
Now, what I'd like to do is to draw your attention to the second page of this exhibit.
Yep.
Is that a curriculum vitae of you and a picture of you.
It
Yes,
sure
it
is.
And sir, under education,
Objection.
I will,
The objections stays.
right. Do you,
Do you want to bring it over? We can take
I
it
will,
there.
Your Honor. I will.
Jurors, feel free to stand up and stretch.
Yep. Yep. His curriculum vitae was filed as an exhibit in a federal court proceeding, and it reflects him having the wrong education. Yep. That's where this question has been going for a while. I don't even know why the judge asks them to approach, because she knows exactly what is happening. There's no way she has to know exactly what's happening. I've known what's happening for like 15 questions. Like I know exactly where this is going. Just waiting to get there. Just waiting to get there. It's like I can skip to the end. I already know the answer. I already know. It's like I can skip to the end of this thing. I already know the answer to the question 15 questions from now. I'm not sure exactly what the questions are in between, but I know the answer to the 15th question. Can we get a refresher? A guy is getting flambéed, man. It's like I didn't know exactly what the 15 intervening questions were going to be. I didn't know how we were going to get there, but I knew what the end goal was. I knew exactly where this was going to go. I'm just waiting for the question. We're getting pretty close to the question. The team really did their homework. You got to give it to the defense team. They really did their homework. They found every case that basically this guy's been involved in, and they pulled basically the records of every single case that guy's been involved in, basically since the beginning of time. That's a lot of legwork. That is a lot of legwork. Respect. And of course, you don't know when you start that there's going to be anything there. That is a lot of work to go through on a chance. I guess it paid off though. Holy shit. I mean, they do have the team for it though, but still, man, that is a lot of that is okay, fine. All right, hold on. I got to figure out something. Give me a second. Let's see. Okay. Okay. This. Okay.
May I approach again, Your Honor?
Yes.
Thank you. Mr. Burgess, I'm going to have to get a little closer
Sure.
proximity. Bear with me, please. What I would like to do, sir, is to put before you again Exhibit FF for identification and Exhibit EE for identification. And what I would like to do is to ask you some questions, sir, with regard to the process in the case.
Okay.
Are you aware, or do you recall in this litigation that, as typical in litigation, including federal courts, that as part of the litigation process, the parties have to designate their expert witnesses? Are you aware generally of that process?
Generally, yes.
Yes. And have you participated in the documents that need to be prepared for an attorney or a party to prepare documents and submit them to a court to establish the designation of expert witnesses?
No, I have not.
And so you have never participated or never been aware of a process like this?
No, I'm aware of a process, and that process goes through other staff members
Okay, so it goes through other staff members where?
at Aperture.
Right.
Correct.
Are you aware that that process is occurring, even though it may be done by other staff at Aperture?
Yes, I am.
And in this instance, you were aware in this litigation that staff at Aperture needed to submit documents in support of an expert witness designation, correct? Even though you may not have done it yourself, you were aware that some person or persons at Aperture were performing that process, correct?
Correct.
And they were performing that process so that you could be designated as an expert witness in that case, correct?
Correct.
And so you were aware of the process, you were aware they had to submit documents that would establish your qualifications as an expert in the case so that you could be designated as an expert witness, correct?
Correct.
And now specifically with regard to Exhibit EEE for identification with these court filings, etc., even though you may not have done it yourself, were you aware that this document, which is EEE, was submitted as part of the expert designation process we were talking about?
Not this specific document, no.
Were you aware that a CV was needed to be submitted on your behalf as part of the designation process?
Yes.
So you were aware a CV had to be submitted, but you're saying you don't recall this specific one being submitted?
Correct.
Does the timestamp up at the top of each page of Exhibit EEE, including this page that is your CV, match the timestamp, or is it different from the timestamp at the top of Exhibit FFF?
No, that is the same.
So it's exactly the same.
Yes.
And have you been involved in processes in courts where your qualifications, including your CV, have had to be submitted to courts to establish a designation as an expert witness?
Yes.
And can you conclude from these documents, including the timestamps, that the submission that was made to the court to establish your status and as an expert witness consisted of Exhibits FFF and EEE?
Objection.
I'm going to allow that. Were you aware of that?
Yes.
Your Honor, at this point, I move EEE and FFF into evidence.
What happened? Skipped ahead or something. What the fuck?
Documents in support of I.
Come on up.
All right, for some reason, just skipped ahead. There was they just called for a sidebar, so I'm not sure what happened with her in terms of the video, but whatever, it's fine. Yeah, the court feed just skipped. I'm not sure what was the cause of that, but this is GG indeed, man. Are we sure this is an Exhibit GG? Because it feels like it's Exhibit GG. Am I right, chat? Am I right?
You have reapproach, Your Honor.
Yes.
I'm going to have to stand here again, Mr.
Sure.
Burgess. So what I would like to do, Your Honor, at this time is to offer into evidence Exhibit E, and Exhibit F for identification.
As one exhibit?
As one exhibit.
All right, we'll do that. Madam Court Reporter.
And that would be the order.
Exhibit 193.
Thank you. May I hand to the witness?
Yes.
Mr. Burgess, I am handing you what is now in evidence as Exhibit 193. I would like to draw your attention to the fourth page, which is your CV, and further, if I could, sir, draw your attention to the category of education, where it says BGS.
Yep.
Is it correct that there you state Bachelor of General Science in Mathematics and Business Administration, University of Alabama - Birmingham, Alabama, comma, 2024? Did I read that correct?
You did read that correctly.
And that was the punchline. That was the punchline. Yep. Yep. We got there. Round of applause. Round of applause. Yep. There you go.
And this was filed in 2023.
Understood. So now what I'd like to do, Your Honor, is to... May I keep this for a moment, Your Honor? Give it to the witness as needed. Thank you. With Your Honor's permission, I would like to publish a document that is already in evidence.
Okay.
Actually, there may be two, 183 and 184. Let's start with 183. Let's expand it. And then, Mr. Wolf, do we have what has just been to publish as well? So what I'd like to do is to publish first, with the court's permission, Exhibit 193 that we were just talking about, so the jury can see what has been the subject of discussion.
If someone doesn't ask him, how's that BS degree going?
And sir, if
I'm
you,
going to be
Mr.
really
Wolf, if you
sad.
could just enlarge, all we need is the education section.
If someone doesn't ask him, how is that BS degree going?
Now,
I swear, man. I
Mr.
swear.
Burgess, as I heard it correctly in questions from Mr. Brennan, you answered the question that whether you had ever filed a document that misstated your educational background in a court. Do you recall that question asked of you?
Yes, I did.
And your answer was no, correct, sir?
Correct.
So let's look at this document, which we've just gone through, was filed in federal court in the United States District Court, Eastern District of Texas, Marshall Division, which is a federal court.
Holla.
And attached to it is your CV, and in the line of education, it lists under BGS, Bachelor of General Science in Mathematics and Business Administration, University of Alabama, Birmingham, Alabama, 2024. You see that, sir?
I do, yes.
Now, you stated, and now what I'd like to do is do a, is there any qualification whatsoever in that line, that reference to BGS, qualifications at all, explanation, sir? Is there anything?
I don't know what you mean.
It's just a statement, right? There's words there, there's nothing after it that explains what's intended, correct?
Correct.
Now what I'd like to do, Your Honor, is to go to what was filed in this case, which is in evidence, and we'll go to 183 and then 184.
There is not enough face palm for what is happening right now.
Now, in what has been filed in this case, there is a currently pursuing at the end after University of Alabama - Birmingham, Alabama, correct?
Yes, that's correct.
Let's go back, please, to Exhibit 193.
Can we get the University of Alabama to comment on this? Has anyone called? Has anyone called?
There is no currently pursuing
whoever
there,
the
is there,
PR
sir?
staff?
There is not, but that was filed in 20.
Has anyone called whoever is in charge of like public affairs at the University of Alabama and asked for a comment? If not, could one of my mods like send an email to somebody at the public affairs and ask them for comment on this guy and his status? And that's the I like some comment from the University of Alabama right about now. That'd be great. Thank you.
2023, so that would be an expected graduation date of 2024.
Okay, so this document was filed in 2023. However, there's nothing in this document that in any way leads the reader to believe anything other than the degree is obtained on 2024, correct?
Correct.
So the only way somebody in the court system or a judge or a jury would know anything about this is to have to know about court filing dates, correct? I'll ask it another way, Mr. Burgess. You know how to write. Let's go back to 183 and 184. You know how to write currently pursuing on your CV, correct?
Correct.
And writing currently pursuing lets the reader know that you don't have that degree, correct?
Objection.
In that form, it's sustained.
You intend by writing currently pursuing, don't you, sir, that anybody reads this to know that you do not have a bachelor degree, correct?
Correct.
Now let's go back to what you filed in what was filed in federal court in that case. And it does not have the words currently pursuing, correct?
It does not.
So the reader, it doesn't have that verbiage, correct?
Correct.
So isn't it the correct answer that you did file a document, your CV, in this federal court case that misstates the status of a Bachelor of Science in Mathematics and Business Administration?
Objection.
Sustained.
Excuse me, Your Honor. You stated again, sir, that you have not filed a document that misstates your educational background, correct?
Correct.
And the last time I'll cover it, you know how to put currently pursuing on anything to do with a Bachelor of Science, correct?
Correct.
A Bachelor of General Science in Mathematics and Business Administration does not exist as an offered degree at the University of Alabama, Birmingham, does it?
Sure, so that is an error. Clearly, BGS stands for Bachelors of General Studies, and that should have a with minor in Mathematics and Business Administration.
What is clear from that document that BGS stands for a Bachelor of General Studies? What is clear in that document about the definition of that acronym?
That is a known acronym.
No, it's not. It's absolutely not. I've never heard of it before in my life.
To
ever.
Bachelor
Fuck
of
you.
General
No, it's
Science
not.
in Mathematics and Business Administration. That degree does not exist.
How many of you have heard of it? How many of you have ever heard that acronym before? Anybody?
Not offered at the University of Alabama, Birmingham, correct?
No, that is not.
So therefore, an incorrect statement about your educational background was filed in a federal court in Texas, correct?
Yes, it was.
That's it, Mr. Alessi? You
Yes,
done?
that's it.
Okay. All right, is there anything?
There is.
Okay.
Brennan? No. Just no.
The document that the attorney just showed you, did you submit that to the federal court?
No, I did not.
Did you ever see that document before it was filed?
No, I did not.
The document says 2024 for a degree. Is there a presumption whether you had it or expected it if that document was filed in 2023?
Yes, there is.
And what is the presumption if it was filed in 2023?
Objection, Your Honor, respect.
So presumption,
Well,
so I'll strike that.
okay. He asked if there was any designation to make it clear. If it says 2020, if it was filed in 2023, and it says 2024, what was your expectation at that time as far as your degree?
That I would complete my degree in 2024.
When you didn't,
You began a bachelor's degree in 2004 and your expectation was you were going to finish it in 2024? Okay.
complete.
I'm going to start putting PhD philosophy currently pursuing on my resume. That's what I'm going to do. What other degree should I put on there? SJD? Maybe an MD. It's not too late for me to have a medical career, right? There's some second career medical people, right? I'm 44. Is it too late for me to go to med school? Let's go. Let's put MD pending. That sounds good.
Your degree in 2024 as you expected, did you then change your CV
Yes, I did.
to accurately reflect the change in your status?
Yes, I did.
And what did you change it to?
Currently pursuing.
Why didn't you finish your degree in 2024?
Sure. So,
No. I want to know the answer to this. I want to know. Don't object. I need to know the answer.
No, I'm going to allow it.
as most people can probably relate, work, family, and life many times get in the way. So as a personal objective, I would like to finish my bachelor's, but again, work and life gets in the way.
Bullshit.
Did you ever represent to a court that you had a degree that you didn't earn?
No, I have not.
He asked you a number of questions about this 2023 filing, but didn't ask you any questions about the data. Does your opinion regarding the data change in any way in light of his questions about a 2023 filing that you didn't file and someone filed on your behalf?
Objection, Your Honor.
The objection is sustained. I'm going to strike that question.
Okay. No further questions.
All right, Mr. Burgess, you are all set.
Thank you.
Let's do a little palate cleanse, you and I. Just a little breathing, maybe. Some meditative breathing. Breathing sounds good. Let's do a little meditative breathing, you and I. Sounds good. All right, let's do the breathe in. And breathe out. Breathe in. Breathe out. One more time. Breathe in. Breathe out. Okay. Namaste.
Mr. Brennan?
I'd like to play a number of clips. If I could begin with clip 23.
So we approach from the north, we actually miss the turn, and John says to me, it's Fairview, we just passed it, it's back there, it's on my left. I said, all right, so I pull nose into a driveway and back out onto the street, which I now own was Cedar Crest, and then come from the north onto Fairview.
I'd like to next play clip 25.
At 12:41, I leave a voicemail to John where you can clearly, and this will probably be played on Monday, you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage truck. And then you hear the car go off, and then you hear the slight ding, ding, ding as I open the door, shut the door. I had high heels on that night. You hear me walk in, go into the stairs up into the kitchen, shut the door, and you hear me walk in the kitchen. It's like a full minute long. That's at 12:41.
And finally, clip 24.
I do. I mean, I'll tell you, John and I argued the morning of the 28th, Friday morning. So we think he died right around 12:25, 12:30 on the early morning of January 29th.
Thank you. I have these for submission into evidence, Your Honor.
194.
The next witness, Mr. Allen?
Yes, Your Honor. I'll call Ms. Christina Hanley to the stand.
Excuse us.
Step up, face the clerk, and raise your right hand.
You solemnly swear the evidence of the court and jury in the case now hearing to be the truth, the whole truth, and nothing but the truth, so help me God? Okay.
Good afternoon. All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
Could you please introduce yourself to the jury, spelling your last name for the court?
Sure. I'm Christina Hanley. Hanley is Hanley.
And Ms. Hanley, what do you do for work?
I am a forensic scientist 3 at the Massachusetts State Police Crime Laboratory in the Trace Arson and Explosives Unit.
And where did you go to school?
I went to, I had received my Bachelor of Science in Chemistry with the concentration in Forensics from Merrimack College.
And do you have any other degrees?
I do not.
Now, following your education, where did you first go to work?
I began working at the State Police Crime Lab in 2008 in the drug identification unit. And in 2009, I transferred into the trace unit. And in 2017, I was promoted from a forensic scientist 2 to a forensic scientist 3 in the trace, arson, and explosives unit.
Could I ask you please to speak up, please?
Ms. Hanley, if it helps, that microphone is adjustable, so if you could get it as close to you as possible, that would be great. Thank you. The Massachusetts State Police Crime Laboratory where you work, is that accredited?
Yes, it is.
And by whom?
We are accredited by ANAB.
And what does ANAB stand for?
ANAB stands for ANSI National Accreditation Board.
And what does ANSI stand for?
Sorry, I can't remember exactly what ANSI stands for. I apologize.
That's okay. As part of that accreditation process, do you undergo any sort of proficiency testing?
Yes, I do.
And can you explain to the jury what that proficiency testing process consists of?
Sure. So proficiency tests are a quality assurance measure that's used to monitor performance. And I'm required to complete at least one external proficiency test per year, where I'm authorized to do casework in multiple subdisciplines. In my unit, I typically complete more than one proficiency test per year.
And what areas do you specifically undergo proficiency testing in?
Sure. So I'm authorized to do casework in multiple subdisciplines in trace. So I complete proficiency tests in the subdisciplines of hairs, paint, fibers, glass, tape, and serial number restorations and physical match examinations.
And generally speaking, what is entailed in those proficiency testing that you're given multiple times a year?
It's provided by an external company that provides the proficiency test, and I'm required to successfully complete one of those proficiency tests per year.
Now, have you successfully completed each of those proficiency tests that you've taken?
Yes, I have.
Now, what type of training or continuing education have you undergone at the State Police Crime Laboratory?
Sure. So I had internal training as well as external training. The internal training consisted of I had to complete required readings. I was required to complete some laboratory exercises, learn how to utilize the instrumentation in the lab. I observed other analysts in the unit working on casework. I was also required to complete a written exam as well as a competency test, and in addition to that, a mock trial.
Now, you mentioned earlier in the testimony you're a forensic scientist 3 currently, is that correct?
That's correct.
And what is the difference, or can you explain the difference to the jury between a forensic scientist 2 versus a forensic scientist 3?
Sure. So a forensic scientist 2 is essentially just like a bench chemist who their primary role or responsibility is casework. A forensic scientist 3 does casework, but in addition is also a unit supervisor.
Now, what does the trace unit do or examine within the Massachusetts State Police Crime Lab?
Sure. So I'm responsible for examining and comparing trace items that, for example, such as paint, glass, fibers, hairs, tape, miscellaneous items. I also perform serial number restorations on firearms and physical match examinations.
And what are your general duties and responsibilities within the trace unit within the lab?
So I am responsible for the general operation of the unit. I train other forensic scientists within the unit. I also complete technical and administrative reviews of casework. And I also complete my own casework in the trace disciplines that I previously mentioned.
Now, Ms. Hanley, you as a supervisor, you review other analysts' work within the trace unit, correct?
Yes, I do.
And who reviews your work for any sort of trace analysis that you do?
So depending on what the subdiscipline, some of the casework that I'm authorized to do work in, it needs to be technically reviewed by an external technical reviewer because I'm the only one within my unit that can do certain types of casework currently. So we have to utilize an external technical reviewer at this time.
Now, with reference to physical match analysis, can you explain to the jury first, just in general terms, how is that analysis performed?
Sure. So when I receive an item, I take that item into my custody, and I document it with photographs, and I make observations and take notes. And then I'll examine the items microscopically, and I will do any comparison work to determine if there is or is not a physical match between items.
Now, that physical match analysis within the trace unit at the state lab, is that general work supported by any sort of scientific principle or methodology that you're aware of?
Yes.
Let me ask you this. Are you familiar with something called the Lockhart exchange principle?
Yes. So the Lockhart exchange principle, it's kind of the foundation or basis of trace analysis. It is a principle that states that when two objects or two items come into contact with each other, there is an exchange of material.
Now, with reference to your workspace, what is it that you do to your bench between your examination of separately packaged items?
Sure. So the bench top as well as the tools that I'm going to use are all cleaned with a bleach solution. And once that's done, there's a clean piece of butcher paper that's put down on the bench, and that's done in between looking at different items.
And why is it that you do that in between looking at different items?
That's done to prevent any cross-contamination.
Now, you've alluded a little bit earlier in your testimony, but on what types of evidence can you perform a physical match analysis?
Sure. So physical match examination can be conducted with many different types of material. For example, plastics, glass, tape, etc.
Now, when evidence is submitted to your lab, how is it kept track of throughout its stay at the lab?
Sure. So when evidence is submitted to the laboratory, the case information is put into our LIMS system, which stands for Laboratory Information Management System.
And once it's assigned that number, how is it sort of tracked as it progresses through the different units within the lab?
Sure. So the unique case number that's assigned to the case is tracked within the system. It's referred to as the chain of custody. So items of evidence will get scanned depending on where their location is, and the LIM system keeps track of all of that, so we know exactly where an item is.
So when you take an item or you receive an item to be tested, can you explain to the jury what you do to begin your analysis?
Sure. So when an item gets scanned into my custody, after I've prepped my area to examine the item, I scan that item into my custody, and I will document that item with photographs. I will make notes of my observations. I will examine the item microscopically. If needed, I'll proceed with sampling and possibly additional microscopic examination and instrumental analysis.
Now, specifically starting with items of glass, when you take an item of glass to conduct a comparative analysis, generally speaking, what is the process for conducting such an examination of glass?
So it'd be the same process that I just mentioned. I would take that item, take photos, make any observations. I would proceed with, first I would check to see if there's any physical match comparisons, and then if needed, I would take any samples to examine it microscopically and or instrumentally.
And that general process that you've just described is the items that you tested in reference to this case or analyzed in reference to this case. Is that the process that you followed in this case?
Yes.
Now, what kind of instruments do you use, starting off with items of glass, what kind of instruments do you use to conduct that analysis?
Sure. So I'll use a stereo zoom microscope to initially examine it microscopically. If I take samples to do additional microscopic examination, I'll examine it under a polarized light microscope. And then if I need to take samples to do instrumental analysis, that would be using our, it's referred to as a GRIM, which stands for Glass Refractive Index Measurement. And it's an instrument that measures the refractive index of glass.
And if you could, please explain to the jury, what is a refractive index?
Sure. A refractive index is a measure of how light bends when it passes from one medium to another.
And how are you viewing that utilizing the GRIM device when it comes to glass?
So a sample is prepped on a slide, and it is placed on a hot stage of the microscope of the instrument, and the oil that the sample is in it goes through a cooling and a heating phase, and as it's going through a cooling and a heating phase, it passes through what we refer to as a match point. So you can make that observation as the sample is running, and then when the sample is done running, it takes an average, and it calculates the refractive index of the sample through the calibration data of the instrument.
And what is an FTIR?
So an FTIR is a Fourier transform infrared spectrum and an analytical tool that we use samples. Essentially, a sample is exposed to infrared light, and your sample reacts in a certain way to it, and it produces a spectrum or a graph of peaks and valleys, and it is representative of your sample.
And how is that FTIR instrument, how is that used in this type of physical match analysis?
So actually the FTIR was not used for physical match examination.
Now, you mentioned it a little bit earlier in your testimony. What is a polarized light microscope?
So a polarized light microscope it's a microscope that just has a couple of filters in it that we use to look at samples at a higher magnification and make observations of certain optical properties of samples.
And how are you utilizing that instrument in your analysis in the lab?
So it's used to examine various different types of samples, paint, fiber. We can also look at glass.
Now, do you document your work as you perform your analysis in the lab?
Yes, I do.
Now, Ms. Hanley, at some point were you assigned to perform some work on a lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes, I was.
And what type of work were you assigned to do in this case?
So I was given items for physical match comparison of some glass items, as well as some instrumental analysis of the glass. And I was also given items for some items of plastic for comparison.
Now, starting with glass pieces, do you recall what item numbers you analyzed pertaining to the glass pieces?
Yes, so I examined items 3-2, which was a clear glass cup with broken irregular edges. I was also given item 3-3, which was 5 pieces of clear glass with broken irregular edges from the bumper of the vehicle. And then I was also given item 7-12, which were clear and glass pieces recovered from the road. And I was given also 7-14, which was a clear piece of glass recovered from the road.
And now if we could, Ms. Hanley, just break those down sort of one by one. So starting with item 3-2, what was provided to you in reference to a description of what that item was?
Sure. So item 3-2 was a clear glass cup with broken irregular edges, and there was dirt debris on the exterior and interior of the cup.
Now, did you measure that item?
I did.
And what measurements did you obtain from that item, the drinking glass?
I just would need to refer to my report for measurements.
Okay, you can do that. You have your report right there? Go right ahead.
Thank you, Your Honor.
So the diameter of the bottom of the glass cup was 2 3/4 inches, and it measured approximately 2.5 inches in height.
You mentioned that there was debris on both the interior and exterior of the drinking glass. Is that correct?
Yes.
Now, turning your attention to item 3-3, what was provided to you as a description of item 3-3?
Sure. So item 3-3 consisted of 5 pieces of clear glass, all with broken irregular edges.
And was there anything provided in the description of where those 5 pieces of broken glass were located?
Yes, they were recovered from the bumper of a vehicle.
And was there any identifying information provided to you as far as in reference to that vehicle?
The only other description of the item is the license plate of the vehicle.
What was the license plate that was provided?
So it was MA3GC684.
And did you measure each of those respective items?
Yes, I did.
Now, as far as before we get to the measurements, Ms. Hanley, when it comes to a lab item number, say 3-3, that has multiple pieces to it, how are each of those individual pieces then subsequently labeled?
So sometimes we'll subsequently label them with a lettering system.
And as far as these particular pieces contained within item 3-3, the pieces of glass from the bumper of the defendant's vehicle, how are they labeled?
So these were labeled A through E.
And With reference to the measurements, what measurements did you obtain from the pieces within item 3-3?
Sure. So I measured the largest and the smallest, and the largest measured approximately 7/8 of an inch by 5/16 of an inch, and the smallest measured approximately 3/16 of an inch by 1/8 of an inch.
Now, with reference to the drinking glass, you examined that microscopically, is that correct?
I did, yes.
And with reference to these items from item 3-3 from the bumper, you examined those microscopically as well, is that correct?
Correct.
And was there a particular piece from the pieces from the bumper that you did any additional examination of?
Yes, I did.
And what instruments did you use in which piece?
Sure. So there was one piece, I sampled a piece E that I had labeled as piece E, and I took a sample for examination under the polarized light microscope and a sample to analyze it instrumentally on the Grimm instrument.
Now, turning your attention to item 7-12, what was provided to you as a description for item 7-12?
Sure. So item 7-12, that consisted of 5 pieces of clear apparent plastic and 9 pieces of clear apparent glass with broken irregular edges.
Now, the 9 apparent pieces, well, let me ask you this first. As far as the description that you were provided, was there any description as far as where those items were recovered from?
Yes. Those items were recovered from 34 Fairview Road.
And is it your understanding they were recovered from the street or the roadway outside of that residence?
It just says recovered from 34 Fairview Road.
Now, as far as the 9 pieces of clear apparent glass from item 7-12, were those similarly sub-labeled as the previous item 3-3?
Yes, I received those labeled with the lettering system. They were labeled A, B, C, D, E, F, I, K, and L.
And with reference to those 9 pieces of glass, did you examine those microscopically as well?
I did, yes.
Now, turning your attention to item 7-14, what were you provided with as far as a description of that item 7-14?
So this item consisted of 1 piece of clear glass with broken irregular edges.
And similarly, was there any description provided as to where that item was recovered from?
Yes, it was recovered from 34 Fairview Road as well.
And again, how many pieces were contained within that item 7-14?
7-14 was just 1 piece of glass.
And did you measure that item as well?
That item, I do not have the measurement of. It was examined by a previous analyst within the unit, so that measurement was taken at that time.
And that other analyst would be Mix Valier, is that correct?
Yes.
Okay. And as far as your examination of that item 7-14, what type of instruments did you use to examine 7-14?
So I sampled 7-14 to examine it under the polarized light microscope, as well as to analyze it instrumentally using the Grimm instrument.
Are you familiar with a term called a class characteristic?
Yes.
Can you explain to the jury what that is?
Sure. So a class characteristic is when a material can be associated with a group of items that share characteristics.
And what is an individual characteristic?
An individual characteristic is when a material can be related to a single source, such as a physical match.
And so what is the difference between a class characteristic versus an individual characteristic?
So class characteristic is that it can be associated with a group of items that share characteristics, versus the individual characteristic. It's more individualizing. It can be related to a single source, just in the case of like a physical match.
And what is a physical match?
So a physical match is if an item is broken and those pieces are compared to each other, and they're broken irregular edges fit back together, and they have a jigsaw fit, that would be considered a physical match.
Now, can you please explain to the jury the steps and the process that you undertook in your comparative analysis of items, specifically of glass in this case?
Sure. So I first did a comparison of all of the glass pieces and the glass cup that were recovered from the road. So those were items 3-2, 7-12, and 7-14. So I examined all of those to determine if there was a physical match between any of those items first. There were, I believe, 6 pieces of glass from item 7-12 that fit mechanically to the cup that was also recovered from the road, item 3-2. After I completed that examination, I then did a comparison to see if there was a physical match to some of the 2 of the glass pieces from the bumper, and there were 5 total from the bumper. 2 of them I used for physical match comparison, and there was no physical match comparison between those 2 pieces from the bumper, item 3-3, compared to the glass pieces and the cup that were recovered from the road. And then I sampled, as I had mentioned earlier, one of the pieces from the bumper to do further microscopic and analytical analysis on, and did a comparison with one of the pieces from the road.
Can I see counsel at sidebar for just a minute, please?
I need help, chat. Does anyone know an easy way to convert part of a video into a vertical clip? I know how I can create a clip inside of YouTube, but how do I then download that clip, or how do I convert it into a vertical so I can make it into a short? How does anyone know how to do that? I don't have a local recording of it. Do I have to download the entire stream so that I can clip it out inside a video editor? Or is there another way to go about doing this? I need help. Okay, I can download the entire video and then do it from there, I guess. All right, so I'll just download the entire recording and then I can do it from there. All right, we'll do it that way. Okay.
So jurors, it's been a long day, so we're going to stop for the day. Ms. Hanley, I'm going to ask you to come back tomorrow, but a little bit later in the day, and the victim witness person.
Okay, I need to create a stream for tomorrow, so I can't do that now because I have to do something else. All right.
Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know, and watch your social media use. Thank you. So Ms. Hanley, after the jury trials. Okay.
All rise to the court, please. Close your notebook and follow me.
Goodbye.
All right, you don't need me for anything, right? We're all set?
We're all set. Thank you.
God for that. Let's try first. This is going to be the 21st. It's going to be day number 20. Change the thumbnail. Yep. Schedule the time, 21st. Schedule time, 7:45 a.m. Next. Next. You can do it with your phone. Go to the video on your phone and there's an option. I don't have the video on my phone, not the original. I didn't record it with my phone. I recorded it using my computer. So I have to download to my phone first? I don't know. All right, let's see. Now I need to create a redirect for tomorrow. Create a redirect. Right, okay, great. All right, and then okay, go to Mars stream. Optimization. Monetization, change it so the ads don't display. Do that, save it. Trailer. Yep. Save. Great. Create the redirect. Set the redirect for tomorrow. The redirect is set up. Okay, guys. I will see you tomorrow. Thanks for joining in on Uncivil Law. It's been fun. I'll see you tomorrow morning. Goodbye, guys.